Court calls the case, people versus Kyler Johnson versus Amadalen Bailey.
Ready, Your Honor. Dawn Van Dusen, P69647 on behalf of plaintiff.
Judge Dominic Camden, P67745, appearing on behalf of the defendant, Amadalen Bailey. Judge, my client is also in the Zoom room.
Oh, there she is. All right, where are we on this case, folks?
Your Honor, this matter that it's regarding a trailer park, a mobile home in that park. My client, which is Kyler Johnson, owns the trailer in the park. Miss Bailey is his ex-girlfriend who is occupying it at this time. At this time, they did do a purchase agreement at one point, but I think I don't know where they got their purchase agreement, but Mr. Johnson would like to, already told her that he was going to rescind it. He does not live there at this time, but he would like the occupancy to happen. He has a loan payment on this trailer each month that has it was agreed that she'd split half of it. She still hasn't made any of that. She failed to make payments October all the way to February on just that loan, which is her portion would be 500 of it. But with them not being together, it's a total of 1,000. The rent there on the lot.
Because they're not together, her payment went up.
Well, they agreed they would split it at one point, but she hasn't made any of it. So we're not even asking for a judgment in this matter. We just want, as in a money judgment, we'd just like Miss Bailey to move out of the home, out of the trailer. She's changed the utilities into his name, into her own name. She has, so he cannot even get access to make sure payments are made. So she's actually only made payments starting in January for the utilities. So we're asking at this time that eviction of a 10-day order be granted to order her out of the premises.
Mr. Hamden.
Judge, the parties are subject to a purchase agreement. I don't believe you can just unilaterally rescind an agreement. I don't believe the purchase agreement provides for that. And my client is still wishing and desiring to go forward with that purchase. Second of all, my client is on the written lease agreement with the park. And so she has the right to occupy this space as the landlord to the property. So this is probably better characterized, Judge, as some form of a replevin case, as opposed to an eviction in order to retain his property back. It's not properly characterized as an eviction. It's probably better characterized as some form of a replevin.
Well, but I don't. Is the purchase agreement still in effect?
It did not have a termination date, Judge.
Your Honor, it also says the initial payment is non-refundable. It looks like she received this piece of purchase agreement, a copy of it, and that she filled it out. And it was part of the parks where if they were going to sell you one of their trailers. I mean, there was no down payment. There's no initial payment that it discusses is non-refundable unless the applicants are denied their credit and background check. Your Honor, this is not a normal purchase agreement, and it has no closing date, no nothing on it. My client has rescinded 2 days after he signed it and said he does not want to sell it to her.
And again, my comment on that, Your Honor, would be that my client was prepared to close on it, had coordinated with a lender in order to do so, and he refused to go forward with the closing, and there is no provision in there which allows him to unilaterally rescind it. I think it's also worth noting, Judge, that the parties, and I'm sure Your Honor has put 1 and 2 together, at one point in time dated each other, and one of them was required to leave the premises because of a police report. And so what this appears to be is
oh dear God. Is that true?
Your Honor,
Was it,
agreement was
hold on a
signed-
second. No, I just need a very clear answer because this court has a very clear policy on that. If, and I'm just gonna say, because usually it's the male that's doing this. Is there a domestic violence complaint that was made?
Yes, Your Honor, it was made on October
And
23rd.
he was then required to leave the premises?
Correct.
I am not.
And Your Honor, there's no charges pending against my client. In fact, the charges were dismissed by Miss Bailey 2 days later after she made the complaint.
Okay. How long were they living together?
That
Give
would
me
be
one-
something that my client would have to answer, Your Honor.
Judge,
Miss Bailey, how
We were-
long?
Living together 1 year.
Okay. All right.
Your Honor, I wanted to add something. I just wanted to say that the reason why of wanting to go back on the purchase agreement was because initially I had signed the purchase agreement, and the next day she was trying to falsely accuse me of, and call the cops on me for stuff that wasn't done, and just falsely accuse me. So that was
So
why
you
I
got
wanted to
mad
go.
and said, I'm rescinding the purchase agreement, blah, 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 blah. I hear it all. All right. So what do you guys want me to do? I am not issuing a judgment. Not today. And I'm assuming, Mr. Hamden, you want to file a written answer to this.
I do, Your Honor, and I think it would be helpful if the court actually saw the purchase agreement, as well as the lease
Well,
agreement.
somebody attach it, because if the
I'll-
purchase agreement's there, but there's also another signed document between the parties, correct?
There's a purchase agreement that was signed between the parties, Judge. The other agreement was signed with the park landlord, to which my client is a tenant, as well as Mr. Johnson. They are both tenants from the park landlord standpoint.
Ralph Davis, Ralph Otis Davis, 26741234 A, B, and C. Your name?
Otis Davis.
You have drywall suspend, drug paraphernalia, and improper plate. You have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer? I'm gonna go ahead and arraign you and send you to the prosecutor on January 7th of 26. The police think you were operating a motor vehicle in the city of Woodhaven on Allendale West at 11:55 p.m. They think you had a suspended license that is a misdemeanor. It is punishable by up to 500 fines, 93 days jail, costs for all those. You also have a drug paraphernalia charge. That's punishable under local ordinance by up to 500 fines, 90 days jail, costs for all those. You understand that?
Yes, I do.
You also have a third charge of improper plate, which is punishable by up to $100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes, I do.
And did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Plead guilty to all of those charges.
Do you understand what I've said, though?
Yes, I do.
All right. You still wish to waive your right to a lawyer?
No, I think I'll take a lawyer.
Okay. I'm gonna enter a not guilty plea for you.
Okay.
$500 personal bond. You cannot purchase, possess, or consume alcohol or illegal controlled substances. Do you understand?
Yes.
You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll set you up with a court-appointed lawyer. He just needs the pre-trial, John. So you go out in the hallway, we'll set you up with your lawyer. Any questions?
No, sir.
All right, good luck. Ralph Otis Davis, 267841234 A and B. Mr. Gaith, which case do you have? John, pull it out. Will you find out which one it is and pull it out for me?
Morning, Your Honor, Mike Hillcroft, representing Mr. Davis. Mr. Davis, state your name for the record.
Ralph Otis Davis.
All right, so what are we doing on this? He's gonna,
For purpose of arraignment, Your Honor, not stand, meet, wait for reading of the charges.
yeah, I actually already arraigned him.
Okay.
And then, so he's gonna plead to no ops on the suspend charge, right?
Correct.
The suspend's going to be dismissed. And also he's gonna plead the drug paraphernalia. And the improper plate will be dismissed,
Correct.
right?
Yes, Your Honor.
Is that what you want to do?
Yes, sir.
If you plead guilty to no ops, possible penalties are up to 100 fines, 90 days jail, costs are all those. If you plead to possession of drug paraphernalia, the possible penalties are up to 500 fines, 90 days jail, costs or all of those penalties. Do you understand that?
Yes, sir.
And did you understand all your rights on the advice of rights that you signed?
Yes, sir.
If you plead guilty to those two charges, I'm going to dismiss the suspend and dismiss the improper plate. The conviction will be entered for no ops. The conviction will be entered for drug paraphernalia. You understand that?
Yes, I do, Your Honor.
All right, so any questions on your rights? To the charge, no valid operator's license on person, how do you plead?
But I don't.
To the charge of no valid operator's license on your person, how do you plead?
Not, I mean, because. Last time you said it.
Hang on a second, slow down.
You going so fast, I'm got one.
All right,
Pleading guilty to it.
all right, maybe I am going too
Okay,
fast.
yeah.
My apologies. I'll slow down. To the charge of no valid operator's license on person, how do you plead?
Guilty.
To the charge possession of drug paraphernalia, how do you plead?
Guilty.
Were you operating a motor vehicle on Allendale West in Woodhaven, January 7 to 26 at 11:55 p.m.?
Yes, sir.
Did you have a valid license on your person?
No, I didn't.
Were you in possession of drug paraphernalia? And if so, where was it? Was it yours? And what kind of drug paraphernalia?
It was mine, it was in my pocket.
And what was it?
After it was a glass stem.
I can't hear you.
A glass stem.
Okay, and you used that for what purpose?
You wouldn't believe it if I told you.
I need to know. Tell me.
I used smoking tobacco, I'm gonna fix it, but they said it's fair from never so I'm taking a fair charge. I'm gonna fix this, but that's the truth.
Did you use it for any other purpose?
No,
Smoking crack?
no, I had no drugs on me.
I didn't ask you that.
I didn't,
Well, I can't. A hard time accepting a plea if he's not acknowledging he used it for drugs. You never use that for drugs?
not that,
I can't hear you.
no. Not what they found on me, no. What they
All
found.
right, well,
Could we work on this? a little bit?
yeah, we'll pass that. Ralph Otis Davis, 26W841234 A, B, and C.
I can cooperate with Mrs. Davis who's approaching.
Mr. Davis, your name?
Ralph Otis Davis.
Are we gonna try this again?
Yes, Your Honor.
If you plead to no operator's license on person, the possible penalties are up to 100 fines, 90 days jail, costs are all those. The drug paraphernalia carries up to 500 fines, 90 days jail, costs are all those. If you plead to those two, the prosecutor will move to dismiss the improper plate and driving on a suspended. Do you understand that?
Yes,
Is that what you want to do?
yes,
Did you sign, read, and understand the advice of rights?
yes,
If you plead guilty, you'll be giving up all the rights, and it's not going to be a hearing or a trial. Do you understand that?
yes,
To the charge, no valid operator's license on person, how do you plead?
Guilty.
To the charge of possession of drug paraphernalia, how do you plead?
Guilty.
Were you on Allen in Weston Woodhaven, and were you operating a motor vehicle on the 7th of January of 26 at 11:55 p.m.?
Yes, sir.
Did you have a valid license on your person?
No.
Were you in possession of drug paraphernalia?
Yeah.
And to that charge, possession of drug paraphernalia, how do you plead?
Yeah.
What kind of drug paraphernalia did you have? What'd you have?
A pipe.
A glass plate.
Yes.
Did you use that to smoke something other than tobacco?
Yes.
What did you use it for?
Milk.
We had an opportunity to talk with the prosecution, Your Honor. We agreed, although legal, it is a narcotic, was in possession of.
How do I convict somebody of drug paraphernalia if it's legal?
It's still a narcotic.
Ah. Law's not an ass. I don't know how I accept that plea. Call in, Mr. I don't know what's wrong with my phone today, John. Maybe it's well, maybe it's working now. I got it. You didn't use it to smoke crack or anything else? I'm asking you a question.
And we,
Can you come on in here a second? Thank you. I'm asking you, did you use it to,
yes, I have.
to use what? To smoke?
Drug,
What kind of drugs?
marijuana, crack, cocaine.
Okay, well, that's different. I'm not convicted. I cannot accept a plea for somebody that's legally using something. I'm not gonna do that. Now you're telling me you've used this to, well, listen to me. I don't want to go through this again. If you want a trial, I'll give you a trial. But I've asked you 3-4 times, you're in a courtroom. Just be honest with me. Have you used this pipe that was found on you on this date of January 7, 26 to smoke crack cocaine?
Yes,
Are you telling me that because that's truthful?
yes.
Then why are you playing a game with me?
I'm not,
First, you just used it to smoke tobacco, then you used it just to smoke marijuana.
at that particular time, that day, you know,
Well, I don't care.
Okay, I know that. I apologize, I was not trying to take.
You're all right. I don't need you. Are you on probation or parole?
No, I'm not.
Nobody forced you to plead guilty.
No.
Plea is accepted. There are no ops. The plea is accepted to possession of drug paraphernalia. I'm dismissing the suspend and the improper plate on motion to prosecutor. I don't know if he's got a drug problem or not, but I'm ordering a screening and assessment. He'll be screened and assessed today. He's gonna come back for sentencing, and I'll see what we're gonna do here, okay? So I'll sentence you on both cases on the same day, but you have to go over to probation and fill out a questionnaire and be interviewed, okay? So what date do you want to give me there, Heather?
We can do March 4th at 10 o'clock.
March the 4th at 10 a.m., okay? That will be your sentencing date. Do you understand that?
March 4th, 10 a.m.
Yeah, so you go down the hall, you'll get your notice. And then you're gonna go back over to probation where you'll fill out a questionnaire and be interviewed, all right?
Oh,
We understand one another?
yeah, I understand everything.
But what?
You on the floor.
But what?
Well, I don't drive, of course, I ride an e-bike. I live 20 miles from here, I'm riding an e-bike here. Is there any way we can do this Zoom?
Yeah. Yeah, I'll let you do it by Zoom. You're gonna get screened and assessed today. Heather, make a note in these files. I'm letting them appear by Zoom.
Okay,
Okay.
Judge.
Yeah, I don't have a problem.
Okay, I push it, and sorry for the.
And give him make sure we have his correct address, will you please?
Thank you.
Yes, Judge.
Thank you, thank you.
I got 3 more.
Okay. Randall Patrick Watson, 26W84107 and B.
He is also on Zoom. He's out of state, Judge.
Yeah, Mr. Watson, start your video and state your name, sir. Your name?
Randall Watson.
All right, you're charged with disorderly person, public intoxication, and resisting obstructing an officer. You have the right to a lawyer. If you want one, I will provide you with one at public expense. Would you like a lawyer?
No, sir.
I'll go ahead and arraign you then, and I'll explain the charges and your rights, and we'll go from there. On January 22 of 26, it is alleged that you were at 20990 West Road with the Buffalo Wild Wings in the city of Woodhaven at 11:16 p.m. and they think you were disorderly, public intox, a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. They think you had a PBT result of 0.248. Do you understand that?
Yes, sir.
You're also charged with resist and obstruct an officer. That is a misdemeanor. It is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court. You have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial or a hearing of any kind. You understand that?
Yes, sir.
So I'll enter a not guilty plea for you. I'll send you to the prosecutor. Listen. I'll send you to the prosecutor. I'm gonna give you a $500 personal bond. You don't have to post any money. But here are your bond conditions. You can leave the state. You live in Texas, right?
Yes, sir.
You can leave the state to go to Texas without consent. You're not to enter, not that you're gonna be here. I don't know what you were doing here, but you're not to enter 20990 West Road in the city of Woodhaven or any other Buffalo Wild Wings. You're not to have any contact with prosecution witnesses. You're not to purchase, possess, or consume alcohol, illegal drugs, or marijuana. Do you understand that?
Yes, sir.
All right, so I'll send you to the prosecutor and you can work that out. And if you can't work it out, you want a lawyer, I'm entering a not guilty plea, as I said. If you want a lawyer, you tell me when you talk to the prosecutor if you don't think you can work it out, okay?
I mean, sir, if it's all the same, I'd just like to pay the fines and be done with it.
Just go talk to the prosecutor. I'm trying to be fair with you here, okay? It can't hurt you.
Alrighty.
All right?
Thank you, sir.
What school's in Lubbock again?
Texas Tech.
I thought so. Okay. All right. Have a good luck to you. We'll see you back on here in a few minutes whenever you're done talking to him. Thank you.
I'm
Yes,
gonna
sir,
put you
thank
in
you.
breakout room 1, Mr. Watson, okay, with the prosecutor.
Alrighty, thank
Breakout
you,
room
ma'am.
1. All right, Watson.
Yes,
Randall
sir.
Patrick Watson. 26W84107-1A and B. Your name, sir?
Randall Watson.
All right. Jeez. All right, so this can be a no contest plea. I'm not sure what he's doing here. It looks like it's a no contest plea to resist and obstruct an officer based on, here, can you mark that, please? Based upon your level of intoxication, he's going to dismiss the disorderly person. Is that true?
Yes, sir.
Is that what you want to do?
Yes, sir.
And you understand a no contest plea has the same effect as a guilty plea.
Yes,
And
sir.
if you plead no contest to resist and obstruct an officer, I'm going to go ahead and dismiss the disorderly conduct charge. Do you understand that?
Yes, sir.
And a no contest plea has the same effect as a guilty plea. If you plead no contest, possible penalties to resist and obstruct an officer are up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes, sir.
And you remember the rights I covered with you at your arraignment, right?
Yes, sir.
If you plead no contest, you're giving up the right to remain silent. You're waiving your right to a trial. You're waiving your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead no contest, you'll be giving up all those rights.
Yes, sir.
Hang on one second. He's got the wrong police report in here. Jeez. I don't know what the hell is going on. Hello?
Yes, sir. I'm still here.
I don't know what's going on with this here. Can you call over to Mr. Urick or whoever's in there? And I need the police report on Watson. The one that you marked is not the correct. They put it in the wrong file. This is not.
Which room?
Wait a minute. Hang on one second. I do. Yeah, I need Mr. Urick. I need the police report on Randall Watson. You guys got a couple different guys in here or something. Oh, wait a minute. What is, hang on a second. Is it just a one-page report, maybe? You got arrestees listed as a James Kareem Williams and Gregory Thomas Marshall. And then they've got the all right, I think it's just a one-page report. You guys gave me the 3 pages and the other 2 belong to somebody else. Here, let me take this, you're gonna have to remove this exhibit sticker. And then that can go on this one if you, or else I need another one. I'm so sorry, Mr. Watson. If you plead no contest, you're giving up your right to a trial. You're giving up your right to remain silent. You're giving up your right to testify or remain silent. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving the presumption of innocence. And it has the same effect as a guilty plea, like I told you. Do you understand that?
Yes, sir. Perfectly fine with all of it.
And you stipulate I can use the police report to establish a factual basis here.
Okay.
So I've had that marked Peoples 1 to the charge, resist and obstruct an officer. How do you plead? No contest?
No contest.
I'm gonna review the report. All right. Are you on probation or parole?
No, sir.
Anybody force you to plead no contest?
No, sir.
I'll accept the plea of no contest. They're recommending fines and costs only. Please accept it of no contest to R and O. Dismiss the disorderly public intox. I'm ready for sentencing. Is there anything you'd like to tell me?
No, just
Have you
I
been in trouble
apologize to
because of
the
your
arresting
drinking?
officer.
Have you gotten in trouble because of your drinking before?
Yes, sir. Previously in the past.
Do you have any drunk driving citations, convictions?
20 years ago.
When's the last time you had an episode of where you were arrested because you were intoxicated prior to this January 22 of 26 incident?
I would say 8 or 9 years ago.
All right. Okay, I'm gonna go ahead and sentence you, but if you have something else to say, I'll
The only
listen.
thing I have to say is I apologize to the arresting officer, just in general, and to the Buffalo Wild Wings staff.
100 fines, 225 costs, 75 victims' rights, $50 justice assessment, 450 or 90 days. Can you pay that today?
Yes, sir. I can pay it right now.
You can go on 33court.com, and that's with the B case number, because I've dismissed the disorderly public intox. Okay?
All righty.
You're all set. Have a good day. Good luck to you.
Thank you, sir. Thank you.
Come on up here, folks. People against Dolores Griselda Vasquez Vales, 267841375, and Travis Philip Shatima, 267841324. You
all the representatives of the business.
all right. And your name again?
Shalonda Heisley.
You're still under oath.
Yes, ma'am.
And your name, ma'am? Sir, your name? All right. So what I have here is 2 pleas that are going to be taken. They're going to plead to retail fraud for a period of 12 months under 771.1, correct, Mr. Crawford?
Correct.
And is that what you want to do, Mr. Shatima? Is that what you want to do, Ms. Vasquez Valles?
Yeah.
If you plead guilty here, folks, the possible penalties are up to 500 fines, 90 days jail. Costs are all of those. Do you understand that, Mr. Shatima? Ms. Vasquez Valles?
Yes.
And again, did the interpreter read you the rights form, Ms. Vasquez Valles?
Yes.
Mr. Shatima, did you read the rights?
Yes, sir.
Did you understand them? Did you understand the rights, Ms. Vasquez Valles? I need two judgment forms.
Yes.
If you would, please. Just the probation orders, I mean. And, all right. Now, to the charge of retail fraud, Mr. Shatima, how do you plead?
We plead guilty, sir?
And Ms. Valles, how do you plead to the charge of retail fraud?
Guilty.
Were you, Mr. Shatima, at 23800 Allen Road in Woodhaven on February 2 of 26?
Yes, sir.
And were you there on that date, Ms. Valles?
Yes.
And did you take something that was offered for sale without paying for it, Ms. Valles?
Yes.
What did you take?
A little light for my child's bicycle.
Did you take up something that was offered for sale and walk past the register without paying for it, Mr. Shatima?
Yes.
What did you take? Did you each steal something different?
Yes.
All right. And what was the value of those items? Can you tell me, Mr. Shatima? And the police recovered the property, is that right? Are you on probation or parole, Mr. Shatima? Are you on probation or parole, Ms. Valles?
No.
Anybody force you to plead guilty? Anybody force you to plead guilty, Ms. Valles?
No.
All right. I'll accept the pleas to retail fraud. I'll take them both under section 771.1.
Pleadings for immediate sentencing.
I am going to do that. Is there anything you'd like to say, Mr.
I've
Crawford?
had an opportunity to talk to both of my clients. They're ashamed of their decision that particular day. It's a one-off, Your Honor. They don't have a good explanation for why they did it, but they know they were wrong. So they feel sorry about it. They're embarrassed to be here today. You won't see them here for this type of activity.
Anything you would like to say, Ms. Valles?
Yes. We have been very sorry. Let's see. I don't know why I did it.
Going to be expensive $30 items. 12 months probation. Do you want to say anything, Mr. Shatima?
Pretty much the same thing as her, embarrassing. Don't do this. I don't know what came over that day, that's about it.
12 months probation. I'll take it under section 771.1. I'm going to need a review hearing date, Heather. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must report to probation as directed. You're not to enter 23800 Allen Road in Woodhaven or any other Walmart. And that's it. I'm not gonna assess community, I'm not gonna make you do community service, but these are expensive because there's $240 in probation fees. Fines of 50. Cost 25. 75 victims' rights fee. $50 justice assessment. 440 or 90 days. So all you have to do is stay out of that address, not go in any Walmart store, pay your 440, come back, I will dismiss the case on motion to the prosecutor. It will be on, what's the review hearing date, Heather?
It'll be February 17th, 27.
At 8:30 in the morning, February 17th of next year at 8:30 in the morning. What's wrong? What are you shaking your head about, Mr. Shatima?
Nothing.
Well, tell me.
That's crazy. I mean, you are. I mean, it's not nothing against you. Just we are planning to move out of state, you know, this year, and so I mean, they don't just do that because it's gonna be but
We're not, listen, you pay you stop, put your gum in the garbage, will you? Well, you're chewing something. You swallowed it then.
no, I didn't know.
Okay, listen, nobody's gonna stop you from leaving the state. Pay your 440, come and talk to me. And the prosecutor will probably move to dismiss earlier. But all these fees, the probation fees are 20 a month. That's standard. The 75 and 50 victims' rights and justice assessment, the state mandates I charge you that. All I charged you was $75. So that's the best I can do.
No,
Can you pay this or do you need time?
Your Honor, but they're gonna need time. I talked with them about this. My client here, he's the only one working in the household, Your Honor.
Just tell me how much.
I can pay $150 when you take it today, and then they can pay $50 a week thereafter.
Fine. 150 now, $50 a week. I'll start that beginning on February the 23rd. I'll even give you a little bit of leeway time. And if you ever need more time, just call the court. We'll go on Zoom. I'll be glad to give you an extension, okay? So that's what I'm gonna do on these. I wish you both well. You'll get your review hearing date. I don't even know if probation will need to instruct. It's just a question of payment. Okay? Are the other two done or not?
One.
Mr. Urick, call Mr. Urick in, John. All right,
Judge, you
thank
cut out on their payment plan. It was pay 150 today and then $50 a week beginning when? It cut out.
On the,
Next Friday.
on the 23rd.
Of February?
Yeah,
Okay,
Yeah.
thank you.
okay? Young lady, thank you so much for your help.
Enjoy your lunch. Thank you.
You too. Do we have Butler and Robertson in there?
Yes, Your Honor, they should be coming
Anthony
in.
Butler versus Paul and Shauna Robertson, 2600122. Appearances? Your names?
Anthony Butler.
Skylar Crenshaw.
Paul Robertson.
Shauna Robertson.
I don't remember where we left this. You guys were gonna resolve it or something, weren't you? I can't remember where we left this one. My apologies. Can somebody talk to me and tell me where I left this?
As far as I know, you sent us into a break-off room to get more information that they uploaded an M file, and you asked them to send it over to me, which was never sent over.
Well, did I tell you to send documents over, Mr. Robertson?
I emailed Anthony the documents or the pictures is what we were told to bear with me.
So you have to email.
AJ Butler at yahoo.com.
That's not the correct email address.
That's the email we had from what
Guys,
From where we
Guys.
sent documents for the lease.
guys. Come on, don't make me referee this nonsense. What is your email address, Mr. Butler?
It's ajbutler0025@yahoo.com.
Repeat that. Write it down, Mr. Robertson. Mr. Robertson and Mrs. Robertson, this is a rent, correct?
Yes.
If the problems are so bad, why do you still want to live there?
Your Honor, since the last hearing, we've decided to transition to alternative housing, and we're simply asking for 30 days for my family and myself to transition to our new home.
And what do you intend to do about the payments that are due?
That's exactly, we understand that there's a balance claimed, and we're just requesting guidance from the court and how that balance should be handled. But at this point, there has been
Glad
no
to come out there and
communication.
look at the property. You want me to come out there and look at the property? I'll be glad to.
You're more than welcome to. It's AJ's home. I mean, but I'm currently the resident. I have no issue with that whatsoever.
Now, correct me if I'm wrong, Mr. Butler, you acknowledge that there were some water issues, correct?
Not that they made aware to me. I just have a city report from when we sold the house or were trying to sell the house before they moved in that said that some waterproofing needed to be done around the house, but nothing about water issues within the house.
Well, they wouldn't say anything about waterproofing necessity unless there was some indication that there was going to be water intrusion. You can agree with that, right?
Correct. And we've been working with Steve McKegg, the building engineer, with the city of Trenton to get that solved. We had an inspection done January 14th, and we followed up with him after our second hearing with you and kind of went over that with him. And they didn't really have insight on
Guys,
exactly
let me stop you. You think if I put you in a breakout room that you guys can maybe resolve this or not? Does somebody want to talk? Or is there a big delay here?
I'm more than willing to talk to them and stuff, but I just feel like, I feel at this point, there's been no communication on a plan moving forward of anything
Okay,
being fixed
well,
on the
here's the
inspection
issue.
list, so
Here's
I
the
just-
issue. Here's the issue. Is the property uninhabitable? And if so, to what extent? Now, I see that you've got some pictures here of, it must be your kid, your child?
yes.
Yes.
Now, I can't say that I have any indication that that's caused by any water intrusion. So I want everybody to keep in mind that you should have told them Mr. Butler and Mrs. Butler, about the water intrusion possibilities and that you were advised to get waterproofing done. And I want you two to keep in mind that you're going to be entitled to an abatement of the rent only to the extent that the property becomes uninhabitable. So you guys can go from there. If you cannot resolve this today, I'm setting it for trial. And I'm going to give you a date probably next week. And I'm going to come out and look at the property with your permission, Mr. and Mrs. Robertson. And you both can present testimony and evidence. But you've been there and you haven't paid any money. And maybe, just maybe, you guys can go into a breakout room and don't leave. Do not leave if you don't come to a resolution. I want to talk to you again. I'm going to go on to another couple of cases. So you guys see what you can do. Be respectful of one another. And I mean that. You might not like each other or think that you were harmed because they're not paying rent. He's cheated and they didn't tell you about the waterproofing issue. Just be respectful of one another. Don't leave until I call your case again, please. Okay?
Yes, Your Honor.
Your Honor.
Thank you. Put you in a breakout room. Thank you. Hidden Oaks. This is Linda Cisco. 260138.
Good morning, Your Honor. For the record, Joseph Shimatero on behalf of plaintiff Hidden Oaks.
Ms. Cisco, your name?
Good morning, Your Honor. Lisa Cisco, defendant.
I gotta ask you something. Ms. Cisco, did you bother calling the court and telling them a clerk on the 1st or to meet on the 27th of January that your father had this medical issue that requires 24 hours oxygen and you couldn't appear on the 2nd?
No, the 2nd, it was a misunderstanding.
What do you mean?
I got the date wrong.
Well, what did you get? What date did you have in your calendar?
I had, it said you would see me the 1 week from today. So I thought the date was Tuesday. So I apologize. It was just a misunderstanding for the return date.
Did you show up here on, what would that have been, the 3rd? Did you show up at court and say, hey, I'm here, where's the judge? I want to have my case called with Hidden Oaks?
No, actually, I realized on the 2nd, but I realized it while the case was going on. So I filed the motions the following day.
What do you mean you realized it when the case was going on? Did you call the court? Were you zooming in? What do you mean?
My mom was zooming in and let me know that I missed
She
it.
was zooming in just to watch court?
Yeah, to watch my case.
Well, but why, if you told her it was the 2nd, why did you think you didn't, which caused her to zoom in, why did you think you didn't have to be here till a couple of days later?
I thought that I had to be there on a Tuesday. It was just a complete misunderstanding.
Did you call the court then?
Yes, I did. I called immediately.
Did you speak to somebody in the civil department?
Yes, I did.
Who did you speak to?
I don't know her name. I'm sorry.
Did anybody get a phone call, Jennifer, on the 2nd of February from Ms. Cisco?
I don't see any notes, but if she did call, it would have more than likely was after her case had been called in front of you.
Was it after the case was called, ma'am?
Yes, it was.
lack of written notice of any rent increase. I can't recall anything being raised about that. Mr. Chimatero, can you enlighten me?
So Judge, Ms. Cisco's been there for several years. She had, her original lease, I believe, was at a $950 a month rental rate. I've got the owner and manager of the property on the Zoom if you want to swear him in, and he can give you exacts on that. But she had increases over the years. I've got a ledger here from management that indicates that her rent was increased back in 2024 to $1,350. Now she acknowledges that she had communication verbally, but nothing in writing. And she had, in fact, according to this ledger, made several payments at the $1,350 mark. But at some point last year, she started going back to the previous amount of $1,000 a month and reduced her rent. So the arrearage that and the judgment that's there is because of like a $350 difference between what her rent was supposed to be and what she was paying over a long period of time. So in speaking with her, her position has been that she doesn't owe the increase because it wasn't communicated to her in writing. And you know, I've got my client here to indicate that he sent her statements over, you know, quarterly over the last few months or over the last year as to what her balance was, what her arrearage was. And, you know, truthfully, he was working with her and she had been a tenant for several years there. But it's gotten to a point now where she's unwilling to pay the increase. And, you know, and she's a month-to-month tenant, Judge. There's no long-term lease in place right now. And so my client is just at a point where he wants her evicted.
Well, but if she pays the back due rent.
Well, yeah, it's a non-payment of rent. So if I've communicated that to her and she said she's unwilling to do that. And so that's where we're at.
Well, okay. Is this your client? Is he a representative from Hidden Oaks here, Jimmy G?
That's correct. Yes. Jim George.
Okay, Mr. George, I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, sir.
What is your position with Hidden Oaks LLC?
I'm a managing member.
All right. When did her rent increase to $1,350 per month?
I do apologize. Don't have the exact date in front of me. I am on vacation right now when I was notified about this, but I believe it was in 2024. And my attorney, I believe, has the ledger in there when the tenant, Ms. Cisco, was paying the increase. I believe she paid 4 or 5 months the increase and then stopped and went back. So
why did you stop paying the $1,350, Ms. Cisco?
I didn't actually stop paying it. Some payments were made for different amounts. And
he's telling me, I think, that you paid $1,350 from the time that he increased the rent for a period of 4 months. And then his lawyer, is that not true?
No, that is not true.
Do you have the ledger, Mr. Chimatero?
I do, Judge. The ledger here indicates that the first increase was April 1st of 2024. And on April 8th of 2024, there's a payment for $1,350. On May 1st, 2024, again, a $1,350 charge. On May 15th, a payment of
Hang on a second.
Yeah.
You can't wait a couple minutes. Look, I came back. I said I'd be back at 5 after 1. I was out here waiting for, I walked in the door. My court officer said there's perfect timing. I don't know what was taking so long. And everybody else's problems become my problem. I'm going to ask you to stay until I can get through those. I mean, I haven't asked you to stay on an afternoon ever, I don't think. Maybe if I have, you can remind me when.
Historically, Judge, if that's the case, we anticipate that to effect. There's a bench trial set.
Do you have another court office?
Dispatch.
Do you have another court case?
We could.
Do you have another court case?
No, I have an obligation that I would have made different provisions for had I known I would be here going on to a project.
I don't control how fast you guys work is the problem. If I did, I would have been done by 11 o'clock today. So I've got Glenn that's going to be a plea to disorderly. I've got Novotnik that's going to be a plea to no ops. I mean, I'll be glad to let you go, but I'm going to ask you to keep your afternoons open. I don't control when lawyers show up, how quick they are, when people show up, how quick they are. I'm going to ask you to do that for me. Okay.
Appreciate that. We moved as briskly.
I know, well, I know, but okay, good. Mr. Chimatiro, my apologies.
No problem.
You said you started to say her first payment was going to be $13.50 on April 1, and on April 8th, she paid how much?
On April 8th, she paid $13.50. On May 15th, 2024, she paid $13.50. On June 17th, 2024, $13.50. July 15th, 2024, $13.50. And then September 2024, a $13.50 payment. And then there was
So there she was behind a month, starting with April 1, right? She didn't pay anything in August.
August, there's two payments, Judge. She paid $13.50 in August too. There was a $1,000 payment, and then 2 weeks later, a $350 payment.
Now, why isn't that acquiescence, Ms. Cisco? It's not like you can say to me, I just decided out of the goodness of my heart to start paying more money. What was the rent before it was $13.50?
$9.50.
Well, did you just decide out of the goodness of your heart to start paying $13.50 because you thought you were paying too little to the landlord?
No.
Well, then what's the problem? You acquiesced in the arrangement, didn't you? When you started paying $13.50, you told me you didn't pay it for 4 or 5 months. He just reeled off 4 months when you made the total payment of $13.50 and another month where you paid $13.50 total. Right?
Yeah. What
about in October, Mr. Chimatero? How much you pay in October?
So then in October of 2024, she made one payment of $1,000. But then there was a July of 2025 where she made a $13.50 payment. All the other months then were $1,000.
I cannot find, ma'am, that there's a meritorious defense here. I mean, you did not do anything other than agree to pay the $13.50, or you wouldn't have paid the $13.50.
Well,
So I don't know if there's a meritorious defense when you acquiesce to it. And I can't find good cause either because you should have been here and you weren't. And the fact that your mother was on there watching should tell you that you told her the court date was on the 2nd. I mean, otherwise she didn't just get on here and start watching Zoom TV at 33rd District Court. I can't do anything for you. I'm sorry. I'm gonna deny the motion to set aside default judgment. And I'm going to.
Can we pause the eviction just because I have my father here who's disabled?
Should have
until I
thought
can find
about this
place
a
to live?
long time ago. You know, now I got to tell you something. I'm not unsympathetic about your father. I'm very sympathetic about your father. But these guys, am I supposed to say, hey, just let them stay? You should have thought about this. I'm sorry. Did you submit your application for a writ yet, Mr. Chimatero?
No, Your Honor. Shortly after, I'm looking at the judgment. I think February 12th is the date for the writ, but we had this motion filed, or she had this motion filed, so we didn't apply for it until after this hearing.
Defendant's motion to set aside default judgment denied. Defendant's motion to stay eviction denied.
Thank you, Your Honor.
Hang on a second. I'm going to ask you to not submit a writ, the application for a writ until Monday. Can you live with that?
Until when, Judge?
Until Monday. Can you live with that?
Yeah, that's no problem, Judge.
So do you mind preparing a separate order here that says motion to set aside default judgment denied, defendant's motion to stay eviction of writ denied. However, court ordered plaintiff's counsel not to submit application for writ until Monday, February the 23rd. So you got to be out this weekend, ma'am.
I have to be out of here this weekend
Absolutely.
with a disabled senior citizen.
Ma'am,
Oxygen.
I'm not going to argue with you.
I'm not arguing. I
You
need
knew
to
you
clarify.
knew about this. You knew about this for a long time now. You had court dates about this. They served a 7-day notice. They served their complaint. We had a couple of court dates. You didn't show up on the 2nd. You knew you got the judgment saying to be out by the 12th. There's nothing more I'm going to do. I'm sorry. I really am. Good luck. All right. I'm recalling Anthony Butler versus Paul and Shauna Robertson, 2600122. I see you're all out there. I don't want to know the status of your discussions. Are you guys getting anywhere?
Yes.
Yeah.
Okay,
Yes.
good. I'm putting you back in a breakout room then, okay?
I think we're like, we have
A tentative
Yeah.
resolution,
Yeah.
if you would like to hear that, or do you need a?
a minute.
Well, no, I don't need anything. I'm here to, you got my full undivided attention. But I want to make sure when you say tentative, have you guys agreed on this?
Yes. The only
Yes.
thing partially.
Do you, Anthony, go ahead. Do you want to just take the?
Yeah, go ahead.
Yeah, so
the
we,
discussion?
Hang on one second. Hang on one second. Jennifer, I just want to have, while I'm doing this, I'm gonna prepare a judgment for you guys.
Okay,
And
I'll print one up.
thank you. All right, go ahead. Tell me what the terms are.
yeah, so they're following through with moving out of the residence at the end of March 31st, we agreed on. As
Okay.
far as rent payment and what's owed, I guess we wanted to touch base with you on the judgment of that and how payment system would work.
Well, wait a second. Did you guys agree to a figure or not?
We gave him what all is owed, including our lawyer fees, and Paul
Well-
has his say
Well,
in not
I
wanting
don't
to
really,
pay.
okay, so here's the problem, guys. I don't really want to be the one facilitating a settlement discussion because I'm going to be the one who's going to decide the case if you don't resolve it. So I don't think I should be the one mediating this dispute, particularly if I'm going to be the one that's going to decide whether or not money's owed, and if so, to what extent. So I can put you back in a room and let you guys talk about it. I gave you my best recitation of the law, so to speak. And that is, the property has to be uninhabitable, but that doesn't mean there wasn't some damage. Now, I don't know how much damage there was. That's for you guys to decide. So I don't feel like I should be the one to facilitate that discussion any further. I can do one of two or three things. I can put you back in a breakout room, or we can set it for trial next week. And I'll come over and look at the property as part of the proceeding. And, you know, if I order that, they might be out in 10 days too. So if that's what I decide to do.
Your Honor,
This is strictly, by the way, you guys, the way they've crafted their pleadings is for non-payment of rent. So if you guys decide that they're going to be out by whatever date, that's fine. Maybe there's a provision that they have to pay so much in rent in the next 10 days. Maybe there's a provision that they have more time to pay. Maybe there's a provision that gives you a money judgment in favor of the plaintiff and against the defendant. I don't know. But that's something for you guys to figure out, because I don't want to get in the middle of that. I will decide it, and I shouldn't be involved in settlement discussions on a non-jury case for the most part. I just shouldn't do that. So
Your Honor,
I
where
don't,
we,
go
oh,
ahead.
we left off where the butlers did, or they were to, they have a documented amount and a breakdown of the outstanding rent, late fees, lawyer costs and whatnot. And we agreed that that would be emailed to us today. And then possibly I would have 48 hours or Monday just to review. And then we could come to an agreement outside of the court rather than a trial, because
Nobody wants it.
no one wants that. We're four adults. I think that we can resolve, but I think the matter of us just going back
Well, why don't
into
you
a court.
spend time resolving it now?
I don't have all the information, and they don't have all the information of all of the ins and outs or the details. That's what I would just like the just to agree on a, substantial $10,000. I don't feel comfortable doing that without
Well, how
some form of
much,
time.
how much is the monthly rental rate?
It's $18.50 a month.
And how many months are they in arrears?
4 months behind.
All right, so that's $7,400.
Yeah, with late fees, and then in the lease.
The most I
every-
give in late fees is $75 a month, so the most they could be behind is 300 more.
Yeah, we charge $50 a month for late fees.
Okay, so then you only get $200. All right, that's $7,600. Then they have their costs.
Yep. Lawyer fee was $1,049, and then
Who's
per our
that for?
Heather.
No, I mean, some lawyer you hired that isn't entered an appearance. You're really not entitled to that.
Okay, that's fine. But in our contract,
What I
after
can do, guys, here's what I'm gonna do. I'm gonna say, I'll go along with what you're doing. I'm setting this for trial next Wednesday. I'm not adjourning it. You guys can submit figures, and I'll call, we're gonna have you guys in here on Monday. And if it doesn't resolve, we're going to trial on Wednesday, period. Everybody can do that, Mr. and Mrs. Butler?
yes.
Okay, so
Mr. and Mrs. Robertson?
Yes.
What's wrong? Did you have something to say, Mrs. Robertson?
I just wanted, so we're gonna be able to get we're gonna go over, so mainly we're meeting to file, so we'll have a judgment of how much money will be paid on Monday. Is that
If
what
you
you're
guys
saying? I
resolve
just want to
it. If not,
understand
we're
it.
gonna have a trial on Wednesday. What time
Okay.
could I do it on Wednesday, Jennifer?
I was gonna say Tuesday would be better. You do have a civil day Tuesday.
Okay, then we'll do it Tuesday. Is Tuesday not gonna be very busy?
It's not terribly busy because that was originally the Mount case. So we've added things, but it's not
What's my latest thing scheduled for?
11.
All right, so we're gonna set this for 11 on February the 25th.
24th,
then-
Your Honor.
24th at 11, and you guys are gonna meet, and we're gonna schedule that where you guys meet. What do I have Monday?
Monday you have landlord tenants.
All right, good, perfect. We'll set this for the 23rd at 8:30. And you guys can hash it out. You guys can hash it out. If you don't resolve it, fine, we'll go to trial on Tuesday. Everybody good with that, Mr. Butler?
Yes, that's fine.
Mrs. Butler?
Yes.
Mr. Robertson? Where'd Mr. Robertson go?
Oh, I'm right here, Your Honor. Yes, I'm fine with that.
Mrs. Robertson, you okay with it?
Yes.
Okay, so I'm gonna encourage you guys to keep talking, okay? And hopefully on the 23rd, it'll be resolved. All right.
Every day in the USA, people find themselves in court.
Thank you. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. You may proceed on the warrant.
On February 18th, 2026, at approximately 3:43 in the morning, Officer Bro and Officer Sloan were dispatched to 10th Street for malicious destruction of property in progress. Officers were advised that a female was in the caller's backyard striking their vehicle with a baseball bat. Officers were then advised that the female fled in a gold-colored sedan, last seen northbound on Electric from Walnut. Officer Bro and Officer Sloan arrived at 2215 15th Street and spoke with the caller/witness, Jill Sotheby, Plano. She explained that she observed Becky Rose striking David Hasselback's 2017 Chevy Silverado with a baseball bat, causing damage to the hood, driver's side front and rear doors, driver's side rear fender, broke off the passenger side headlight, broke the driver's side door handle, and put multiple scrapes on the front driver's side window. Sotheby Polano further explained that she and Hasselback were sleeping when she woke up by a loud bang coming from the driveway. This is when she looked at the bedroom window and observed Rose striking Hasselback's vehicle. Rose was leaving the backyard to speak with Sotheby Polano, but when she realized she was on the phone with the police, she fled in her vehicle in an unknown direction. Hasselback explained to officers that he and Rose were in a former relationship and ended a few days ago, and this is probably the reason for her to damage his vehicle. Sotheby Polano has a camera facing a driveway and it captured the incident. Officer Saltzman responded to the call as well. He had prior knowledge of Rose and the vehicle that she drives. As Officer Saltzman was approaching Cedar and Electric Avenue, he observed an older gold Chevy Impala turn westbound onto Cedar Street from Cora Street. Officer Saltzman drove past the vehicle and observed a white female with brown hair sitting in the driver's seat as a sole occupant. At the same time, the caller told Officer Bro that the female left in a Dodge Neon. So Officer Saltzman disregarded the Chevy Impala and continued looking for a Dodge Neon. Moments later, Lincoln Park Police Officer Wilson, badge number 2634, operating Patrol Unit 4A, advised they were attempting to catch up to a gold Chevy Impala with Michigan registration traveling northbound on Ford Street near Emmons. Officer Saltzman advised that this was the same vehicle that he just observed and he would like it stopped. Officer Wilson initiated traffic stop on the vehicle on 4th Street near Riverbank. Officer Saltzman made the scene and identified the driver in the vehicle as the same that he had seen near Cedar Street and Cora Street. The driver of the vehicle was identified as Rose, and she was taken into custody by Officer Saltzman for MDOP. During his interactions with Rose, Officer Saltzman observed her eyes to be bloodshot and glossy, and he also detected a strong odor of intoxicants coming from her person. So he requested her to submit to a standardized field sobriety test, which she did. After performing the SFSTs, Officer Saltzman read Rose her preliminary breath test rights. which she agreed to submit to. Officer Saltzman administered a test and received a result of 0.34% BAC. He explained to Rose that she was under arrest for NDOP and OWI. While conducting an inventory search of the vehicle, Officer Smith located a wooden bat in the passenger seat of the vehicle. Officer Saltzman, while checking Rose's purse, located several containers containing pills. In a silver metal circular container, he located one white oval shaped pill labeled M366. He identified this pill as a hydrocodone by utilizing drugs.com, which is a Schedule II controlled substance. Officer Saltzman read Rose her chemical test rights, and she agreed to a blood test. Rose was transported to the Henry Ford Wyandotte Hospital, where RN Nicholas Travis removed 2 vials of blood from her right arm. The vials were sealed and later placed in the outgoing mail to be mailed to the Michigan State Police Forensic Laboratories. Rose was transported back to the Wyandotte Police Station, where she was housed. After checking Rose through lien, it revealed that she had 2 prior OWI convictions. The first back in July of 2008 out of Southgate, and the second back in October of 2010 out of Woodhaven. A MAPS report was produced and it revealed that Rose had a prescription for hydrocodone back in May of 2025.
On examination of the complaining witness, I find that the offenses charged were committed. There's probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you. And ma'am, your name for the record, please.
Michael Rose.
Okay. And counsel, as to the arraignment.
As the arraignment, we waive formal reading. My client stands mute.
The court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. And you did, in fact, have an opportunity to speak to an attorney today. Is that correct?
Yes.
The court has also signed the petition in order for appointed attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th. 10:45 a.m. Counsel, as to bond.
Your Honor, I know that my client does have 2 priors, but I will note that they're both 15 years plus old. She's not on probation or parole. She lives in Lincoln Park with her daughter, who's 24, strong family support system. She works full-time in a nonprofit organization. Your Honor, I believe that this is obviously something that potentially stemmed from a breakup that went terribly wrong, but I don't believe this is inherent of a situation where she's going to duplicate this behavior. I don't believe that she's a flight risk. I would respectfully request any consideration, although it is a felony, that her 2 priors are significantly old, and the other one is regarding damage to property. I would ask consideration for a personal bond. Thank you, Judge.
All right, ma'am, where do you work?
I work for a nonprofit in Lincoln Park. It's the 501(c), the Downriver Alano Club. I also forgot to mention that I do crafts with my mom on the side as well. I didn't tell, I forgot to disclose that information.
Okay. And ma'am, if you were to test right now, what is in your system?
Only my prescription for my antidepressants, my anxiety meds that have been brought here and given to me by the officers.
Okay, and what do you do for the nonprofit, ma'am?
Counter help, help with events, cleaning, decorating, opening and making sure that the rooms are open for members.
And what is the use Alano or Alamo?
Alano, as a and as a no, sorry.
Okay, and that's an environment for individuals in recovery, correct?
Yes, it is. Something that, sorry.
And are you out on bond in any other jurisdiction?
No.
Have you ever failed to appear for court in any other matter?
Ma'am. Mm-mm.
I'm sorry?
No, ma'am, I haven't.
All right.
I appeared when told to be or scheduled.
All right, and you're not on probation or parole anywhere, are you?
No, ma'am.
All right, Detective, would you like to address bond?
Yes, Your Honor. On this case, she does have 3 felony charges. Yes, the OWIs are older, but the MVP that she just committed, damaging a gentleman's car, I'm looking at 15,000, 10%.
All right. And ma'am, how do you know Mr. Hasselback? Do you have any children in common?
No, we were actually dating. We hadn't broken up. We had been together. And he didn't answer. And
I would ask, yeah, Judge, they don't have any children together, and they were in a relationship, or obviously there's going to be a no contact provision, which I won't object to.
After review of the charges in this matter, review of Ms. Rose's criminal history, taking into account the nature of the charges and the allegations, and that there are 3 pending felonies, the court does not find a personal bond would be appropriate in this matter. The court does find that a bond of $20,000, 10%, is appropriate. You are not to, these are the following bond conditions, ma'am. You're not to have any contact with David Hasselback or Jill Sotheby Paulino. That's phone contact, text message, email, social media, third party, anything of the like. You are also not to enter the premises at Mr. Hasselback's home, nor Ms. Sotheby Paulino's home. You're not to possess or consume any alcohol or drugs unless prescribed. You also, ma'am, are not even to be on the streets that they reside on. You don't reside in Wyandotte. You don't have any reason to be on those streets. You're not to possess or have access to firearms or weapons. Do you have any of those, ma'am?
No.
You are not to be released without GPS and alcohol tethered through the Wayne County Jail. Any questions?
No.
Okay, we'll see you back on March 5th. Thank you.
Thank you, Judge.
You can go in there and you can come over here.
Four? This lady has 4?
Yeah, she had warrants off and then.
Okay. All right, let's go on the record in the matters of, let's see, we have the City of Wyandotte for Cheryl Shabani, 1829227. 193794. The State of Michigan for Cheryl Shabani, 241258. And the City of Wyandotte versus Cheryl Shabani, 26208. Okay, counsel?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Ma'am, your name for the record, please.
Cheryl Shabani.
All right, counsel, as the City of Wyandotte matters, which there are 3 of those, I'm actually running out of room on here with all of these files. With the City of Wyandotte matters, counsel, let's handle those as far as an arraignment. As the arraignment on those matters, counsel.
Wait, formal reading. My client stands mute.
Okay, the court will waive the formal reading on those matters. Enter pleas of not guilty on your client's behalf. Schedule these matters for pretrial on March 4th, 10:45 a.m.
I need to like that one.
And then counsel, as to the state matter.
We wait for more reading my client stands, ma'am.
All right, ma'am, the court's going to waive the formal reading in that matter. You do understand you do have the right to have an attorney. If you're unable to afford an attorney, you may have one appointed to represent you. Do you understand that, ma'am?
Yes, ma'am.
You have in fact had an opportunity to speak to an attorney today. Is that correct?
Yes, I did just before this.
The court is also signing the petition order for appointed attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, ma'am.
The court will enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th.
10:45.
At 10:45 a.m. also.
It's 2 days right next to each other.
What's that, ma'am?
Nothing.
Okay, counsel, as to bond.
Your Honor, on a positive note, my client is a local resident of Lincoln Park, currently lives alone, but she is gainfully employed. She works at Getwell Urgent Care in Southgate. She's a medical assistant. She's also a full-time student at Henry Ford, taking 13 credits, and she has aspirations to go to nursing school. Judge, I know that there's some outstanding warrants. We'd ask that those be set aside, and we'd ask any leniency when determining an appropriate bond based on her age, her employment, and her schooling. Thank you, Judge.
All right, ma'am, why do you continue to ghost the court here? Do you not like to come visit here?
The last court date I did come to, the first one, apparently I thought it was a video on my phone, but it wasn't, it was here. But then my attorney rescheduled that next one. And then when I showed up to that one, I sat there for 2.5 hours on the video one. My attorney never showed up. And then I was told to hang up and get a hold of her. I got a hold of her. She never got a hold of me back. Now that's not me. I should have called again. I should have rescheduled.
Well, of course, ma'am, because it's been 16 months. So actually almost 18 months. So yes, well, first of all, you were arraigned out county on your felony matter September 1st of 24. You were scheduled for probable cause conference September 12th. You did not show up. A warrant was issued for your arrest. Prior to the court issuing the warrant, you must have contacted in and we rescheduled it to September 26th.
Yeah.
You were present. Your attorney was not.
Yes,
attorney,
ma'am.
the court made a note on here that you were present, but not at the time the case was called. Defense attorney attempted contact to no avail. The court waited an additional 2 hours to call the case so that your attorney could get a hold of you. And he or she was unable, Sarah Krause, she was unable to get in touch with you. And so the court issued an immediate warrant. Now, it's important to note that your charge in this matter is possession of controlled substance and driving a license suspended, revoked, or denied. That's important, ma'am, because not only did you fail to appear on 2 other matters for the same charge of driving a license suspended, revoked, or denied, but then you ended up arrested last night for the exact same thing once again.
Yes, ma'am.
And you have made zero attempt to contact into the court to schedule any court dates. Because you also, ma'am, on your 2019 and 2018 cases also had failed to appear for your arraignment pretrials. We ended up sending you notice. We sent it for October 30th of 24. And you once again failed to appear in court on October 30th of 2024. You did not contact the court. You did zero, ma'am, to resolve your issues. Zero.
On the first ones, yes, ma'am, you're right. I didn't. I was very immature. Even though I was an adult, but I was very immature and stupid. I had a lot of drug problems. I've been trying to work through that stuff now. I haven't used drugs in a very, very long time now. I'm trying to get a better education And that last one we got before this one with the drugs, I want to fight that one, and I was trying to fight it. And I'm sorry I didn't push it further and keep trying my lawyer. I want
Ma'am?
to take care of this and get this out of the way. I don't want to
Ma'am?
this out more.
Ma'am, I can appreciate and commend you for being in recovery. However, what I'm hearing from you is you want to take care of these matters, but you're not doing anything to take care of them. In
I do
fact,
want to take care of them.
excuse me, you're continuing to violate the law and driving without a valid license, as you're alleged in all 4 cases to continue to be doing.
I lost my license for the driver's responsibility fee. I didn't even know that was a thing until after I lost my license. So yes, I got upset. Wasn't fair. I lose my license for something I didn't even know about.
Well, ma'am, then you have to address it.
Young
You
and
have to,
dumb.
excuse me. You need to address it and you need to stop driving until it's addressed.
Yes, ma'am.
And you reside by yourself?
Yes, ma'am.
All right. And you knew that you had warrants, and you knew your license was suspended, and you continued to drive anyway.
Yes, ma'am.
The court's going to, on the 24 matter, the court's going to order a $10,000, 10% bond. Based upon your previous failures to appear, the matter, you have 3 matters that you failed to appear on, and then you have a new matter that's the same charge as the other 3 matters.
That's 4 or 5 of them.
And the court will note that you have not made any attempt to resolve these matters since September of 24. The court's going to order on the 26th case a $10,000, 10% bond. The court wants to ensure the safety of the public as well, because you continue to operate a motor vehicle without a valid license, which does put the community at risk. On the 193794, the court's going to order a $5,000, 10% bond. And on the 182927, the court's going to order a $5,000, 10% bond. Your bond conditions, ma'am, are that you're not to possess or consume any alcohol or drugs that are not prescribed, and that you are to not operate a motor vehicle without a valid driver's license, which you're not allowed to do anyway, ma'am. But if you are, if you've posted bond and you are out and about and you're driving a motor vehicle, ma'am, you will be arrested again, and the court will likely revoke bond. And you'll be in custody until your next court date.
Understood, ma'am.
Have a good day.
Thank you, Your Honor.
All right, off the record.
Every day in the USA, people find themselves in court.
Yes, sir. I know Mr. Cat. Good morning. Good morning. All right. Good morning. This is State of Florida versus Dakota Cat, 25 CF 2340. And I think also has 24 CF 3049, which is should be a violation of probation. We're here today on a motion to suppress. And Mr. Cat is, Mr. Ballock's filed on behalf of Mr. Cat, and the state has responded. You too, Mr. Meredith. Thank you. Ms. Beasley, you have a good weekend too. All right. Let's see, this is, state concede they have the burden?
Yes.
Okay.
State called John Gay.
Mr. Gay, come on up.
Yes, ma'am.
Morning, say your name for the record, please.
John Darbrigade Jr.,
And where do you work?
the Panama City Police Department,
How long have you worked there?
since May 2023.
What are your current duties?
I'm a detective with the Street Crimes Unit,
How long have you been in street crimes?
approximately a year.
What's the role of the street crimes unit?
Mostly narcotics, drugs, prostitution, vice crimes, etc.
So you're part of the drug unit for the city?
Yes, sir.
As part of your training, are you trained to detect the odor of marijuana?
Yes, sir.
Were you working on July the 29th, 2025?
Yes, sir.
All right, now, you arrived there and were you involved in a different arrest, 261 Everett Avenue?
Yes, sir.
And that's the Henry Clerking Apartments?
Yes, sir.
Now, about that area, have you in your experience done drug arrests in that apartment complex before?
Absolutely.
All right, so would you consider that a high crime area and specifically about narcotics?
I would.
Now, so you're involved in this other arrest of someone else. How did you first come into contact with the defendant, Dakota Cat?
We were currently investigating another drug offense in the parking lot of Henry Kirkland. While talking to him, Dakota Cat exited an apartment nearby. As soon as he saw us, he started making furtive movements, tucking stuff in his pants, and he walked right beside us. His person smelled of marijuana. We made contact with him at his vehicle and obviously his vehicle.
Yeah, we'll get there. So he walks by you. How does he look?
Nervous.
He looks nervous. And then he goes, where does he go?
Straight to his vehicle.
And what do you do?
Well, I made contact with him at his vehicle.
All right, and what happened when you approached the vehicle?
As myself and Detective Shaver were approaching his vehicle, he tried to rapidly start it and leave. But we exited our vehicle, made contact with him at his driver door. I tried to ask him to get out of the car. His car smelled like marijuana. He instantly began resisting, wouldn't let go of the steering wheel. We had to force him out of his vehicle.
Now, at the time that he got into the car, did you see him doing anything in the car?
Yes, sir. He would, when he sat in his car as we were making contact with him, he was also still trying to mess with his pants, just sticking stuff in his pants.
And did that cause you any concerns?
Yes, sir. It's a big officer safety concern, possibly destruction of evidence or concealing evidence, etc.
So two concerns there, potential for officer safety and potential of destruction of evidence.
Yes, sir.
And you asked him to get out of the car?
Yes, sir.
Were you wearing your police gear?
I was.
So you were clearly marked as a police officer?
Yes, sir.
And he didn't comply with any of your orders to get out of the car. You had to physically remove him from the vehicle.
Correct.
Did you search the defendant?
Yes, sir.
Did you find something?
Yes, sir.
What'd you find?
He had a $20 bill that was folded multiple times. It had a substance inside of it that field tested positive for fentanyl.
And in your experience, that fold, is that indicative of anything?
Yes, sir. It's common with street level narcotics.
So you had a substance tested positive for fentanyl?
Yes, sir.
Did you then search the car?
Yes, sir.
What'd you find in the car?
Ammunition and marijuana.
And you then found out that Mr. Cat is a convicted felon?
Correct.
And we're not allowed to have that ammunition?
Correct.
No further questions?
About your witness.
Okay, you said that you were investigating a separate issue at this time, correct?
Correct.
How long were you on scene for that?
20 minutes.
Okay, and was that at all related to Mr. Cat?
Yes, sir.
That investigation was related to Mr. Kent?
Yes, sir.
How's that?
What we were investigating is we got out with somebody in the parking lot of Henry Kirkland Apartments, had fentanyl paraphernalia in plain view inside his vehicle. That individual later provided a sworn recorded statement that Dakota Cat did sell him the fentanyl from his apartment. And Dakota Cat was later interviewed at the Panama City Police Department in reference to that.
This all happened after this encounter though, right?
No.
This happened prior to?
Yes.
How soon before?
Minutes.
So minutes before they gave a sworn statement that Mr. Cat was involved.
Correct.
And that's an investigative report that you
Not mine, the Corporal Porter.
reporter?
Corporal Porter, Porter.
So you said that it smelt like weed. How close did you get to Mr. Cat?
When he walked by us?
Yeah.
Feet.
And what type of day was it? Was it dark out? Was it
It
light?
was clear sunny skies, 5 o'clock in the afternoon.
Okay. Was it windy?
Not very.
You said in your report that you smelled burnt marijuana, or was it regular marijuana odor?
Marijuana.
Is there a difference between burnt or regular?
To some people.
What about to you?
Not really.
Did you smell burnt or regular marijuana?
I smelled marijuana.
Okay. Was there any?
I want to know, is it burnt or green marijuana? I mean, that's a question I'd like to put in the answer.
Burnt.
Okay. Was there any indicators that would suggest that there was marijuana being burnt? Was there any smoke coming off this person?
While he was walking, no, sir.
Okay. Was he holding a joint or a blunt?
No, sir.
Did he toss anything in your presence?
No, sir, but he was messing with his pants.
Okay. Is that in itself criminal?
What?
Criminal in nature to tuck in his shirt or put things in his pockets?
Yeah, it can be, yes.
Okay. So it could be innocent, but in this situation, you saw it as criminal.
Let's hold on just a second. Whoever's out there making the noise, y'all need to be quiet. If you can't be quiet, leave the courtroom.
I think I was saying that you didn't see any observable evidence to suggest that he had a burning piece of marijuana on his person, right?
Correct.
Okay, so all you smelt was what you thought was an odor coming from his person.
Correct.
Okay. You don't stop him right then though, right?
No, sir.
Okay, you get in your car and you drive to his car, right?
Correct.
He's in his car when you pull out and you block him in, right?
Correct.
So he was unable to move.
Correct.
Was there any indicators that the car was turned on?
When
Did the
I
lights
was,
illuminate in Mr. Cat's car?
no, I could hear the ignition.
Was it a push to start or a key turn?
It was a key.
Okay, so you're in your car driving up and you can hear the car starting.
No, sir. It started when we exited our vehicle.
Okay, so you exit the vehicle and you're approaching his car
Correct.
and you're saying that he tried to start the car then?
Correct.
Was he under arrest at that point?
No, he was detained at that point, or preparing to be detained.
Did you give any lawful orders prior to that?
Prior to
Pulling up?
no,
As
sir.
he passed you, did you say, hey, stop?
No, sir. I didn't make contact with him until I pulled up to him.
Okay, so he passes by you, he puts something in his pocket, he tucks his shirt in, and you see that as indicators of criminal activity?
Yes, sir.
You walk up and within 6 seconds, you get him out of the car, right?
I don't know how long it took.
Did he open the car or did you open the car door?
I did.
So you walk up after blocking him in and immediately order him out and open the car door.
Correct.
Did you give him any chance to comply?
Yes.
Did you say open the door?
I said, step out of the car, open the door, and then myself and Detective Shaver ordered him multiple times to step out of the vehicle, to which he did not.
At this point, does he have to turn the car off?
No.
Because it's not on.
What do you mean?
The car at this point is not on, right?
No, he couldn't start it. The ignition was just turning.
Okay. And you saw that as evidence of him trying to flee?
Trying to not follow orders, yes, sir.
Okay, but at this point, he's not even He doesn't even know that he's being arrested or detained or anything,
No,
right?
he did. He was being told.
Through the glass in the car.
Oh, the door was open.
So it's your position that he was fleeing by trying to start the car?
I didn't say that he was fleeing.
So he was never fleeing?
No, sir.
Did you find any marijuana on his person when you did search him?
No, sir.
And when you did field test the remnants or the residue on the dollar bill, you said it came back to be fentanyl?
Yes, sir.
And was it later lab tested?
I believe so.
And did it come back not fentanyl?
I did not get the results of those. It wasn't.
If I were to show you, could you confirm it was or wasn't?
No controlled substance.
So what you presume to be criminal activity later was understood to not be, right?
I don't fully disagree with that or wholly agree with that.
Not like marijuana, but you found no marijuana in his person, correct?
No, sir, just in his vehicle.
And what you, well, and then what you thought was fentanyl on his person ended up not being fentanyl, correct?
Correct.
Would you agree that positioning your car in front of his made it impossible for him to be evasive or to flee?
Yes.
Did you ever ask him if he had a med card?
No, sir.
And where was the marijuana found in the car?
In the rear seat of his vehicle.
Okay, so not in the front seat or the passenger seat?
In the rear seat.
Okay, was it in a box or anything?
No, sir, it was just a joint.
Was it already lit?
It had been burnt previously.
How far would you say that you traveled from where your car was parked to get to where Mr. Cat was?
25, 30 yards.
I told you it took you 16 seconds to get there. Would that be somewhat accurate?
Sure.
Okay. So it takes you 16 seconds to get to his car. And yet you're saying that all the while driving over there, you were able to see through your glass and his glass, him doing movements in the car?
Yes, sir.
Your view wasn't obstructed at all?
No, sir.
Did Mr. Cat ever ask you why he was being stopped?
Yeah, multiple times. I told him that he was being detained for a lawful reason.
And what was that reason?
The odor of marijuana and the sworn statement collected from the individual.
I don't think I have any further questions for him, Your Honor.
Can you reiterate?
Yeah, just briefly, there was ammunition in his vehicle.
Correct.
And he was placed under arrest for being a felon in possession of ammunition.
Yes, sir.
Any other questions?
No.
Can the witness be excused?
Yes, sir.
So you may go about your day.
Thanks, sir.
Call your next witness.
That's all I have, Your Honor.
All right. Anything else?
Just like to add some closing argument, Your Honor.
Sure.
It's the state's position, there's the defense's position that the state has mischaracterized this as a detention that escalated. And it's our position that it was a detention from the start that's unsupported by objective facts, and the state attempts to justify it with facts learned afterwards. I believe that they cite several cases as controlling in this case. The first one is MIMS, and we believe that the facts in this are distinguishable from MIMS because in MIMS, it's a Supreme Court decision where the defendant was driving erratic, or he was driving on an expired tag. They pulled him over, they asked him to come out, and they had lawful reason to do so because he was being detained for breaking the law. this is distinguishable here because Mr. Cat was not driving. He was not breaking the law in any way. There are weak facts that the state stacks to make it seem like there's a stronger, compelling argument for why the justification was for detaining him. But it's our position that those weak facts don't automatically become strong facts just because you have a lot of them. It's our position that when taking the totality of the circumstance, deferred movements are tucking in his shirt and putting his hands in his pockets, moving his hands around in the car. He could have been using his cell phone, generic nervousness, and then vague officer conclusions. We don't believe that that's taking this in the totality of the circumstances, create objective facts to prove that unlawful activity was taking place. And to go even further, the state then cites the first DCA opinion from Hatcher. This is distinguishable from that case as well, because in that case, the defendant was driving at 3 a.m. He was driving erratically. When he gets pulled over, he admits, I just smoked a blunt, I just threw it out. He makes admissions, and then it's later determined that he was at a no valid driver's license. So they had the basis to determine that the detention was lawful based on objective, articulable facts in the case. In this case, he wasn't driving, he wasn't acting erratically, and the officer even admitted that the basis for it was not that he was fleeing or eluding, as the state contends in their response to our position. It's the state's position that we mischaracterized this stop as it beginning when the odor was detected, and that the stop actually happened when he was trying to flee. But it's the officer's position that he was never trying to flee. The officer put his car in a position where it was impossible for Mr. Cat to flee. And then there's no objectable facts to prove that he was doing anything unlawful aside from just smelling like marijuana. And I mean, we're talking about an open area in the middle of the day in a known crime area where they're saying that it came from him and not from somewhere else in the area. I think that those are weak arguments. We also rely on Kilburn, where it's another DCA opinion, first DCA opinion. In that case, the court found that innocent behavior, in that case, the facts are that there was a gun in plain view, and that they said that's an unlawful activity. But the court determined, no, that's actually not unlawful and not criminal activity, because you can have a legal gun, and just seeing the gun is not evidence of criminal activity. In this case, we argue that the weed smell alone is akin to the observation of a firearm in the vehicle. That just because he smells like marijuana doesn't mean that he's committing an unlawful act. They never asked if he had a med card. They never asked if he was in lawful possession of marijuana. They just assumed that because he was in a high crime area, that he somewhat smelled like marijuana, even though he testified wasn't burnt marijuana, it was the odor of marijuana. That does not justify breaking his Fourth Amendment by protections. It's our contention that the basis for the stop was for the smell of marijuana and not for fleeing. There was no lawful detainer. He was never told that he was under arrest. And moreover, Your Honor, I have this written down. It's our position that that there was no lawful stop here, that MIMS, though it's reference to them, it presupposes that a lawful detention was taken, had occurred, and that the issue here is that there's no basis for the detention of the defendant. And then Hatcher, it shows independent facts that created an issue before there was an escalation. We believe that the officers in this case escalated this situation, and that here it is. We believe that Your Honor, because there was no marijuana on this person and because the fentanyl tested, the suspected fentanyl ended up not being a controlled substance, it's our position that the state is in the wrong for continuing to prosecute Mr. Cat. And that rather than admitting it, we now have to prove why this whole thing never should have happened the way it did. Your Honor, it's our position that Mr. Cat was acting lawfully on this date and that he was detained without objective facts to establish he was creating or doing anything unlawful, and the officer is unable to articulate a valid reason to detain him. It was the state's position said, no, actually he wasn't. On just the smell of marijuana, I believe that they're violating his protections by using that as the sole basis to detain him and then further search.
Yes, Your Honor. A few things. I think Mr. Ballack suffers from a case of selective amnesia, starting with the fact that he puts in footnote number 1 of his motion that he accepts all of the facts of the state as undisputed, but then comes here and wants to challenge all of the facts. So I'm not sure if he wants to have his cake rated too, if the facts of the state's alleging are undisputed, and then he comes in here and challenges those facts. So one way or another. He's also missing one of the things that he elicited today, which I had not written in my response, but there was an informant who pointed directly to Mr. Cat as the person who had sold him the fentanyl. So it's not just the basis of marijuana alone. Mr. Ballack seems to forget that they had information about Mr. Cat selling fentanyl. They find a substance that field tests positive for fentanyl. It doesn't matter that it later wasn't anything. And I'm not prosecuting him for the possession of fentanyl anymore. We're prosecuting him for being a felon in possession of ammunition. So the later field test or the later test doesn't matter at this point. What matters is they were justified at that point in time because they had the field test, which allowed them to search the car and find the ammunition. We had an encounter here that was escalated over time. So, and each of the steps, they were allowed to do what they did, right? So they were allowed to approach him the way that they did because they had information about him and his appearance and his furtive movements. There's been no testimony about tucking in a shirt. I don't care how many times Mr. Ballack has to say that, right? He's the one who's saying he was tucking in his shirt. And then in the car, those furtive movements, and that allowed him to ask him to get out of the car. They search him, then he refuses, which then puts him under arrest at that point and being detained. The search of his person yields the fentanyl, which allows him to get into the car. So at each of the steps here, law enforcement followed what needed to occur. And again, missing and forgetting about certain inconvenient facts doesn't make it so.
I'll take it under advisement. We'll set this. No, we're not set for trial.
I like to set this for an evidentiary hearing. That's where this will end up. Yes.
Yeah, let's set it for March 25th at 1:30 and 9 o'clock. Now I have an order on this motion to suppress prior to that. Okay.
May I point out something that's really,
Unless you want to be placed under oath and be subject to cross-examination, no, sir. Mr. Cat, just have a seat. You weren't called as a witness. You want to be called, if your attorney wanted to call you as a witness, you'd have to be sworn and give testimony. So have a
ma'am,
seat.
you can leave. Now, thought about her. You need to leave right now.
Your Honor, if we could just reopen it.
Both y'all can leave.
You might want to talk to him. I mean, because he's going to be subject to cross-examination and everything else. Mr. Cat, just have a seat.
Yes, sir.
All right, you call your next case.
The only other one I have is with Mr. Solomon. We're waiting for him to get back from sentencing.
Which one is that?
Foster.
What are we doing on Foster? What is that?
Well, I understand, but Mr. Sullivan was hopeful he would be here.
Florida versus Michael Anthony Foster, 25 CF 3217. We're here today on the Mr. Foster's motion to suppress. Doc, you ready to proceed? Mr. Sullivan, you ready to proceed? You concede that you have the burden?
Call Officer Casey.
Yes. Tyler Casey.
Where are you employed?
Panama City.
How long have you been with Panama City?
It'll be 4 years this year.
And you are a canine officer?
Yes.
Your canine is Molly?
Yes.
How long have you been an officer with Molly?
I got her in September.
September 2025?
Yes.
What type of training do you have to go through in order to become a canine officer?
We did a 6-week training with the canine trainer.
And is Molly certified?
Yeah, we were certified through NNDDA.
What is that?
It's the National Narcotic Detection Dog Association.
As part of your canine handler duties, do you have to like undergo regular training with Molly?
Yes.
How often do you do that?
We're required to do 16 hours a month of training, but we go above and beyond that usually.
Can you estimate about how much time you spend with Molly on training?
Every time I'm on shift, we do at least an hour of obedience, and then past that, we'll do about an hour of narcotic training, and then she's also certified in bite work, so we do that as well.
What drugs are Molly trained to detect?
She's trained on fentanyl, methamphetamine, heroin, crack, and cocaine.
I want to talk a little bit about Molly's process of locating drugs. I guess we'll do it this way. Were you asked to conduct a sniff with Molly on the vehicle that Mr. Foster was in?
Yes.
And that was in October of 2025?
Yes.
Could you walk the court through your process with Molly and why you do what you do when you arrive on scene?
Yes. So when I get there, ask the officer basically what they've got, what we're doing. And they usually just tell me, hey, we just need a free air sniff. So I will take the dog out, go to the, I always start in the same spot, the driver's side front area bumper, and we go around the vehicle. And then if she shows any behavior changes or anything like that, or hasn't shown an alert, we do another pass around.
Okay. So I want to distinguish between behavior changes and alert. For you, are those two different things?
Yes.
Okay. What do you mean by alert?
So an alert, a final alert would be her sitting at an odor.
And what is Molly trained to, I guess, alert on?
Those 5 narcotics that I listed
That was
earlier.
a poor question. I mean,
Okay.
so you distinguish between behavior changes and alert.
Yes.
At what point does Molly get where she gives an alert?
She's been trained to perform the task, and then if she finds an odor, she will alert,
Okay.
or she is trained to alert.
Okay. And what is her alert?
To sit.
In this particular case, did Molly give you that indication by sitting?
No.
Now, let's talk about behavior changes.
Mhm.
What are you looking for as far as behavior changes go?
Once I give her the command to search, I will watch her and look for her to close her mouth to sniff deeply. I'll look for her to have a head snap, which is where she basically almost turns back around with her head. Look for pauses as we're walking around the vehicle. Any behavior change that's not normal from what we've trained.
Okay. And were there behavior changes in this particular case?
Yes.
What behavior changes did you observe, and where did they occur in your process of walking her around?
All of the behavior changes occurred at the driver's side door.
Okay.
She had a head snap as we passed it the first time. She closed her mouth and took quick, heavy sniffs. When we came back the second time, she stayed in the odor, so she stayed right there. She never sat, but she would not keep moving the car, even if I was moving.
Okay. And what did that tell you as her handler?
She's in an odor of a narcotic odor she's trained on.
Okay. How do you reconcile that with the fact that she didn't give a final alert?
It would be all the behavior changes, not just one or altogether. The totality of them would be an alert to a handler.
And is that what you observed in this particular case?
Yes.
And based on that, was the vehicle ultimately searched?
Yes.
I've got no further questions, John.
Well,
Just to be clear, Officer Casey, during the arrest on 10/10, K9 Molly never sat.
Correct.
And I noticed that you said that you got her September 2025. When was she actually certified?
She was certified in narcotics in September. I don't know the exact date.
So within a month, you get her and she's certified.
Yeah, we certified within the first week, and then we certified the rest of it about 4 weeks later.
Okay. So this incident took place less than a month after she was certified.
Correct.
Was she on or off the leash when you were doing this?
On leash.
She was on the leash, and she's trained to be on the leash. She's certified for on the leash?
Yes.
Okay. I have here some of your training reports. Looks like you did ones on the 4th, the 8th, the 17th, the 9th of September, the 23rd of September, all the way up until a few days before. Do you remember doing these reports?
Yes.
Okay. And these are for the training of Molly, correct?
Correct.
Do you remember making a report where on September 4th, you stated that Molly was investigating the desk, she sniffed the top and indicated there was an odor?
If I wrote it, then, but I don't remember it exactly.
And then you would say when she found the source, she alerted by sitting.
Correct.
Okay. So she's rewarded for alerting, correct?
Correct.
And she's not rewarded for indicating.
It depends on the training we're doing. Sometimes we reward her for the behavior changes.
You didn't reward her changing in behavior on September 4th, right?
If that's what the report says.
But you did reward her for sitting, correct?
Correct.
We'll have you back at 1:30, okay? Go ahead. I'm sorry, Mr. Ballard.
So that was September 4th. You did not reward her for indicating, but you did for sitting, correct?
Correct.
On September 8th, you noted that during your training on the 8th at 5:30, I'll skip to the relevant portion. Molly had her head snapped back, indicating an interest in an odor, and there was no reward for that, correct?
Correct.
And then later, she began inspecting that area by taking quick, heavy sniffs. When she found the source, she alerted by sitting and was rewarded, correct?
Correct.
And then you note in that report that she alerted by sitting, and was rewarded every time, correct?
Correct.
On September 9th, the next day in the morning, you were searching for fentanyl and not give a final alert, but then she was corrected. And when she sat, she was rewarded. Do you remember giving that report?
Correct.
On the 17th, you noted 1, 2, 3, 4, 5, 6 times that she alerted and she was rewarded. You remember those?
Yes.
Okay. And at no point was she ever rewarded on that day for indicating.
All of the indications had behavior changes associated with them.
Right. But it goes in your training, it goes indicators that lead to an alert, correct?
Correct.
On the 18th, you had similar findings where there was indications without rewards, and then when she was alerted by sitting, she was rewarded. Do you remember that?
Yes.
In the same day, later on that day, you made reports that sitting was a final alert. Do you remember that in rewarding her?
Yes.
In it, other points you make references to final alerts being when she sits, correct?
Correct.
At no point is a final alert or an alert in general characterized as doing the behavioral changes, correct?
In my reports, yes.
On the 19th, you made a note in your training report that You conducted a simulated traffic stop. She sniffed every scene in the car, but would not give a final alert by sitting. You then directed her to sniff where you, she did, that's when she sat and was rewarded.
Correct.
So she was not rewarded just for going around the car, sniffing every scene in the car. She's only rewarded when she gives an alert or a final alert for sitting.
Correct.
Again, on September 23rd, you indicated that Molly indicated an odor. She was never rewarded, but then later when she found the source, she was alerted, she alerted by sitting. And then later in that report, you say that on 3 blank vehicles, she never alerted or showed any changes in behavior, changes indicating an odor. Do you remember giving that report?
Yes.
So what specifically did Molly do on 10/10/25 that would lead you to believe that she was alerting to the vehicle?
As I stated before, she had a head snap. She closed her mouth and took quick, heavy sniffs at the driver's side door. And then as we came back the last time, she stayed in the spot and would not move.
And based on the testimony in reference to your training reports, she was never rewarded for any of those actions during the training while she was in your care, correct?
She was rewarded at the alert, but she had all those indicators leading up to the alert and was rewarded for all of that.
Correct. But I'm asking, at no point in any of her training was she ever rewarded for head snapping, closing her mouth, or staying in a place for too
She
long?
was rewarded for that, as well as the sit.
On what day did that happen? I just ran through.
You ran through all of
them.
them, and she was rewarded at the sit, but she was rewarded for all the indicators leading up to the sit.
There was also times when she would not, and you didn't reward her.
Correct, because we're training at a known source.
Should Molly behave as she's trained to do in the field, or does she have free will to do anything she wants in the field?
She should behave as she's trained, yes.
Is it your belief that sitting provides probable cause to then search the car? An alert provides probable cause?
Yes.
Any further questions?
Yes, I know this is gonna sound like a stupid question, but when you run your dog can't just speak up and tell you, hey, I smell drugs, can it?
Correct.
So when you do your training, you're training the dog in a way to communicate to you that it smells drugs.
Yes.
Correct? But as a canine handler, you're able to watch and observe these behavior changes that also indicate, short of that communication, that the dog smells drugs.
Yes.
And in this particular case, drugs were also found in the vehicle based off of the search that was conducted.
Correct. 110 grams.
So the dog's senses in this particular case were accurate.
Yes.
Your observation of the dog's behavior changes were accurate.
Yes.
Have you taken your dog and run the dog before and not noticed any of these behavior changes?
Yes.
No further questions, John.
Any other questions?
Are you a dog whisperer?
No.
Anything else, Ms. Witness?
No, Your Honor.
You be excused.
Yes, Your Honor.
Or you may go about your day. Any other witnesses?
No, Your Honor.
Any argument?
Yes, Your Honor. The fact that he's not a dog whisperer is exactly why he watches and observes the behavior changes. I'd also, just as far as argument goes, Judge, this is the exact same issue that Mr. Valak asked you to reconsider in the Maurice Bennett case yesterday. So as far as the case law goes, Your Honor's already done the research, knows the law. I would ask that you just essentially repurpose that order because it's the exact same situation as this case.
Anything else?
Yes, Your Honor, I would contend that it is the exact same situation. And in your analysis, you note that, I believe it was the Prada argument, that you explained that there are indicators that lead to an alert. Or no, there's alerts that lead to an indicator that it indicates where the presence of the narcotics are found. However, in the training logs, it does the reverse logic. It says that it needs indicators to get to the alert. At no point in the training logs is he ever rewarded for changes in behaviors. He was never rewarded for a head snap. He was never rewarded for a closed mouth or staying for too long. The question is, did the canine alert the officer? And if he did alert it, that provides probable cause. It's our contention that an alert is a term of art. It's not alerting, alerted. It's not an interchangeable word. The officer only gets probable cause when the dog comes out and alerts the officers to the presence of narcotics potentially being in the vehicle. I agree that the state's trying to use the dog whisperer argument against me, but how do we know what the dog is trying to convey if it doesn't do what it was trained to do? The officer Casey handled the canine around the vehicle multiple times and had every opportunity to provide the officer with probable cause by sitting, and it never did that. It's undisputed that Molly never sat. If the dog doesn't sit, then the dog does not objectively alert the officer to the presence of narcotics. The Prada argument is that the dog is always alerting. It's alerting by changing behavior and that it indicates the presence of narcotics. But the training logs say the opposite. It says that it indicates a potential odor of narcotics through changes in behavior, but it never alerts until it sits. So unless the dog sat, it never provided the probable cause.
Very good. All right, I'll take it under advisement. Where are we at as far as the case?
Remember, we could put the training logs in the vault list.
What?
The vault list.
In the evidence? Any objection? They'll be marked as defendant's exhibit number 1.
Question for the where we're at posturally in the case. I believe we've already done depositions. We'd asked if you did find a motion, and then we discussed entering a plea. And
When I said March 26th, is that our motion? That's our pretrial at 9 o'clock. No, the motion. I have a water hot.
thank you.
All right, thank y'all. All right. That's all we've got this morning. We've got just Alistair, we got a couple this afternoon. Is Mr. Overstreet gonna be here or somebody covering for him? All right.
Thank you.
Yes, sir. Have a good weekend.
Every day in the USA, people find themselves in court.
Thank you. Court calls the case, people versus Kyler Johnson versus Amadalen Bailey.
Ready, Your Honor. Dawn Van Dusen, P69647 on behalf of plaintiff.
Judge Dominic Camden, P67745, appearing on behalf of the defendant, Amanda Lynn Bailey. Judge, my client is also in the Zoom room.
Oh, there she is. All right, where are we on this case, folks?
Your Honor, this matter that it's regarding a trailer park, a mobile home in that park. My client, which is Kyler Johnson, owns the trailer in the park. Miss Bailey is his ex-girlfriend who is occupying it at this time. At this time, they did do a purchase agreement at one point, but I think I don't know where they got their purchase agreement, but Mr. Johnson would like to, already told her that he was going to rescind it. He does not live there at this time, but he would like the occupancy to happen. He has a loan payment on this trailer each month that has it was agreed that she'd split half of it. She still hasn't made any of that. She failed to make payments October all the way to February on just that loan, which is her portion would be 500 of it. But with them not being together, it's a total of 1,000. The rent there on the lot,
Because they're not together, her payment went up.
well, they agreed they would split it at one point, but she hasn't made any of it. So we're not even asking for a judgment in this matter. We just want, as in a money judgment, we'd just like Miss Bailey to move out of the home, out of the trailer. She's changed the utilities into his name, into her own name. She has, so he cannot even get access to make sure payments are made. So she's actually only made payments starting in January for the utilities. So we're asking at this time that eviction of a 10-day order be granted to order her out of the premises.
Mr. Hamden.
Judge, the parties are subject to a purchase agreement. I don't believe you can just unilaterally rescind an agreement. I don't believe the purchase agreement provides for that. And my client is still wishing and desiring to go forward with that purchase. Second of all, my client is on the written lease agreement with the park. And so she has the right to occupy this space as the landlord to the property. So this is probably better characterized, Judge, as some form of a replevin case, as opposed to an eviction in order to retain his property back. It's not properly characterized as an eviction. It's probably better characterized as some form of a replevin.
Well, but I don't. Is the purchase agreement still in effect?
It did not have a termination date, Judge.
Your Honor, it also says the initial payment is non-refundable. It looks like she received this piece of purchase agreement, a copy of it, and that she filled it out. And it was part of the parks where if they were going to sell you one of their trailers. I mean, there was no down payment. There's no initial payment that it discusses is non-refundable unless the applicants are denied their credit and background check. Your Honor, this is not a normal purchase agreement, and it has no closing date, no nothing on it. My client has rescinded 2 days after he signed it and said he does not want to sell it to her.
And again, my comment on that, Your Honor, would be that my client was prepared to close on it, had coordinated with a lender in order to do so, and he refused to go forward with the closing, and there is no provision in there which allows him to unilaterally rescind it. I think it's also worth noting, Judge, that the parties, and I'm sure Your Honor has put 1 and 2 together, at one point in time dated each other, and one of them was required to leave the premises because of a police report. And so what this appears to be is
oh dear God. Is that true?
Your Honor,
hold on a second. No, I just need a very clear answer because this court has a very clear policy on that. And I'm just going to say, because usually it's the male that's doing this. Is there a domestic violence complaint that was made?
Yes, Your Honor, it was made on October 23rd.
And he was then required to leave the premises?
Correct.
I am not.
And Your Honor, there's no charges pending against my client. In fact, the charges were dismissed by Miss Bailey 2 days later after she made the complaint.
Okay. How long were they living together?
That would be something that my client would have to answer, Your Honor.
Judge,
Miss Bailey, how long?
Living together 1 year.
Okay. All right.
Your Honor, I wanted to add something. I just wanted to say that the reason why of wanting to go back on the purchase agreement was because initially I had signed the purchase agreement, and the next day she was trying to falsely accuse me of, and call the cops on me for stuff that wasn't done and just falsely accuse me. So that was
So
why
you
I
got
wanted to
mad
go.
and said, I'm rescinding the purchase agreement, blah, 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 blah. I hear it all. All right. So what do you guys want me to do? I am not issuing a judgment, not today. And I'm assuming, Mr. Hamden, you want to file a written answer to this.
I do, Your Honor, and I think it would be helpful if the court actually saw the purchase agreement, as well as the lease
Well,
agreement.
somebody attach it, because if the
I'll-
purchase agreement's there, but there's also another signed document between the parties, correct?
There's a purchase agreement that was signed between the parties, Judge. The other agreement was signed with the park landlord, to which my client is a tenant, as well as Mr. Johnson. They are both tenants from the park landlord standpoint. I will attach both of those to my written answer.
Yeah, that was going to be my next question. So under what theory is the plaintiff terminating the tenancy?
Eviction, he owns the mobile home that she is living in at this time. He owns the mobile home. He actually has a mobile home mortgage that he has to pay every month. On top of that, then they rent the property the mobile home is on. So the only thing they have a lease for is the property that the mobile home is on with that park. So all he has to do, and which he has already started doing, and is he has to go in and get her off the lease, which means he just has to do
if I went to a family court and deal with a divorce, that's not really a divorce, I would have done that. I don't know why I'm even dealing with this mess.
Because it's an eviction, Your Honor.
I don't know that it's a proper eviction, because I've got a purchase agreement for property that one is saying I got mad and I just rescinded it after I signed it. The other party is saying, well, I'm sitting in here and he's gonna,
Yeah, the terms of this purchase agreement haven't even been fulfilled by her. She's already, at the beginning, she was supposed to give him initial payment, and that has never been done. So the terms of this purchase agreement are so
but your
vague.
client just said that's not the reason why he wants to rescind it. He wants to rescind it because he got mad because she was saying things. He just said that to me.
Yeah, she has not even made in good faith an attempt to go try to finance this trailer.
My client had it financed, Your Honor, and was prepared to close. And I'm looking at the purchase agreement, and I could be wrong, and I don't want to be held out.
You can keep talking. I don't really care. I don't really care, because if there's a purchase agreement, you're saying that she's not doing whatever. And okay, fine. But your client just told me that's not the reason why he rescinded. I mean, counsel, I'm just going to let you know, because if there was a domestic violence accusation, this court has been very consistent with its votes. With a police report filed, whether it's carried through or not, the court is going to be very reluctant to evict someone who may have been a victim of domestic violence.
I understand.
And I'm getting the sense that that's the reason why the purchase agreement didn't go forth. That's the reason why everything is now being sort of couched as this eviction and this is my property.
But Your Honor, this could also be a reason how she gets him out of the home. She knows if she calls the police, makes false allegations, that he has to leave the premises. There's a reason it got dismissed 2 days later.
Well, you said she did it.
Well, she did. She went and, she made the allegations to get him out of the house. When he said, well, I'm not going to sell you this property anymore, then she says, I'm going to go dismiss the charges.
Mr. Hampton, how long do you need to answer?
Monday, Judge?
Pardon?
Monday. I'll get it going over the weekend. I actually had intended to get it going earlier this week, but
well,
my judicial secretary called in sick and everything was fine. I had no problems whatsoever, but I didn't get it done. So.
All right. Defendant to file an answer by, well, I'm going to give you a week to get an answer in. You're to file an answer by February 27th, 2026. And then I'll set this for an additional hearing. The way this is out, there's no reason for me to set this on a Friday. Give me a Tuesday that I can hear this.
The first Tuesday would be March 3rd.
March 3rd. I'll set this for, I'll call it a settlement conference. I don't know that that's going to happen. March 3rd, 2026 at 9 a.m. All parties are required to be present in person, including attorneys.
Thank you, Jan.
Thank you.
Thank you, Judge.
Pierce Lake Village Association versus tenant. Don't know what that means. Well, tenant, and then there's James Heaton Trust and Ellen Green Living Trust. Oh boy. Go ahead, state your names, please.
Good afternoon, Your Honor. Livia Camoro appearing on behalf of Pierce Lake Village, P85454.
Good afternoon, Your Honor. Travis Gagne, appearing on behalf of defendants. I am co-counsel, though my formal appearance has not appeared, with my co-counsel, Angela Jackson.
Got it. Okay. And this is a termination. Dare I ask, where are we on this?
So my understanding is the initial hearing was on February 13th. My colleague appeared at that. None of the defendants had appeared. Last week we were scheduled to reappear, and Angela and I stipulated to adjourn it 1 week. So this should be the first hearing on the eviction matter.
Well, there was an initial hearing on the 6th. And then the 13th, I'm not sure what happened. I didn't have a docket the 13th, did I? No, I did have a docket the 13th, and you stipulated to adjourn it.
Oh, yes.
And that's why we're here today. You're a week off, but I got you. All right. So now where are we on this whole case?
Well, I wasn't aware. Are you representing all defendants now?
I'm going to be representing all defendants, although I will note for the record that Ellen Green Living Trust is not an owner of the property, so an improper defendant in this case. James E. Heaton Trust owns the property, and then there is a tenant living at the property. So at least as to Ellen Green Living Trust, that should not be a defendant in the case.
Your Honor, I believe on the deed, and let me see which exhibit this would be. Yes, if we look at exhibit 1 attached to our complaint, it names it names that it was conveyed and warranted to Ellen Green Trust, which is why we named her.
Whose interest was conveyed?
James E. Heaton Trust was conveyed to the Green Trust and James E. Heaton Trust. So our understanding based on this deed, Your Honor, was that both of the trusts own the property and therefore would be responsible for the money judgment that we are requesting.
My understanding is that, again, this is a tenancy deed. My understanding is that there is not a financial interest from the other trust. I'm happy to file a formal motion, though, as it comes to striking a defendant and attach proofs and evidence in regards to that.
All right. So I'm not, I guess as we sit here right now, I'm not sure that I have the party straight. Because you're claiming that the Green Living Trust is a proper party, you're saying that it's not.
I am saying that it's not a proper party, but I'm appearing on behalf of all of the named defendants at the moment, so.
Okay.
I am here and everyone is represented.
All right, but we've got to figure that all out.
Yes.
All right, how would you guys like to proceed forward?
I mean, you've seen the complaint here to recovery. My understanding is that there are two complaints that they have. Again, plaintiff here is the HOA. They are not actually the property owner. They are moving for an eviction, but not necessarily possession of the property, since they are not entitled to possession. The owner here, as it goes to damages, the James E. Heaton Trust, they are trying to evict the tenant. The items complained about are.
Have they requested that the trust evict the tenant?
Your Honor, under the Michigan Condominium Act, specifically MCL 559.212, Section 4, the condominium association has a right to move for eviction if the tenant is.
It may surprise you, I know the law. I asked a question as to whether or not they had asked the owner of the premises to evict the tenant.
Not directly, Your Honor, but they received the bylaw violation letter, which gives them 15 days to cure, and that has not been.
Okay.
Your Honor,
So that's a no?
I'm going to say that's a no, Your Honor. They have not requested eviction. They have stated that there's a damage to the outside door fixed at owner's cost, and they have said that there are multiple noise violations and that they should cure the noise violations. Our position is that the noise violations have been cured. They have not produced any police report that since this time of saying that things should be cured, or their notice to quit, that there have been any additional police reports. And I will note that in the police reports, the police did not actually find any evidence of there being noise violations. They noted that they didn't hear any noise. And there's a declination to prosecute that's in the file that was filed by plaintiff in this case. There's been no, I mean, the complaint frames it as saying there hasn't been a cure because the tenant is still there. There's been no request to evict the tenant. I don't think there's a basis to evict the tenant. And so our position here is that there is not costs owed. There's not a request for a common element to be fixed or anything like that. And there's no, there's no further noise violations. So I think it should be dismissed.
Your Honor, we respectfully disagree. Under the bylaws, there's a specific requirement that there's no noisy activity. And there have been numerous calls to the police department evidencing, and we will bring witnesses at the subsequent hearing, but I wasn't aware that the defendant that counsel was representing all of the defendants. In fact, in my communications with Ms. Jackson last Friday, she advised that she did not know whether she would be representing all of the defendants or not, and therefore hadn't contacted me since, nor filed an appearance on behalf of all defendants as of today's date. But we will bring witnesses to testify regarding the noise at the subsequent hearing.
And Your Honor, just to
but is that going to be the basis for determination?
Yes, Your Honor, and that is appropriate under the condominium documents.
But has the noise, these people are going to come forth, say my neighbors are noisy. I'm hearing this noise. Has that been cured?
No, Your Honor, and in fact, it's loud screaming and pounding on the walls. It's not just, some loud music or something of that nature. And this happens throughout the day. And this is a problem that has disrupted the neighboring home.
This is why normally in these cases, counsel, I realize what the Condominium Act indicates, that usually the owner of the premises is contacted, asked to correct the tenant's behavior and or evict. When they refuse or don't do so, then the homeowners association acts.
Your Honor, they received the same bylaw violation letter, which provides them the opportunity to.
All right, I know you told me this.
Correct.
I do hear, I understand, but okay. I guess we're just gonna go down this road. All right, yeah, go ahead.
To contextualize the tenant who is currently there is a relative of the owner, the trustee of the trust. There was the word that I'm looking for. I don't think that it is necessarily contested that the tenant has dealt with some mental health issues of which the family is trying to provide him services for. To the extent that they are sending cure letters to the owner to correct noise violations. Again, the curage here is any damage that has been reported, which is again just some exterior damage to the door will fix at owner's cost. Noise violations are being addressed for the procurement of treatment. I think what's being asked here is an HOA to throw out somebody with a known mental health issue onto the street because they don't like their neighbor. And frankly, we're ready to contest that.
I don't think I have an answer from you guys yet, right? How long?
No, if you, frankly, I could get it by the end of today, but if you would give me till Monday, I'm happy to file the formal.
Defendants to file answer. I'm going to make it by February 27th, 2026. And then you get that, I guess I'll reset this to the 6th. We have, correct?
You have the 6th, yeah.
Then I'll adjourn this out pending that answer to March 6th, 2026 at 2 p.m.
You're in person with you, Your Honor, correct?
Pardon?
You're in person with you?
Yes. So everybody can see how my joyous day goes. Yes. All right. Thank you.
Thank you, Your Honor.
Court does call the case of Clara Ganon versus Holly Ellison.
Good afternoon, Your Honor. This is Ike Start, student attorney at the University of Michigan, and I'm requesting to appear on behalf of Ms. Ellison, pursuant to Michigan Court Rule 8.120 under the supervision of Attorney David Santacruz.
Permission to practice is granted.
Thank you.
No?
No, she is unrepresented. She is not present. This is defendant's motion.
Yes, this is defendant's motion. But I don't have the plaintiff. So what do you want to do?
If you want to hear the motion, Your Honor, I'm willing to argue it.
I'll hear the motion, but what would you like the court to do? I don't have the other side here.
Yeah, we could go forward with the motion.
All right, go ahead.
So, Your Honor, this case was supposed to be resolved by conditional order of dismissal, which was entered by this court on November 21, 2025, and the relevant terms of that the conditional order of dismissal was that my client, Ms. Ellison, was to vacate the property by the end of the year and also facilitates funding for Ms. Gannon. And then in return, Ms. Gannon was supposed to return Ms. Ellison's security deposit within 30 days of vacating the premises as required by law. So Ms. Ellison vacated the property. That's my client vacated the property on December 5th, 2025. And that 30-day period for plaintiff to return the security deposit was ended on January 4, 2026. And we had not received the security deposit by that date. So this motion, we have two claims in this motion. First is that plaintiff violated the conditional order of dismissal. And we had not received the security deposit at the time of filing, but since we have received that security deposit after filing, and so the remedy for the breach of the conditional order was simply to get the amount of the security deposit, which we now have. That being said, we have a second claim, which is that plaintiff violated the Security Deposit Act. MCL 5546132 states that the failure of the landlord to return the tenant's security deposit within 30 days of termination of occupancy makes
Did your client supply Did your client supply notice?
Oh, yes, Your Honor. Yes.
A forwarding address?
Yes, Your Honor. She supplied her forwarding address on the day that she moved out via email. And that, I believe that's attached as an exhibit on the motion if you'd like to see that email.
Wouldn't all of the provisions of the Security Deposit Act haven't been waived if you are placing it in the confines of a conditional order of dismissal?
No, Your Honor, the conditional order of dismissal in no way waived the statutory obligations that would make the plaintiff.
Does it say that in the conditional order of dismissal?
Let me take a look. That's also attached as Exhibit A. Let's see. It certainly gives action to reopen the case and to reinstate the case and for the court to issue a judgment if the terms of this order were not complied with. So I would argue that the conditional order in no way waived. And I would say it's pretty clear from the text that it did not waive the statutory obligations of plaintiff. So continuing on, the under MCL 554613, plaintiff is liable to my client, Ms. Ellison, for double the amount of her security deposit retained. And Ms. Ellison,
when was the security deposit returned?
It was after the date of the filing, and this was filed on January 29, 2026. So I think it was shortly thereafter. So end of January, maybe early February. But in the meantime, my client was threatened by her new landlord because she didn't have the money to pay for rent. She was relying on the security deposit to be returned, and so this caused great hardship to her, a fallout with her new landlord, and potential more litigation. And she was very anxious about being homeless.
Was there more litigation that ensued?
No, Your Honor.
It was just her worry that she would be sued.
That's correct, and Miss Ellison contends that she relied on the fact that Miss Gannon would comply with the law and return her security deposit. So when she moved to the new address, she told her landlord that I'll have the money by January at the latest, January 4, and then January turned into February. And the landlord, in my understanding, was days away from initiating litigation, and my client was anxious about being homeless again, her and her son. And this was all because Ms. Gannon failed to abide by the law. And so Ms. Ellison contends that she is entitled under the statute, and that's the statute. The purpose of the statute is to protect against this exact thing, which is that a tenant would rely on the word of the landlord, but and then the landlord not following through. And I would just say one more thing is that counsel or myself tried to reach out to Ms. Gannon many times. When it came to our part, our obligations under the conditional order of dismissal, Ms. Gannon was very, very willing to communicate, always answering our calls and emails. But as soon as she got her money and my client moved out of the apartment, it was radio silence from Ms. Gannon. I emailed her, I called her, I left her voicemails with nothing in response for over a month. And that caused great hardship to my client. And so my client, Ms. Ellison, requests that this court reopens the case because it was previously closed under the conditional order of dismissal, and then award.
But why wouldn't I consider all of the provisions or the provisions of the Security Deposit Act were, because you'd almost have to reserve that, wouldn't you? Because everything in this conditional order dismissal circumvents the Security Deposit Act.
No, I don't think so, Your Honor. I think
Well, I know you don't think so, but wouldn't you have to reserve it?
Well,
I mean, give me a reason why you wouldn't have to reserve your rights under the Security Deposit Act. Because you're altering it. You're altering that statute in the confines of this order. For example, it's 4 days and you limited it to 3 days for the time period at which to do that. There's no provision that's laid out. I mean, and also you're saying that she's agreeing just to return the security deposit. Just return the security deposit. All of the provisions that would apply within the Security Deposit Act as to what the landlord could do have been altered.
So, Your Honor, if I may jump in for 1 second here.
No, he's doing just fine losing this by himself. Go ahead.
So I would say that normal practice is if you've got a COD that could take more than 50 whatever days it is to be paid out on, that you have to explicitly waive the law. But without an explicit waiver, it obtains. So that was our approach.
But you changed what's in the statute. It's usually a 4-day period, right, to receive forwarding address.
Well, we just did it faster, but yeah.
But you've altered the statute.
But
by the 3 days. You've also altered the rights of the landlord to do anything, because even as I read the terms of this, irrespective of whether or not there's damage, irrespective of anything, the security deposit is coming back. That's not the way the statute reads. You've altered the statute, but now you want to enforce the remedy provision that's contained in the statute.
I'm sorry, you're breaking up a little bit, but I don't read the conditional order of dismissal to really do anything other than to benefit the plaintiff. So, and I mean, the law is the law, and if we gave more grace.
No, the law is the law, and the law says that if she gives that notice, that if the landlord has damages, the landlord can do something. The landlord, with regard to that security deposit, the landlord with this conditional dismissal can do nothing but return that security deposit. You've altered the statute and the remedies provided to each party under the statute, but now want to enforce the other remedy provision within the statute. I don't think that's how it works. If what you wanted is to say that given everything we've done here, that if you don't return it within 30 days, that she'd be entitled to double the amount, then it should have been said, but it's not said.
Understood, Your Honor. I mean, my client left in a timely manner. I mean, the fact if this might be a different case, if my client left the place a mess and and there was
but it wouldn't matter. But it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing, but regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisions. You can keep shaking your head, but tell me where I'm wrong.
Well, I don't think that this conditional order of dismissal would force her to return the security deposit even if there was damages. I don't think this conditional order dismissal supersedes the law. That's my contention.
Hold on a second, counsel. How do you read that? Look at your paragraph 7. If the defendant vacates the lease premises timely under the terms of this order, plaintiff shall return the defendant's security deposit in the amount of to defendant's checking account or send it via email by forwarding to the address within 30 days of the date that it vacates. Tell me how what you're proposing could even happen.
Well, under the statute, Your Honor, again, I don't think that the wording that we use in this conditional order supersedes the law written by the legislature. This was just an agreement to get this case settled. I don't.
Yes, you have, because you already altered it with the 3 days versus 4 days. You already altered it, making it mandatory to return it irrespective of anything else. There's no exception here. There's nothing. There's no exception that if gas, utilities, or anything else is owed, may not have been in this case, but there's no exception in here that if something else is owed, they could take it out of the security deposit. This security deposit was coming back regardless. And the rest of the rights, this court would rule as to what would pertain under that security deposit were not retained or preserved or reserved. And so therefore, your motion to do that, I don't think is equitable and fair under the circumstances, and the court does not believe that that is the intent of the order that I signed. And so therefore, your request for relief is denied.
All right. Thank you, Your Honor.
Thank you. That's all I had on it.
Yes.
Right now. HP foreclosure solutions versus all occupant.
Good afternoon to you and your staff, Judge Simpson. Attorney Paul Spaniello, P72366 on behalf of the plaintiff.
Any occupants?
I'm here. I'm sorry. I'm trying to unmute sorry. Mary Cheatham.
Okay, gotcha.
Okay.
All right, this is a termination. This is a motion.
This is Cheatham's motion to set aside a default, Judge, for what it's worth.
Did you get a copy of it, counsel?
I had to ask the court clerk, and they were gracious enough to email me a copy. Yes, I did.
All right, very good.
Thank you for asking.
Ma'am, what is your position on why I should set aside this termination?
I did not see the court document to come to what am I saying? Okay, so I did not receive in the mail the court date until like 3 days after the court date.
Okay, let me explain a couple things.
Okay.
There are two parts to that you would have to show this court.
Okay.
For the court to set this aside.
Okay.
All right. The first part of it being that you'd have to show good cause for your failure to appear, which I think you were going to get into. Okay. What I think is more problematic, I think, for you is you have to show this court that there's a meritorious defense to the claim of the termination.
Okay. So I had entered into a lease with them. There was some problems with the payment. I think I addressed that in my motion. I have been in contact a little bit with, I believe her name is Michelle from HP. And I believe that we could possibly come to an agreement to allow me to just extend my stay a little bit so that I can get everything out of here. I guess.
Who did you lease from?
HP foreclosures.
Is that right, counsel?
Your Honor, during the course of the suit, and I do have Ms. Shifter here if you'd like to take testimony, but Ms. Shifter attempted to work out a resolution with Ms. Cheatham to keep her in the property. There was an agreement that if a security deposit was tendered in first month's rent, that they would have this binding lease and that we would ultimately dismiss the case. As you'll see in Ms. Cheatham's unsworn narrative, I guess her money, her husband or spouse absconded with the money, so nothing came of it. My client had attempted to reach out to her on multiple occasions and was largely ignored, and we proceeded. So, effectively, there is no lease, albeit, we tried to work something out with her, but this if I can finish.
Sorry.
This case was filed on December 9th. The redemption, I don't have it in front of me, expired late last year. And now we're here on February 20th, Your Honor. And there's still been no monies produced. So it's our opinion that there is no lease agreement. I mean, my client would not enter into a lease without that.
But I guess, was there signed documents of a
Yes.
lease?
It's my understanding my client did sign the lease, but predicated that the effectiveness of the lease on that payment.
Okay, so I don't have a copy of the lease.
Well, it wasn't a part of this action. It was something that occurred, my understanding, during the course of this matter. When I appeared at the first hearing, I was hopeful, and I even may have put it on the record that the parties.
Well, counsel, here's the problem with that argument. Under paragraph 5F, this action was maintained because of the expiration of the redemption period, but then specifically indicates no tenancy.
Correct, and there was none at the time that the matter was filed, Judge. Yeah, I'm sure Ms. Cheatham will tell you, and my client representative will tell you, that after this was filed, they were trying to work out a resolution to keep Ms. Cheatham in the.
But then we get into the other issue. So you're saying this signed document, this lease, was entered into after this case was filed?
That's my understanding, yes, Judge.
Ma'am, is that correct, Ms. Cheatham?
Yes, if they filed it on December 9th, because I don't,
When did you sign the lease?
I did, sir. I did, Your Honor.
No,
and I am
when?
prepared. Oh, when? It was in January. I don't know the exact date. Might have been like the 9th or something. I'm not quite sure. But I am prepared to, I have the money to pay them at least the $3,800 today.
Hold on,
Okay.
hold on, stop.
Okay. Okay.
So after this action, both parties signed a document purporting to be a lease. I don't know how there is a conditional lease, but I guess that's what counsel is saying. And Ms. Cheatham is saying that there's a lease. I don't think, counsel, you can argue that there's no lease if both parties sign this document. I don't know how that works.
Well, if I may, just for purpose of nothing else, Your Honor, making a record, there's no consideration. I mean, my client could sign a lease, and if it's predicated, it's our position, it's predicated on payment, like most leases are. And if no security deposit was tendered, no first month, effectively, there's no lease.
No, that's not how tenancy works. I mean, if she's in the premises, you're in the premises, ma'am?
I am, Your Honor.
She'd been in the premises during the whole redemption period, my
I
understanding.
have not. I was in a halfway house. I just got released on January 30th.
Well, we were here before your January 3rd. We were here on January 9th, Your Honor. It was the first hearing, I believe.
Because I'm the executor of the will, so I've been like appearing for court hearings and things like that. But I've been pretty upfront about that. Like when I first came into contact with HP Foreclosure Solutions, that I had just been released from incarceration last July, and I've been in the halfway house since.
Okay, so who's going to send me a copy of this lease or this conditional lease or this thing that one side is purporting not to be a lease, but the other side is saying it's a lease? Because I don't even know how I begin to rule on this without a copy of it.
I don't have a copy. Ms. Cheatham or my client's representative, Ms. Shifter, I could have Ms. Shifter send me a copy and I could forward it to the court via email, or Ms. Cheatham, I guess, could. I'm sorry, I don't have a copy.
If I may, I'm sending that right now.
Okay.
Michelle Shifter.
I'm sorry, Your Honor.
Let me pass this matter.
Okay, thank you. And
then
then
it needs to be sent to my staff.
may I have the staff? Can someone put the staff's email in the chat if they don't mind?
She is putting it in there now.
I appreciate it.
Court recalls HP foreclosures versus all occupants.
Paul Spaniel, Your Honor, on behalf of the plaintiff.
Mary Cheatham.
Counsel, how are you? I don't know how I get to the point of you saying when I'm looking at this, that this is not a lease. Parties have all signed this. Right?
Correct, Judge. As what was sent to me, I reviewed it in anticipation of us going back on the record. It does appear that it's signed. Other than the consideration provided by Ms. Cheatham, before you as well.
The problem I've got here is that I don't think, quite frankly, that, well, I'll just say it this way, that defendant has a valid lease. And I would submit to you that then the beginning of this case, because of that, this court doesn't have jurisdiction to hear this case. I won't have subject matter jurisdiction under the theory upon which this case has been filed. Because you filed it because of the expiration of the redemption period, but at some point a new lease entered in or new interest in property entered in, which I can see. So I don't think, there may be other reasons or a basis upon which this case could then proceed, but I can't proceed as is. I don't think the court has subject matter jurisdiction. When I don't have subject matter jurisdiction over the case, then the only thing I can do is dismiss it.
I anticipated that, Judge Simpson, and I appreciate that. Would you just be inclined to dismiss it without prejudice, and we'll send out the appropriate notices today and get the ball rolling on an appropriate matter before you.
All right, very good. So, Lexa, that dismissal is without prejudice.
And respectfully, thank you for entertaining my argument. I appreciate it.
Not a problem, sir. All
Take
right,
care,
thank
Your Honor.
you.
You and your staff have a great weekend.
You do the same. You also, Ms. Cheatham.
Thank you, Your Honor. You have a good day.
Every day in the USA, people find themselves in court.
We call the matter of Caleb Baker. Is that you?
Yes, Your Honor.
Did you stick your finger into an electric substance?
I was in a hurry. I didn't want to be late. I wasn't late.
Which I had hair on the top of my head, though. Now that you're reminding me. Okay. Earlier, the defendant entered a plea to aggravated assault, a first-degree felony. The pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
I've reviewed it, Your Honor. I don't do particular corrections.
I'm from the state judge.
This made a part of the record for all purposes. Is the complainant here, the victim here?
No, Your Honor. Nothing I'm aware of.
Well, I got a problem here. He says the defendant has a version. I've read that.
Yes.
And then contact was made with the victim who strongly objects to the defendant receiving probation.
Yes, sir.
He advised he has not been notified of the status of this case until this statement.
He was before that because we talked about it right before I made the offer. He just doesn't want him getting probation, wants him to get pen time.
Well, I mean, he says the defendant tried to kill him. He shot over 5 rounds on purpose. He tried to kill me. I mean, he's pretty sensitive about that. Meanwhile, the defendant says it was all the victim's fault.
He's not saying it's all the
You were,
victim's fault.
okay.
I disagree. He's contextual.
Let's read this together. No, let's read this here.
He's not
Defendant's
saying it's
version.
all-
I picked up my wife from work. We were coming down MLK in Franklin and there was a vehicle with its hazards on. I had my blinker on to get over to the next lane. When I started to move over, I did not see a speeding car coming and all I heard was screeching tires. After I slammed on my brakes, the victim pulled up next to my car and started screaming and yelling at my wife, kids, and me. The victim stated, "You are lucky you have those kids in the car. I'll air this bitch out." We kept driving and he followed us. I saw a red laser pointing at us and I took off. The victim pointed the laser again and turned on the feeder road. I turned on the feeder as well, and that's when I pointed my gun and shot at him.
Right. He's not saying, he knows he's at fault here.
Oh, it sounds like self-defense, doesn't it to you?
But it's not deadly force. A laser.
Well, why did you?
He's not justified. He wasn't justified in what he did.
I don't understand. I don't understand this. You're trying to take sides on this, both sides.
No.
Are you the victim or not?
No.
Are you the victim or not?
He's looking at it. You're not a victim.
He wasn't at the scene. You were the one at the scene. Were you defending yourself?
What?
Yes, I was defending me and my family.
From a laser pointer?
I don't know exactly what it was, man.
Yeah. Well, he may have thought in his mind, Your Honor, but from a legal standpoint, I think for self-defense, he used deadly force. It would have to be in response to deadly force. I don't know that what the co-actor did rises to the level of unlawful use of deadly force. He would be entitled to get a jury instruction on self-defense. So he's not obviously an expert on the law of self-defense, but in his mind, he knows he was acting inappropriately when he shot at the guy.
Okay.
I mean, there's no question about that. Right, Mr. Baker?
Right. Yeah.
And if you look at his criminal history, I mean, it's not extensive. It doesn't, it's not like he has an extensive history of any kind of violent related offenses.
I've done this long enough to know to see. You got 2 different stories here, and he thinks
it's better to plead to try to get the probation versus going to a jury for a decision. Your Honor. Yes. And you can speak to the court. I think he's extremely remorseful about this. He's been away from his family for 4 months because of this stupid decision. But it's contextualized. I mean, there's context here. He's not just some maniac driving around the road shooting people. That's not what happened. I mean, it happened that he shot at somebody because there's a context to that. There's 2 people here doing things on the roads, and he's not operating in a vacuum where randomly shooting at cars.
well, he's going to shoot every time he sees a red laser pointing.
No, I think that he's learned.
Oh, that's what he's done. That's what he says. That's why he did. I saw a red laser pointing at us and I took off.
After
the victim.
I'm sorry.
What? You love to control her.
The guy threatened me.
The victim pointed the laser again and turned on the feeder road. I turned on the feeder road as well, and that's when I pointed my gun and shot him.
He had been threatened by him. It wasn't just a laser shot. There was words exchanged. He was threatened. That's actually messages and actions. Again, I don't think he was going to do this again. He's learned his lesson. But he has family with him. And he was scared and he acted inappropriately. I mean, that's what the PSI addresses there through anger management and moral recognition.
I think that
Recognition, then these things can be addressed in a remedial context versus putting him in the.
So what about the victim who strongly objects to him receiving probation? Honestly, because of the severity of the situation, all the is he tried to kill me. He shot over 5 rounds on purpose.
Well, Your Honor,
no regard for my own family or anyone else. That seems serious.
I would say that it's the state's case and the state's decision, Your Honor. Obviously, the court takes into consideration what victims express desire, but I'm united on many times when I have uncooperative victims who want to drop cases that the state reminds me that it's the state's case and not the victim's case. So that's looking at the totality of the circumstances.
It is.
Have to do with
But since one of the victims now have a board.
No.
they do, but they should.
Okay.
But this is not some pristine victim. It's not
What's state asking?
Well, I'm asking for pen time, the 6 years pen time on the 6-year cap. And I think that last sentence in the defendant's statement is what turns the whole thing. When it says he pointed the laser again, it says he turned off on a feeder road, and then the defendant turned off on a feeder road and followed him, and that's when he shot at him. Because the guy was veering off and he shouldn't have gone after him and shot him. That's what gets him pen time.
Well, do you want to address it, Mr. Hagan? What happened?
Start from.
Tell the judge, tell me.
So start from the beginning.
Yes.
So start from the beginning. I had me and my wife and my 3 kids, my 7-year-old son and my 5-year-old daughter and my 2-year-old daughter. We were coming down MLK Street. We got to the light, the hill before Franklin and MLK Street. And there was a car that was in front of us with their hazards on. And I had my left blinker on to get over in the lane next to them so I can pass them up. And I didn't see the car coming down the hill so fast. I don't know how fast he was going, but he wasn't going fast. All I heard was screeching of tires. And that's whenever I slammed on my brakes, thinking that somebody was coming through the light on Franklin. So I kept on going after I realized that nobody was on the side that was coming to hit us or whatnot. So the guy, as soon as we passed the light on Franklin and MLK, going northbound toward the north end of Beaumont, he pulled on the side of us and was yelling at me, my wife, and kids. And he was looking around in my vehicle and he seen my kids were in the vehicle. And he said, "You're lucky you got them kids in your car. I hear this, excuse my language, bitch out." Sure.
What do you think that meant?
To shoot my car, kids don't like him.
What happened?
So what did he do? What did you do when he pulled the gun out at you?
So
did you see the gun pointed at you?
I seen.
Did you see the gun pointed at you?
Not technically, no, sir.
Not technically. You know, by
yes, I mean
clairvoyance. What? But imagination.
It was in the shape of a gun. I don't know if it was an actual gun, but it had a laser on it. I don't know exactly what it was. It was shaped like a gun.
And there was a laser sight on it?
Yes.
What color?
It was red and it hit me in my left eye.
Well, then what happened then?
So when we got to Calder and MLK Street at the light, we got stopped by the light. He pulled over on the side of us again. And he was ramping and raving again. I didn't know what he was saying because I did turn my music up whenever the incident happened on MLK and Franklin, passing MLK and Franklin. And whenever the light turned green on Calder, I kept on going. And whenever we got to the light on MLK and the I-10, that's whenever I seen the laser again. and the resemblance of a gun.
Now then what happened?
So that's whenever I took the feet of road, as well as he did.
No,
Yeah.
you went after him.
Yeah.
Why?
I don't know. I mean, to be clear, like, I guess I was nervous. I was scared. I mean,
So you went after him thinking he had a firearm, you have kids in the car, and so you followed him?
I mean, I'm not necessarily.
That's exactly what you're saying.
I wasn't trying to.
You could have gone anywhere else, but you decided to follow him. You can get your your family in harm's way when you could get out of harm's way. You put them in harm's way.
You did that? I think that's where probation or mediation come in versus punishment, because he does have a wife and 3 kids that he's taking care of. He's been in jail for. He has, I think he has remorse.
Yeah, so I'm fully remorseful. You know, I don't even want to own a gun no more.
How many times did you shoot at him?
To my knowledge, 3 to 4 times.
Were you shooting at him or at his car?
At his car, I didn't necessarily aim just directly at him.
So if you're driving a car and somebody shoots at your car, they can say, I wasn't shooting at the driver, I was just shooting at his car. That's going to make you satisfied?
Also, I was scared, like I said.
With your children in the car, he was no longer a threat to you. You chased him down. I mean, right? You made a conscious decision to either go after him with the kids or turn away and get out of harm's way. If your story is true,
Yes.
but you decided to put everybody at risk. Your family that you love so much,
And I will
that you're
fully
supposed to
regret
care
that.
for them. Huh?
I regretted it every day since I've been arrested on this charge.
I would
I've been in jail.
I know the court might consider shock probation, but with an affirmative finding of deadly weapon, it's not eligible.
Here's the other thing about it. The victim says there are 5 bullets in the car, 5 bullet holes in the car. His story is still not even close. It's 3 or 4.
In a situation like that, you can lose track of how many times. I think if there's 5, then he shot 5. You confess that you shot 5 shots.
Yeah, if there's 5.
Now it's 5? Was that your final answer?
It could be 5.
It was 3
Yeah,
or 4 a
it
little
could
while
be
ago.
5, yes.
The story evolves
Well, you're
as you're standing there.
It's in the context of a shootout, people lose track of what's going on. Time compresses. I just try to.
Jeez.
Where
As though I've never been in one of those.
Gunfight in the car.
Yes, I know how that exactly works, sir. Anything else?
We're asking for probation, Your Honor. As I said, he can't get shock probation.
How much time does he get credit for?
But for the deadly weapon finding, you can be eligible for shock. He's been in jail 4 months. You could get 6 months upfront time. But I really think this person is a good candidate for probation. He has genuine remorse. I know he feels bad. He has a wife and kids that are there to support him. And in the heat of the moment, he made a bad decision. And again, you can look at his criminal history. He doesn't have any
How long have you
history.
been in jail?
Since the day before September 30th. I was booked in at 10:30 p.m. on September 29th.
How many cases?
I'm sorry.
140 days.
And how many cases do we have in there where the state comes in with write-ups from the jail where they've been disciplinary problems in jail? I mean, he hasn't, in 4 months, he hasn't got a write-up.
They seldom do.
Well, that's not been my experience lately. They get write-ups all the time.
We're gonna start keeping a score. I've been doing this longer. I'm here more than you are. I know when they produce write-up.
Well, maybe
It's not that often,
next
sir.
door that I'm dealing with write-ups and people all the time.
I
I'm
don't think
sure if he-
I don't think these people are irresponsible.
If he had gotten in trouble in jail, the court would be aware. But it would make it.
Anything Anything else by anybody? Okay. Nothing further, Chance? All right. If not, I'm going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence in the record supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt, and I find you guilty beyond a reasonable doubt of this aggravated assault with the use of a deadly weapon. The fact of the matter is that this court is going to have to has two different stories, two different versions of the events. But at the end of the day, the victim has 5 bullet rounds that you shot into his car. I don't see any on your car. You had the opportunity, with of all things, your family in the car, to turn away. You did not. You turned into harm's way. I don't know if it's rage or what it was, but you went after him and shot at him. And he's the victim in this case, Mr. Sampson, strongly objected to you receiving probation. And I see your statement here. But this last sentence, your statement gets you. He turns on the feeder road. You turned on the feeder road as well. And that's when I pointed my gun and shot at him. And anyway, yeah, you were going after him at that time. There is enough evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense of aggravated assault. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for time you have served in accordance with this case. Also, the judgment will reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. This is a tragic situation. Could have been worse. We could be dealing with children dead and others. And everybody needs to, in difficult times, need to somehow stop, think, and appreciate what kind of tragedy can occur by the next choice you make. And sometimes with ego being the way it is, people want to go after issues that they perceive as trouble. If under your situation, the trouble had left and you went and sought it out again. And that was the problem with the family. Oh, that is.
Hey, is there a possible that my wife goodbye?
It's the bailiff is in control of you now.
I love you. Love you. I'm gonna call you.
We now call 25 CR 519, the state of Texas versus Joshua Guidry. You are Mr. Guidry.
Yes, sir.
Present with Ralph Kindler, your attorney and the state's attorney. There is a first amended motion to revoke probation that has been subsequent to an original motion that was on December 9th. And then this first amended is filed January 28th. About 3 weeks ago, two to 3 weeks ago. What are we doing today?
He's gonna, if the court could go through the entire appeal and pleadings and requests.
First amended motion to revoke. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Does he waive a formal reading of this? Can we proceed in summary?
So
In summary, this first amended motion to revoke unadjudicated probation states that on August 7th, 2025, that in this court you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true?
Yes, sir.
And that was a second degree felony, and you were placed on 10 years deferred or unadjudicated probation. Is all of that true?
Yes, sir.
Allegation. There are 9 violations. We haven't done this one. We hadn't had. One state you committed the offense of public intoxication on or about October 10th, 2025 in Jefferson County. True. What is he? Let's
She's
just
not
say
pleading anything evidently. I don't know why we're going through this.
I think we've discussed it with him. I just want to make sure he knows.
Is he going to plead untrue to the indictment? To the motion?
The entirety.
What? Okay, tell me.
We have to go through it. I don't remember if the administrative violations that we're going to.
Okay. None of the substantive.
None of the substantive.
Okay, so the first 4 are crimes: public intoxication, PCP possession, public intoxication, and then number 8 is public intoxication, and 9 is public intoxication.
We were going to plead true to 5, 6, and 7, and then request a bond and have an updated pre-sentence report and give the state an opportunity to prove up the other allegations. I don't know what the problem is with that. I mean, what?
Nothing, except that he's just pled true to violating conditions of probation, which would be the same conditions he'd probably have as a bond. So why does he need a bond?
He's entitled to a bond because it's deferred.
Well, it would be, but you just pled true to some allegations, so the judge can decide. He doesn't have to give him a bond after he's pled true to those. He could actually revoke him, send him to prison right now.
If you don't want to get an updated PSI, you can proceed on the administrative violation.
What do you want to do?
I would plead true to the administrators and request a bond. If Mr. Laird doesn't want to attempt to proceed on the substantive allegations, we can hold the hearing today.
We were set for an announcement today. You want to set it for a hearing? We'll set it for a hearing. We'll have a hearing.
I'd like him to have a bond.
Anything. Well,
yeah, I'm just trying to simplify things by going ahead and pleading to the administrative violation.
That's not simplifying things. All it does is just makes it where you've got 3 allegations.
What we're going to do is we're not going to take it in installments. We're going to do it all or nothing. Let's set this for a hearing. When can y'all be ready for a hearing? 2 weeks?
Yes, sir.
2 weeks.
Could he have a bond for that?
And on the bond, the court is reviewing. What does he have now? Is there a bond?
There's
now? Huh?
There's a bond.
In Mr. Guidry's case, Mr. Guidry, you know how many times you've been convicted. I mean, it's your life, right?
Yeah, but the PCP,
No,
that's what you're charged with. Here, phencyclidine possession. We're going to postpone that to another time. Talking about your criminal history. You know what your criminal history is?
Yes.
Okay. How many convictions do you have?
3.
12.
Conviction.
How could you know your life better than me? We go back to on 2011, failure to identify, giving false or fictitious information to police. You were convicted of a misdemeanor and confined. It looks like 4 days and probated for 6 months. In 2012, you were placed on deferred probation for 3 years for illegal possession of a controlled substance. Later in 2012, you were convicted and sentenced to a theft, a Class B misdemeanor. And I'm not sure what the confinement is. I can't read it very well. In 2015, convicted of manufacturing or delivering a controlled substance and given 7 years probation. And in 2020, misdemeanor of DWI, convicted and sentenced to 90 days. 21, Class A misdemeanor, resisting arrest or search, convicted, and it looks like 10 days in your confinement. So that was Class A misdemeanor. Then a DWI, 30 days in jail in 22. Convicted, sentenced to 6 months in the state jail for illegal possession of controlled substance. 23, convicted, 20 days confinement, harassment of class B misdemeanor. In October of 23, state jail felony, 6 months for illegal possession of controlled substance. In January of last year, 25, class A misdemeanor, resisting arrest, confined for 30 days. And then in March of last year, second degree felony, assault on a peace officer, and that's when you get this 10 years deferred or unadjudicated probation from me. So 12 times, and you've been handled, and you're currently on deferred or unadjudicated probation. You were convicted of all the others. Your criminal history is terrible. And now you are alleged to have committed drug offenses, public intoxication, etc.
Well, again, my suggestion was pleading to the administrator, you can get an updated pre-sentence report and come back for sentencing.
State.
He's got new offenses. I mean, why don't we skip those?
We're gonna have a
Why would we skip
hearing on all of it.
Because then we get.
Your bond is $250,000. Plus, if you post a bond, you're gonna have a DPS class. That's a condition of bond.
I suppose you're, this wouldn't have an updated PSI.
Then we'll have a hearing in 2 weeks.
We'd be able to get an updated PSI before the sentencing.
Maybe. We'll see what happens. We'll see how that shakes out. Okay, thank you. Larry Johnson. What's this one?
Same thing. All of this sure now. What's he gonna do with any? I'm pleading the truth to it.
I take the same position, but if we don't, for some reason, to piecemeal these things.
Well, it's fine if you'll get out of jail and something like.
You know, we're not going to agree to that.
These guys are sitting in there for months.
This guy's been sitting there for 30 days.
I know because he hired me.
Am I hearing the right one? Y'all both playing with me? I'll scare one off. Is that a challenge?
We call 19-3-3-3-3-8. The states of Larry Johnson. No, well, we go through this one. No, we don't do in installments. There's a motion to revoke unadjudicated probation that's been filed as of January 9th of this year. It alleges that you're on probation for 10 years. Deferred or unadjudicated probation. Assault and the maybe violation probation by God. The probation officer that they're not being intoxicated by being a location other than your residence after curfew at 10:52 p.m. Failing to abstain from all intoxicating substances. Having alcohol consumed, and you were approximately 3 times the legal limit of your intoxication, including was not a good Christmas. I'm sorry. What we
Here's how many of them.
0.223. Yeah. 0.08 is intoxicated. 223 is almost 3 times. Multiply it.
That's not the blood test. No, you don't have to.
Well, there was a breath test that indicated his concentration to be 0.223. I don't, do y'all have a result yet?
Not from the blood yet, no, Judge.
Okay. So what are we doing on this today?
We're requesting a bond, Your Honor. He would be pleased with administrative violations, but I guess that's not how we're proceeding. So I'll just request a bond, set it for hearing.
Okay. What are you asking for? Just a bond?
A bond, yeah.
Okay. What state say?
He's on the firm. So.
Judge, if the court determines to give him a bond on this, we would just ask to take into consideration the public safety. It's obvious with the accusations on this particular deal that he's got multiple violations. And as Your Honor frequently comments, this man's running around with a 4,000-pound missile at 3 times the amount of what's appropriate. I don't know what we can do that's going to be safe for the community that's not similar to probation conditions. So I do know that at this stage, I don't have the blood test results, but I also know that the initial findings was that he was almost 3 times the limit as far as DWI is concerned.
I don't know if that was
his. Do you have a pre-sentence report on this?
Yes, sir. I do.
22 thing? Is that a thanks?
So portable, it's not admissible as evidence, Your Honor. We keep hearing about this 0.223. That's not admissible evidence. It is a portable breath test. That's not an intoxilizer. So.
Okay, he's got a felony conviction in 09. He was on probation, failed, and received 8 months state jail. Then in 09, a few months after that, 6 months state jail for illegal possession of marijuana. And he's on this deferred. Tampering with government records, 30 days in jail. Illegal possession of marijuana in 04, 30 days. Illegal possession of marijuana in 2013, 30 days.
There's a gentleman at night. I missed no word.
Who are you talking to? Hold on. What are you? Nobody's asking anything yet. Hold on.
This one, it's
Let me, yeah. Just, it's not a good idea to volunteer without your lawyer running it by your lawyer. Because you might say something that gets you in a mess. Then there was a trespassing and a terroristic threat. That was all set for July 29th. And I don't know what happened to that because that was this is the pre-sentence report for that.
The terroristic threat, he was given a probation that ran concurrent with this, Judge.
Okay.
And from what I can see for his benefit is that while he's been on probation, this is the first administrative hearing that he's had. Of course, the state takes a position that it's very serious, but it's
okay. He's been on probation since
22.
And he owed restitution in the amount of $42,702. And how much does he owe now?
Same amount, Judge. I confirmed that before we started the hearing.
So 3.5 years later. 42 months later.
So
He's never paid even a dime back for restitution of $42,000?
that's correct, Judge.
I don't know how it's being apportioned, but paying.
He's paying the reader of money.
Oh, the house being apportioned.
You're not paying a restitution every month.
That ain't going to the restitution. It's how it's being apportioned. Who do you expect? How much do you pay a month? They don't talk there $100 like that a month.
Looks like he's paying anywhere from $40 to $100 a month, Judge. And that makes it impossible to apply anything towards restitution without a court order from the.
Okay.
You start seeing it.
Well, it's not funny.
Well, you can make it pay $100 a month. Sounds good. To supplement. Gotta pay them.
All right, all right. What are you asking for on the bond?
Something reasonably on. Obviously, he's not in that greater financial shape. It's deferred. I'd like to have an opportunity to be out on bond, getting the hearing on this to try to get on the right track and perhaps get maybe caught up a little bit on the speeds.
All right, staying.
Judge, I stand by my earlier statement that the conditions of probation are not being followed.
Nobody's on
There's the best
deferred or unadjudicated
Yes, sir.
probation.
Judge, if you're going to set one, I ask that it be reflective of the safety for the community, as well as conditions to address what is apparently some kind of alcohol issue. That being an interlock device on his car, as well as other ways to address.
Doing on that for his intoxication. Did we ever have any conditions to deal with that?
No, sir. There may be bond.
Right.
No, only leaving behind bond conditions.
Right.
Are there?
I have.
You don't have.
No, sir.
Well, new things. The just all right, the court is assessing a bond of $50,000. Plus, he cannot operate a motor vehicle at all. You are at home confinement. You can leave your home for medical necessity, for food, and to see your lawyer. In the most direct route to and from your house, and you have to have a GPS device so I know where you are at all times.
What about employment purposes?
What's he do?
What do you do?
What do you
What do you do? Cleans out port the toilets around. What's the name? Open up. Necessary job, Your Honor.
Does the probation know that?
Yes, sir.
Okay, that's what I'm doing. This rules aren't being followed, and I want to make sure that the rules are being followed. You know, you can go to and from this job, but somebody is going to have to. And it's in the most direct route possible. When are y'all ready for a hearing?
Since I know they're going to contest the DWI, Judge, I need to get the blood test results. That asks for a reset for 4 weeks to kind of see where we're at.
We say 4 weeks.
We have to decide, you know.
Here.
Thank you, Judge. I appreciate it.
Okay. We've got an indictment here, 25 CR 1791, that accuses Michael Wayne Osborne, that's you?
Yes.
Correct, of the state jail felony of burglary of a building. And it also alleges that you have a fire forgery conviction out of this court in 97. And then paragraph 3 goes on to allege that after that 97 conviction of forgery was final, you committed the offense of unlawful possession of a firearm by a felon and were convicted of that in Orange County, Texas. So this burglary, this state jail felony then becomes punished as though it was a third or second because they're in sequence. This, if I'm gonna, if you don't interrupt me, okay? That's rude, and we can't all speak at one time. Hold on, you're gonna get a chance to speak. So this appears to be indicted as a state jail felony, though it's punished as a second degree felony if found guilty. So you were looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing in this charge? Now you can speak.
I do.
Okay, good.
Yeah, well, I guess I saw it up.
There are several things that you filed here. Let's see. You got a motion to dismiss counsel that you filed. What was the date on this? I don't see it's undated. And that Miss Minaldi has been appointed to represent you. Are you able to hire your own lawyer?
No, I filed a motion to proceed pro se and to be admonished. I also filed a motion for the recusal of
I
this
know,
court.
I know. I just asked you a question, sir. Just, are you able to hire your own lawyer, though? I'm just trying.
Proceeding pro se.
This is yes or no. This isn't a hard one to figure out, sir. Are you able to hire your own lawyer if you wanted to, though?
No.
Okay, you're because you're in jail and you don't have an income. All right, you're indigent then.
Yes.
Right, okay. All right. We're going to take these one at a time. Motion to dismiss counsel here. Why do you want that? Because this lady is here to represent you. You believe you could represent yourself better? Is that what you think?
Well, I'm sure you're aware, Judge, that I've been through this before and I represented myself. I have no problem with it. It's a barrier of communication when she offset this case and didn't network with me. Then I didn't want this presiding court even to adhere to the alleged offense. I don't want to be tried before this court, not with you presiding.
Why is that?
Well, if you don't recall, you should remember 8-9 years ago, you refused my agreement, and then you still sentenced me, and you never gave me my back time. And I don't see how we can entertain this today when I filed a motion to recuse and you still entertaining the kid.
Yeah. Well, first of all, back time. I don't have number one. You're so wrong because back time is not in this court's discretion. It's law. If you have time credited, you have to be awarded to this. And the court has never in 20 years denied back time that is allowed by law. So that doesn't make any sense there on that one. Number two, you can certainly represent yourself at any time if you wish, so long as you are completely aware and appreciate that the people who represent themselves pro se generally are not successful because attorneys are more profoundly aware of the rules of evidence, the penal code, the code of criminal procedure, and other laws that are used in the trials. Representing yourself is always a disadvantage. That's why it's a long statement. People who represent themselves have foolish people for their own clients. That was something that was part of the history of law before I was born. because there's not a lot of success at doing that. And when you're not adept at the rules of law, then you have a disadvantage. But you're an adult, you get to make your own choice. If you want to represent yourself, you just have to know that when you represent yourself, you're going to have to follow the rules of law and the evidence and the court of criminal procedure and the rules of criminal procedure and the penal code and any other rules that may come into the trial process. Let's see. And you'll be able to represent yourself if that's what you clearly want. Have you ever represented yourself in any criminal proceedings before?
Well, I'm sure you are quite aware that I have.
No, that's just yes or no. And just play like I haven't had 50,000 defendants in this court.
Wow.
You're going to have to refresh my memory. Go ahead. What have you done? What's your experience in representing yourself?
I started out with, Your Honor, with the fact that I filed motions that the court is not adhering to, and it seems to me that you're depriving me of due process because I don't want this court to reside, you to reside over this case.
Well, when you have good cause, just because you don't want,
Okay.
do
Rule
you want to interrupt me all day? We can't both speak because when you speak over me, this lady can't take what you're taking down, what you're stating. And it's rude, number one, but it's impossible for her to take what you state. Let me speak, then you'll get an opportunity to speak, okay? All right. Look, the Constitution of the United States does not state you anywhere that you get the choice to make your to have a judge of your wish before you. And that's, you get a judge who is a lawfully presided judge, and that's what you get. Just because you don't like me to preside over your case, that's not enough to grant your wish. Then I have a motion to quash an indictment here that you have filed, and can you summarize the reason that you filed this?
That was predicated, Your Honor, because it fails to state, I don't have a document, probable cause, information, or anything to go by. And first of all, I never entered any building.
But that's not, that's what we deal with at trial. But the four corners of the indictment, what's wrong?
All four corners, it doesn't meet the element of burglary of a building.
What does it fail to state? Because it states
given notice that I fully entered, partially entered, something to that effect, in which that would probably give me the benefit of defending myself against.
Okay. In summary, this states the elements of the penal code of burglary of a building clearly in this paragraph that on or about October 15th, 2025 in Jefferson County, Texas, with the intent to commit theft, you intentionally and knowingly entered a building or portion of a building not then open to the public without the effective consent of the owner. Those are the elements of burglary of a building. Anything else? What was it missing? What was the element that's missing that's in the penal code that you're saying?
Into the building.
Oh, but it's an allegation, sir. It's not, that's what we do at trial, it alleges, it's what the allegation is. That's why we have a trial, and that's why you get to present evidence, the state presents evidence, and a jury makes a decision. Everybody who pleads not guilty contests what it says. The question is the four corners of the indictment. Does it allege the allegations that are required for the commission of a crime? And it does. That's why we're going to go to trial. So that's denied.
Yeah.
The motion to quash is denied. It does
I'd like a copy of that.
properly fit the elements of of the indictment, and you filed it more than once here. There's a motion to quash on December 19th. What's the difference?
I never got an answer. This is why I refiled it.
That's why we're here today. The motion is denied.
This
Let's
is
see,
nothing but
wanting to
criminal
advance pro se. Well, you're so rude. Interrupt the court. I told you have a chance to be heard, sir. You can't help yourself. How many times we learned that in second grade. Not that our teachers would scold us. Don't be rude to others and don't speak over others. You're going to get a chance to speak. Okay, wanting to advance pro se, that's granted. You're going to get that. That's all. Now that's all I have here. The motion to quash, hold on, the motion to quash is denied. The motion to proceed pro se is granted. That's another pro se, that's granted. Motion to dismiss counsel. That's granted. Anytime you want to change your mind on that, though, I would urge you, let me know so a competent attorney can be appointed to represent you. Does he file something? I'm sure he's not able to pay and Mr. Osborne is deemed a transient. Is there something in there that shows he's indigent though, so that we can appoint somebody? There is an affidavit of indigence that was never signed by you. That needs to be filled out.
Yes, sir.
So that if you, and it looks like the magistrate, it looks like Judge DeRuin
Yes, sir.
went over it, but you wouldn't sign it or filled it out.
No, I filed to proceed pro se and I filed for an examining trial. I requested one immediately.
Okay, but here's the deal. Anytime you want to change your mind, which is the right you have under the Constitution to have a lawyer represent you, what would happen, we'd have to stop everything we're doing and get you to fill out an indigent form. If you fill out an indigent form now, it's in there ready to go in the event you change your mind.
All right.
But it's your call if you don't want to do that, but it stalls everything, I would urge you to do it just to have it as a safety. Okay, sir?
That one thing, did you get the motion for an investigator? I sent that as well.
I'm looking at all of this. And okay, motion to dismiss. There's no investigator in that. Then the pro se motion to quash the indictment. Another motion to quash the indictment. It says wanting to advance pro se. I'm treating that as a motion for pro se, and I don't have it. That's it.
Okay.
That's all I've got here. And then here is there's something about, this says motion to recusal, and then it refers to Judge DeRuin, though. Establish the wanting for examining trial. Is that right?
Yes, sir.
Okay, you don't get an examining trial if you have been indicted. If the grand jury indicts, which they've indicted in November, an examining trial is no longer an option. Says you are illegally confined in the jail. Information indictment, that's paramount. Said John seems to stop. What is that? Step aside, I think is which is some paramount importance. The leading force of this matter is predicated on facts and a profound complaint. Further complaints presented before Mr. Sims made Stephen's failure to not accept the plea agreement in the state felony in the past. From what has happened. First, what may happen. Articulates the presiding judge. The decision years back in a state jail case. I guess it was in this forgery case. Is that right?
Yeah, that
Yeah, okay. Okay. Which I really can't read your.
I know.
Where premise is considered prevalent, that said judge step aside in the best interest of justice. And I don't understand your writing because it's hard to write in there, but I don't understand what you are articulating that would cause this court to step aside. It seems to state you just don't prefer me, and that's not enough, under law. But if you want to write some more, go ahead. But at this time, I don't find that the four corners of your pro se motion sets forth valid reasons for this court to step aside.
Okay.
So we're going to continue to move forward, and you want to continue to represent yourself.
Yes, sir.
All right. And you want to go to trial.
Right. I would like copies of all that's been denied as well. And a copy of my indictment, copy of the cause and information if at all possible.
Yeah, okay. If Reggie, can you make just a copy? As possible, at any time you want to change your mind, let me know immediately so we can get somebody in here, okay? Yes, sir. All right, sir.
Thank you.
All right, thank you. What else?
Judge, did you need him to fill out this anything new?
Yeah, he needs to do it now while we've got him here. Anything else?
No, Judge.
Is that it? All right. Who else do we have? All right, we now call cause number 22-39418, the state of Texas versus Charles Ray Moss III. That's you?
Yes, sir.
Present. Mr. Gertz is here representing you, and the state's counsel is here, Mr. Ham. Earlier in this case, you were indicted by a grand jury for the first-degree felony of murder. You entered a plea of guilty to the lesser included second-degree felony of manslaughter. And a pre-sentence report has been ordered. Have the parties had an opportunity to review the pre-sentence report? Any corrections or changes to it, state?
None from the state, Judge.
Or defense?
We have, Judge, and we do not have any changes or corrections.
Made a part of the record for all purposes. The agreement is a cap of 15 years, I believe, correct?
Yes, Judge.
So you are looking at no less than 2, nor more than 15 years confinement in prison. I don't believe regular probation is an option.
That's correct, Judge.
Deferred can be.
Yes, Judge.
And There are some things I highlighted here that I'd like the parties to address during this hearing, and the defendant may want to if he wishes. Okay. Go ahead, state if you want to go first, or you can go last.
I'd like to go last, Judge.
All right, defense, go ahead.
Judge, we're asking the court to consider deferring probation in this case for a couple of reasons. One is Mr. Moss is not even though he did engage in a fight with the decedent prior to the shooting, he is not the person who shot anyone. I don't think that's anyone's contention, but he was obviously a participant in this episode. Secondly, though, Judge, he has very limited criminal history. In fact, just has a possession of marijuana out of Smith County, but other than that, has little or no criminal history. And then, additionally, Judge, he's been in custody now. I want to say for almost 5 years, if not at 5 years, on this charge, and so that's a significant amount of time under his belt, so to speak.
Well, this occurred on February 17th, 2022.
Well,
The most he can have is 4 years.
4 years. Either way, he's been in custody since within a few days of the shooting, Judge. So I miscalculated that. I apologize to the court. But for 4 years, he's been in custody on this, and it seems to me it would be logical for the court to consider supervising him over the course of that 10 years of deferred adjudication and trying to help him get on the right track with his life and making better choices and things of that nature, as opposed to merely just giving him a prison sentence and letting that be the result. So we're asking the court to give consideration to that option, which again would, if he were to violate it, we've talked about it very thoroughly. If he were to violate his probation, he understands the severity of the consequences. He understands that the 15 years in the cap would go away, and instead he would be facing up to the full amount, which would be 20 years in this case, Judge.
Right, so I'm going to provide a little background so we can put this in perspective, Judge. There's 3 individuals that were charged with this offense. Specifically, Jacoby Broussard took a plea bargain agreement of a cap of 30 years to the murder offense. That was he was pled on October 6th of 2025. He came back on his sentencing on December 1st, and he received 30 years. It was at that time as well that we moved one of the other cases, Arthur Small, who in my opinion had less involvement than Mr. Moss. He received a plea for manslaughter and accepted a sentence of 8 years TDC, and that was subject to his testimony that was going to be offered against Mr. Broussard and Mr. Moss that directly contradicts what the defendant's version on page 1. Mr. Moss, we fashioned an agreement with him to allow him to plead to manslaughter as opposed to murder, again, because of not being the shooter at the time as far as the state's understanding of the evidence, but the fact that he was actively involved, participated in this, and again, specifically, what's highlighted on page 1 is that he was there, he observed it, and I know your honors read the statements of the interested parties. This, the fact that someone could walk away from that and not do anything and then really stand here and ask you for probation is, I understand why they do, but it's just not warranted. When we look here at things from a perspective, the sentence that we gave Mr. Broussard was proper. The sentence that Mr. Small received is proper. It's appropriate that Mr. Moss receive a sentence somewhere between the 30 and the 8 years. To give him
Between what?
30 and 8. Mr. Small received an 8-year sentence. Mr. Broussard received a 30-year sentence. Mr. Moss can receive anywhere up to 15 years. And I'm just telling the court how I fashioned this agreement. There was a fourth individual that was immediately came forward and was not present at, not actively involved, and purposely identified all these individuals, and that's the reason why he went uncharged as far as his facts and circumstances are concerned. But to lessen the punishment for Mr. Moss would be highly inappropriate in this lawyer's opinion. I do agree that Mr. Moss has been in custody for the sum of approximately 4 years. I agree that he has a limited history involving this situation, but his lack really of accepting any kind of responsibility for this and a lack of remorse about what happened doesn't warrant the sentence that they're asking. I feel that 15 years is appropriate, Judge.
Okay. Go ahead. Good man. Anything you want to say?
No, Judge, I think, I think my only disagreement with him is about the what the outcome should be. I think that you know, the court has an opportunity here to address this young man's challenges and issues. And you know, if the court does see fit to give him 15 years, you know, theoretically, he would be eligible for parole in 3 years and, you know, would just be out versus being on the court's supervision for an extended period of time, a much more extended period of time, and all the while having the ability, as the court is well aware, to put him back in prison for an even further extended period of time based on his performance. So I'm asking the court to consider it. I understand what the sentences were for the other people involved, but I think the court can by its verdict can supervise this person, and by its ruling can supervise this person, and be as effective or even more effective than just applying prison sentence.
One last thing I forgot to mention to your honor is when this was set on November 13th, it was on the trial docket. It was at that time that Mr. Moss learned that in addition to Small testifying against him, that Broussard was prepared to testify against him. So all the individuals there were about to come into the courtroom and set forth his actions. And it's only then, in my opinion, when his feet were on fire that we entered into this agreement. So we never fault somebody for waiting, but it is a fact that I wanted to share with the court.
Okay. I'm kind of funny about the presumption of innocence.
Yes, sir. I do too, Judge.
I wrote an article on that one.
Yes, Judge.
And it's the lead article, by the way.
To be fair, I mean, we made decisions for a variety of reasons. Those people would have been subject to cross-examination, and we can see what we would have landed. But he's chosen to accept responsibility for his.
That's what this is all about.
Yes, Judge.
The circumstances of the crime, criminal history, those are the equations. Those are the factors that go into the equation of determining a sentence. You pleaded guilty not to the indictment of murder, but to the lesser included offense of manslaughter.
Yes, sir.
Okay. Did you want to say anything to the court?
No,
Because, okay, because there's a big gap problem here. The pre-sentence report is made a part of the record here without objections. I want to know what you did. Because I can't understand it. It's not clear at all. You admitted, you pleaded guilty under oath to recklessly causing the death of an individual. I want you to explain to me or anybody what you did to recklessly cause the death, because according to this pre-sentence report, you didn't do a thing, which doesn't amount to culpability. Anything you want to say? Or I thought you were complete. Go ahead.
Well,
Anything else?
I'm always concerned about questions like that for my clients, but
Yeah.
I think the answer here is goes back to the rule of parties. So we make a calculation about pleading guilty, not just based on the language.
Okay, go into tell me how that connects him. That he just wasn't in the same area code. What was his connection with the party?
Well, Judge, he started the fight or got involved in the fight that started this entire process. I mean, his decisions to participate in the fight that ultimately led to the death of the decedent, even though it was someone else who did the shooting, he was there and was an active participant. And so, again, that's what the eyewitness says. It's what the other people involved.
Where's the evidence in the history of the reports and all that show where the defendant was at the time of the death? Is there anything you can?
There's statements from Arthur Small from the beginning that he was involved as an individual that got out of the car when Jacoby Broussard shot him. And that's also confirmed from the uncharged conspirator, Ladarius Stevenson. So all that's from the onset, Judge.
And the defendant has nothing more to say, right?
Yes, that's it.
Okay. All right. Anything else?
No, Your Honor.
If not, your last chance, because I'm about to proceed with a rendering of punishment. Okay, it's your call.
I just want to say that I apologize for what happened.
Well, what happened?
The
That
deceased
you're
was
apologizing
the
for?
deceased was my best friend.
I know. What did you have to do with his death?
Nothing. That day I was called to go feed.
All right. All right. You just heard what he said. I had nothing to do with his death.
Judge, he is a party to this offense.
Sir, I know that. I know what he's saying, but how can he say, I plead guilty and I had nothing to do with it? Can you fix that in the record? Because it's a problem.
I understand, Judge. Again, this is why I try not to encourage my clients to have conversations with the court.
Well, but no, it's trying to place a square peg in a round hole. It's not fitting.
Judge, the answer again is he was actively involved in a fight with a person that was his friend, that ultimately was the decedent at the hands of another person, Mr. Broussard. And he was there. They were all at the stables that were there. But when he says nothing, he means he wasn't the person that pulls out the gun and shot anybody. He didn't pull out the gun. He didn't produce the gun. He didn't hide the gun. Well, Judge, he was involved in the fight that led to the altercation that led to the decedent's death.
But I thought he left and separated himself from that before the event.
I don't think it's before the event, Judge. I don't think that would not be the evidence at trial. And
that's not what he just said. That's not what this says. Shortly didn't. He had no idea who shot and killed him. Found out the next day. Interviewed. We got in a fight. However, he left shortly after and did not return. I mean, I'm not a dummy. I mean, this doesn't. add up to being present at the time of the event. But he pleaded guilty. All right. Anything else?
No, Judge.
Anything else from anybody?
There you go.
All right. Here, Mr. Moss, you have pleaded guilty to this lesser included offense of the second degree offense, manslaughter, voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of manslaughter. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir?
Yes, sir.
You will be given credit for all time you have served in accordance with this case. Anything else to add by anybody?
No,
All right.
thank you.
That is all.
Every day in the USA, people find themselves in court.
So the first thing that I noticed is that Mr. Wood, is it Davis or Wood? Davis, your middle name?
Davis is my middle name.
Okay, so Mr. Wood, the address that you have listed here falls in precinct 5. Do you live on Ranch Creek Drive?
No, I live in Pflugerville.
You live in Pflugerville, so even more so. So the address in Pflugerville is on Town Center Drive, is that correct?
Yes.
Okay. Right there, because I think that may be a precinct, so it's,
Precinct 2.
okay. All right, so this is precinct 3, so it was filed in the wrong precinct, so that's the first issue that we need to address. That is to say that with the party's consent, we can hear it here, but it should be in precinct 2, not in this precinct. And so, Mr. Wood, you're the party here that has been sued. Ms. O'Hara, you're the one that filed it. Is there a reason, Ms. O'Hara, why you filed in precinct 3 and not in precinct 2?
Yes, the offense happened in precinct 3 while we both resided there at that time.
Alleged offense. Okay. Which alleged offense? Because you're not suing based on an alleged offense. You're claiming this is as a civil matter that he caused you harm. Okay. And you're saying, at least in the complaint, it says there's a false allegation that was made, a false police report that was made.
That is correct.
Okay,
That led
so
to an arrest.
that is the offense here that you're claiming, right? If in fact there was actual any type of assault, physical assault, according to your complaint, he filed the false allegation that you had committed the assault on him. Is that correct?
Correct.
But you're suing based on the false allegation.
I'm
So
suing on damages and a debt claim that's been unpaid.
So it doesn't say anything in here about a debt claim in your petition.
Yes, I made an amendment to the court. I emailed the court telling them that I needed to amend the original petition, and they accepted it, told me how to do it, and it was emailed back, and they accepted the amended petition. So it should say damages and a debt claim.
Okay, so there's a debt claim for unpaid dues. Okay.
Correct.
And then there's damage to property. Where did the damage to property occur?
Precinct 3.
And the debt that's owed,
Same precinct.
because it says for unpaid dues. Is this a membership of some sort?
No, this was a contract from a loan. It should say from unpaid loan. It was a loan that I loaned Mr. Wood, and he didn't fully pay back the loan. And we have it was a signed contract sent by him to me, docu-signed, and signed by both of us.
For $4,000, which you were paid.
But that's okay. That's just an allegation that she's making at this stage. So you don't have to respond to that. All right. So let's take a look here. Okay. All right. Any objection then to getting the case here?
I'm sorry, could you repeat that? I didn't hear that.
Is there any objection on behalf of Mr. Wood for me hearing this case here, right?
I have no objection, Your Honor.
Okay, so we're gonna go forward then. So typically we also like to do is I like to give people an opportunity to try and see if there's any chance for resolution. Do you think that there's a chance of resolution if I put you into a breakout room so the two of you can talk together to see if you can reach an agreement? Or do we need to go forward with this case?
I would be happy to enter into negotiations with the defendant.
But is that something that you'd be open to doing here, let's say 5-10 minutes? See if we can reach an agreement.
I'm sorry, was that a question for me?
It was a question for Mr. Wood.
Okay.
Your Honor, I don't believe we have anything to discuss.
Okay, not a problem. If I can have both parties please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Yeah.
Your Honor.
All right. All right, Ms. O'Hara, this is your case. So I'll give you an opportunity, just a real brief 30 seconds, 1 minute tops, opening statement, please.
Okay, Your Honor, first off, I emailed the clerk to request the defendant's evidence, and she sent me an email back, and in communication this morning, she stated that she has also not received any of my evidence, and I submitted this on Friday. I'm really concerned about not being able to try a case with my witnesses because they won't be able to see the evidence.
Okay, so here's an issue. This case was specially set for today. Okay, any request for evidence needs to be done well enough in advance so that there's ample opportunity for the parties to exchange, to raise objections, to do any type of discovery, right? Because typically you have 30 days to respond to discovery prior to the court trial. This case has been specially set. So what that means is that if you have not sent that request of him specifically, right? Sending it to the court doesn't do anything because the court, he has to be notified of that. So if you have a motion that you file, he has to be notified of that motion as well. Okay.
I sent it to the clerk and the clerk sent it to the defendant.
Well, that's an assumption that we're making that was done because it's certainly not a requirement on the clerk's part to send it to the defendant. It's your responsibility to do that. Okay. So when did you send the request for discovery to the defendant?
I sent the request to the clerk on Friday.
Friday is not sufficient enough time, so I'm going to deny that request. So if you wish to proceed, we're going to proceed without any of those requirements because there simply was not enough time for any kind of response to be done in that time period because he's entitled to 30 days.
And I don't necessarily need the defendant's evidence, but what my greater concern is that the court doesn't show that they have my evidence. And I have, I'll just show you the paper copies. This is how much evidence I submitted.
Okay, how did you submit it?
I submitted it by a scanner and emailed it to the court.
Okay. Did you scan everything into one document and send that one document to the court?
I scanned it and grouped it into, I believe the scanner did do it in one document, yes.
It's possible, and I'm not saying that this is in fact true, it's possible that that file was too large and it didn't go through.
Yeah, I also did it in separate ones. So I did it in duplicate and I grouped it into, because I looked at the megabytes and made sure that I was under the megabytes there so that the file could send. And it was well under, each one was well under the megabytes.
Where is the email that you sent that attached that? In other words, when you said you did that on Friday, is that correct?
Yes.
Mary, do you have, no, we don't, because everything that I'm looking at here is dated. If you sent it on Friday, it's possible that it's still in a holding area. Is that possible?
If that's the case, do we need to reset this hearing so until the evidence comes in?
The reason I say that is because if you sent it on Friday, Mary, do you see it anywhere in holding? Perhaps?
No, I checked all of our inbox. I checked our archived everything. I do not see anything. I asked Ms. O'Hara to resubmit it to us while we were waiting. She said she was unable to. So unfortunately, I don't see that we ever received it.
So here's the thing. Because it was done on Friday, what time was it done, Ms. O'Hara, on Friday?
It was approximately lunchtime.
Lunchtime. What is your email address? Mary, can you look that up to see if there's...
Yeah, I searched up with her email address and as well with her case number. I could not find anything. Even in our junk, maybe went through there, could not find anything as well.
So unless you're able to present it now, Ms. O'Hara, I can't consider any of that because it's, you have to be able to present it so that we can see it, right? And
Yes, absolutely.
To,
So I can question my witnesses.
so as I understand it, this case was specially set today, which means that we did this on Zoom specifically for you all to have this hearing. Now, I can tell you from my experience here is that, in order to prove up your case, you're going to need evidence. And without physical evidence, it's going to be your word against his word. And Mr. Wood, I don't know if you have specific evidence, but that means you're going to have to show it, share your screen to be able to show what it is that you're talking about. This is not a court of record. So it's not like we're recording. Well, technically we are recording here because we're live on YouTube, but that will be deleted as soon as we're done here.
Well, Your Honor, I filed my response to this case. I don't know, over a year ago.
Yeah, I see the answer. And I think you filed a motion to dismiss as well. Is that correct?
Yes, Your Honor. This is nothing but continued harassment.
Well,
just now it's being tied to a civil case for monetary damages that are not owed.
Has there ever been a hearing on the civil case?
This is
sorry, on the motion to dismiss.
I was not ever, I sent it in. All I ever got back was that it was reset. So I never heard a ruling on my motion to dismiss.
Judge Olivo, we did send it to our Judge Holmes for review. She stated that the case just may be set for a TBC and proceed as normal. That's what the note stated.
Oh, but she never heard the motion to dismiss. Is that right?
Yeah, it says no action needed by court on this defendant's motion to dismiss.
All right. So we basically ruled on that.
It was Judge Holmes.
Yeah, that's what I'm saying. Judge Holmes ruled on it already, basically, that in essence was denying the motion to dismiss.
Yes, essentially.
Okay. And
Judge Olivo, just as I could, Ms. can share her screen if she has the documents on her phone, to see if she can do that as well.
Say that again, it kind of cut out. Sorry.
Oh, Ms. O'Hara can share her screen with the evidence if she has it on her phone or like the device she's
It's all on paper.
Yeah.
but the scan she said you scanned it.
Yes.
That scan
I tried to
copy.
get the evidence from the scan so I could share it on the screen during the break while we were waiting, and I wasn't successful so
Yeah,
far.
unless that scan is actually saved on her phone, she won't be able to go to the phone to open it. So she would have to like put the camera on it in order to see it and hold on to it. All right. As I mentioned to the case before this one, I do not like pushing these cases down. But I can tell you that the only evidence I'm going to be considering today is the evidence that is presented orally and that which is already in our system that we've already received. I cannot consider anything else because we don't have anything else to consider.
Your Honor, would we be able to do a motion for continuance because of this, because you guys did not receive my evidence? Because it's very important because I can show that on many occasions that the defendant is lying and will lie.
I want to clarify also, the motion for continuance is not based on we didn't receive it, right? Because if it was sent, we would have received it. So the motion for continuance would be based on some error on your side, not getting it here. And then because each side, generally, we're going to grant a continuance. And it looks like Mr. Wood requested a continuance in the past, and we granted that. Actually, each of the parties have requested a continuance in the past.
Yes.
All right. So I don't know the basis of that, other than that both of you have requested it. So if you're both in agreement to continue this case, it's going to have to be specially set again, and it's going to be down the road. It's going to be at least 2 months down the road. It's not going to be next week.
Okay.
Your
And
Honor, I'd like
I'd
to
be
get,
willing to see this in precinct 2. I'd be more than happy to do that in precinct 2 where he lives currently.
Then you'll have to file a motion to change venue. To put it back into the precinct where he lives. Which
Okay, is that what we would need to do is, would I need to do that to file a motion to change venue?
Either one of you can do that.
Okay.
Your Honor, I would just assume to have this case ruled on now. I don't have time to go through her hundreds of pages of whatever it is.
You're opposed to the continuance at this stage.
I'm opposed to the continuance. I had to take a day off of work. I'm tired of this hanging over me. It's just yet one more form of harassment.
Mary, tell me about the setting on this, because as I understand it, what's specially set. So we went out of our way to set this specifically today. Is that correct?
Yes.
Y'all picked the date.
No. Well, that's why I'm asking the clerk, is because she has notes as to the history on why this case was set today specifically. In other words, we can take any date, right? But both of you are appearing by Zoom. You're not here in person. So we went out of our way to make these accommodations for the parties today. And so that's what I'm trying to find out. What's the basis for that? And so Mary, the court clerk, is telling me that it was specially set, which means that if there's an objection to a continuance, then I have to take that into consideration.
Well, Your Honor, the reason I did not want to do this is I have no desire to be in the same room with Ms. Guerra. All this results from yet another physical assault by her on me. Okay. It's taken me thousands of dollars of therapy.
Sir,
I don't want to be with her.
Mr. Wood, I'm going to give you an opportunity. All right, so this is what we're going to do. We're going to go forward. I'm going to deny any type of continuance. We're not going to be, I'm going to deny any requirement for any discovery at this point in time. We're going to move forward. I've already sworn each of the parties in. Ms. O'Hara, as I asked previously, give me a quick 30-second to 60-second introduction. Just why are you here? Why are you demanding that Mr. Wood owes you money? And then we'll move on to him.
Okay, thank you, Your Honor. Yes, we are here because there was a false accusation made that led to a dismissal. The court record states insufficient evidence, upside down case. That rendered me suddenly homeless. And all this occurred right after I had Achilles tendon surgery, was not able to walk, was not weight bearing. I incurred extensive amount of debt, attorneys, hotel fees, emergency housing fees. My insurance, we were on the same insurance policy. Without notice, that was suddenly cut. And I was in the process of extensive physical therapy 3 times a week. So I had to pay that out of pocket. I had multiple, I wasn't able to drive because it's my right foot. And I had to obtain Lyft rides in order to get to physical therapy. 2 physical therapy appointments were canceled, which I was charged for. My knee scooter was also taken when I was arrested, and I was not able to walk. Therefore, I had to go to the hospital right after. I'm not asking for that, but there are medical expenses due to the fact that I had to pay them out of pocket that were already, the appointments were already set prior to the false accusation. And also there was a contract debt that was not fully paid back with the interest fees that Mr. Wood stated in the contract. And in Mr. Wood's response to the court, I can prove that all 4 of those points are fallacies, lies with my evidence. And also Mr. Wood filed a continuance. We had a hearing set for December 9th, which I also took that day off. Mr. Wood stated that his reasons for continuance said he was out of town for his daughter's graduation. I have facts showing that he was actually in Austin, Texas at work on Ranch Creek. He was working, he was in town. His daughter didn't graduate till Saturday, and he had not left town yet. So he could have gone to that hearing on December 9th, and I took that day off as well as today.
Issue of the continuance on the hearing has no bearing on this case whatsoever. And so I'm not going to hear any evidence with respect to that.
I understand.
Because we're here just simply because you're claiming that you've suffered damages as a result of Mr. Wood's actions. Okay, so that's it. That's what we're here for today. Okay.
Thank you.
All right, Mr. Wood, real quick brief, 30 seconds to a minute. Opening statement, please.
Your Honor, in the incident that happened on February 20th, 24, the decision to arrest Miss O'Hara was not made by me. It was made by the Travis County Sheriff's Department. They took pictures of the handprint on my face, the whole 9 yards. This was not the first time I was assaulted by Miss O'Hara. It was just the straw that broke the camel's back. The Travis County CA advised me to leave, claiming domestic abuse. I had to rearrange my life, terminate my lease, establish a new lease. I handled all the moving expenses. I've even paid for 6 months of storage on Miss O'Hara's storage unit and that was based on her breaking in and stealing things out of the storage unit that I had by cutting the locks off of them, which is documented in another Travis County Sheriff's investigation. I just want to move on with my life. I'm not seeking any damages against Miss O'Hara. I just want her out of my life and to move on with hers. It has been 2 years. The continual harassment, I have been signed up for everything from Tinder to Grindr to, just little annoyances, calls to my work. I just need it to stop, and I just would like for her to go away and live her life. Let me leave mine.
Just to kind of give you both a little bit of understanding of the general rules of civil procedure don't apply in this court like they normally do in other courts. So with that said, I'm going to give some leeway in terms of evidence that's presented. You still need to object If you object to a particular thing, I will rule on those objections, make sure that if somebody makes an objection, you allow me to respond to that objection before you continue giving evidence or talking or testifying, okay? With that said, I will be, in order to move this case along, and not to get into any tangents, I'm going to be asking some questions of each of the parties to kind of guide you. In a sense, I'm not going to be helping you, but it's based questions that were based on things that I need to know from assumptions that I'll be making from the petition, from the answer on where it is I believe that you're trying to take your claims. Okay. All right. With that said, Ms. O'Hara, you may begin.
Yes, 1 moment here. Okay, my apologies. Yes, in regards to, first off, I have a motion to dismiss, that was accepted, upside down case.
Okay.
File stamped by the court. I also have, in regards to Mr. Wood's claim about paying for storage, that's not true. Oh, I'm sorry. Go ahead, sir.
Are you asking that that document be entered into evidence?
Yeah, that's what I sent in, or yes, I apologize. Yes, that's what I submitted in the scanned documents. How would I do that now?
So if you'll put that document back up again, just kind of hold it there. Mr. Wood, if you want to take a look at that, it says motion to dismiss, and it's the county attorney has signed that to dismiss the assault family violence charge. See that?
I actually cannot see it, Your Honor, but
You can.
I find it,
maybe.
Let me see. It's got a bar across it on my screen. I cannot read that. It's way too small. Your
I
Honor,
could try to put a spotlight and see if that works.
I was never informed about the hearing date because I would have gone to that hearing. And I was never even given a chance to tell my side of the story during that procedure.
Objection incorrect.
So your objection is overruled. So Ms. O'Hara, you're presenting a document saying that the case was dismissed, and you're also making allegations that it was dismissed because it was false. That's not true either, okay? The only basis for that document being entered into evidence is to prove that in fact the case was dismissed. That's it, nothing else. There's nothing about this document that would suggest why it was dismissed or who chose to dismiss it, under what circumstances, whether Mr. Wood was consulted with it beforehand or not. The only thing this document does is provide evidence that the case in fact was dismissed. That's it.
Yes, it states the reason as well.
Yeah, but that has nothing to do with
Okay.
anything here. It just means that the case was dismissed. So, Mr. Wood, is there any objection to this document simply that the case was dismissed? That's the only thing that I'm considering that document for.
I object to it simply because I was never informed of that case when that case went to trial. I was never even given a chance to do it.
All right, so I'm overrule that objection. Again, you being advised of it is not the question that I'm asking. I'm asking, do you object to the document itself, that it states that the case was dismissed? We're not talking about why it was dismissed, how it was dismissed. The only thing is that it states that the case was dismissed. That's it. That's the only thing I'm considering about that document.
I guess I will accept it, Your Honor.
I'm going to accept it, and Ms. O'Hara, make sure you make a note that document needs to be sent in. Now, my question to you, Ms. O'Hara, what does that document have to do anything to do with this case?
It's one piece of evidence showing that it was dismissed, cannot be proved beyond a reasonable doubt, case is upside down. And the DA dismissed it, not my attorney.
Again, what does Mr. Wood filing these charges against you have to do with your damages?
These charges basically is why I incurred over $20,000 of debt.
So if
sudden.
you incurred more than $20,000 in debt,
Yes, I'm only asking for 19,500 though.
okay, but you don't get to say, I incurred more than 20,000, but I'm only asking for 19,000, therefore it falls in the jurisdictional limits of the court. If you incurred more than $20,000 in debt, this case needs to go to a different court and we don't have jurisdiction. It's as simple as that.
Okay,
It's not what you're asking for, it's what the damages that were caused that determines whether we have jurisdiction or not.
which court would this need to go to?
We would go to the county court of law or the district court. But we would not come here because we have a.
Okay,
cap of-
would I requesting your information, but would I still, would this case still, because it was filed, would it still fall under the statute of limitations?
I don't know when this happened. There's a 4-year statute of limitations when it comes to injuries. Okay.
Okay.
Some type of personal injury. I don't know that that's what you're claiming here because your petition is not clear. This is not a breach of contract. Now you do have a breach of contract issue because in your amended petition, you filed the issue of a debt. Okay?
Yes.
And so that is a breach of contract. That's a 2-year statute of limitation.
Okay, and when I filed this, and part of the reason I chose to do small claims is I didn't want a lengthy litigation. And the documents that I have here show the debt of under 20,000.
What was the debt incurred?
The debt incurred are medical fees, counseling fees, hotel fees for housing.
Hold on. You claimed earlier that there is a loan that you gave him that he owes you for.
Correct, a $4,000 loan, he paid half without the fees and the interest.
When was that loan entered into?
That loan was entered into, let me get my evidence here. One moment. May 5th, 2021. And the statute of limitations on debt claim is 4 years.
No, that's not correct. Statute of limitations on this is 2 years on a loan that you've given to him, because that's a breach of contract. And when did you file this case?
I filed this case February of 2025.
Yeah, so that's more than the 2 years. And so any claims that you have with respect to an unpaid loan are hereby dismissed because it does not meet the statute of limitations. So we're not going to talk about any of that whatsoever. Okay, let's talk about when did the injury occur that you received that caused you to spend all this additional money because of
February
your
26th, 2024.
2024.
Correct.
All right. So you're still within the 2-year statute of limitation if it falls into that. I'm still not convinced that this is a personal injury type of a case because you're claiming damages, but you're not claiming the damages from him assaulting you. You're claiming that because of his allegation of the assault against you and you were arrested, that's what in fact caused you to lose your home, to incur medical fees and all that. Is that correct?
Yes, as well as not having, he took my knee scooter from jail and I wasn't able to walk. So I fell about 10 steps outside of the jail after being released.
I think you walked through the jail.
I'm sorry?
Well, you were in the jail for how long?
6 days.
6 days. How did you walk without that scooter?
I didn't. I was non-weight bearing. They brought me a wheelchair. Once they brought me inside, they issued me a wheelchair and allowed it to stay in my room.
And
I was
then
not able to walk.
Did they walk you down to the door?
I wasn't able to walk. They came in and asked me if I was able to walk unassisted, and I said no. And I asked them if they had if I could use the wheelchair or a walker or something, and they said no.
just to be clear, Ms. O'Hara, you're gonna have to show approximate cause between your injuries and his actions, okay? And the fact that he did not, or that he picked up that little scooter, that did not cause your injury when you fell down 10 steps later, okay? I'm just gonna tell you that right now. If he pushed you, or if he took it away from you while you had it, then that's approximate cause, okay? But when you took those 10 steps without it, you did that of your own accord. There is not an issue here of proximate cause that because he picked up that little knee scooter, therefore, you fell down and that's where you suffered an injury.
Your
You
Honor,
understand?
may I speak?
No, sir. All right, Ms. O'Hara. Let me go back a step so I can better understand. Were you all in a relationship?
Yes, we were, and at the end, we were just
Were you living
roommates.
together?
I'm
Pardon?
sorry? Could
Were you
you-
living together?
Yes,
Okay. Did this breakup result in you leaving, Ms. O'Hara?
no, the breakup, because there was a prior accusation made by Mr. Wood that was also declined. The charges were never, I was never charged on that. It needed to be expunged. And Mr. Wood said I couldn't rent an apartment.
Okay, when did you all split up?
February 20, we broke up the relationship as a boyfriend-girlfriend relationship in September of 2023.
Okay, and the allegation, so what caused you all to be together again in February of 2025? Or
My
2020?
case in Hayes County from his accusation, he was strangling me, so I did bite him in self-defense to get away. Was not finalized yet.
So hold on, you said Hayes County.
Correct.
So all of this happened in Hayes County?
No. There was one incident. I had COVID. I was hypoxic, meaning low oxygen. And Mr. Wood was very combative. He put me in a chokehold headlock. I bit his arm to get out for self-defense, asked him to leave the apartment, which he did.
What does that have to do with you losing your home and having to go into the Safe Alliance and incurring medical injuries because of your foot when you were in jail? What do those things have to do with that?
I wasn't going to bring it up in this case. Mr. Wood did in emailing to the court.
Okay, so the Hayes County case has nothing to do with it.
I don't believe it does, no.
Okay, then we don't need to speak about that. So let's
Okay.
move forward to then the case that you're claiming where he made the false allegation. That was in February of 24, is that correct?
Correct.
Okay. According to you, he makes a false allegation and you get arrested that day, is that correct?
Yes, and I can provide a motive that he wanted to get out of the apartment lease without penalties.
Okay, that motive has nothing to do with this case.
Okay.
So, all right. So you get arrested that day in February 2024.
Correct.
You're in jail for 6 days.
Correct.
And that's here in Travis County.
Yes, sir.
Okay. When you get out of jail, you fall down and injure your foot.
I'm not, those aren't the injuries the medical expenses that I'm requesting. I'm requesting medical expenses for missed physical therapy appointments and suddenly having out of pocket, having to pay for physical therapy 3 times a week, plus the 2 missed appointments.
He caused you to miss those appointments.
Because he made the false accusation that led to an arrest.
Okay, so were you in jail and that's why you missed those appointments?
Correct, Your Honor.
So you missed multiple physical therapy appointments and you missed other doctor's appointments all in that 6-day period.
Yes, sir.
All right. Um, tell me more about your case.
Okay. I was in touch with I had Achilles tendon surgery right around New Year's of 2024, a month and a half prior. During this time, oh, I'm sorry.
Did the Achilles tendon surgery have anything to do with Mr. Wood, or that's just something that you had done separately?
Yes, there was abuse was becoming abundant by Mr. Wood, such as neglect, such as he filed me on his IRS taxes against my consent, my consent or knowledge.
So Harry, we're getting off on the tangents here.
Financial abuse.
Did Mr. Wood have anything to do with you having to have the tendon surgery?
No.
Okay. All right. So I don't need to hear about all those other things.
Okay.
All right. So you had tendon surgery. Okay. And that's the reason that you had foot problems. That's right?
I'm not sure that I understand your wording. Could you repeat that?
So you had the Achilles tendon surgery for some reason other than anything to do with Mr. Wood.
Correct.
All right. You had that surgery done when?
December 28th, 2023 to be exact.
Okay, but it was in 25 when you had this, when you got arrested.
No, 24. So it was approximately 2 months.
Late.
2 months after surgery.
Okay, so 2 months after surgery, so you're still doing rehab on that. Okay. You get arrested, so therefore you can't go to some of your appointments.
Correct.
All right. Now you claim that you're no longer on his insurance and you had to pay out of pocket.
Yes, and I was not informed of that at all. I found that out by going to something. I'm sorry?
Were you married to Mr. Wood?
No, I was not, but he claimed that I was on the lease agreement and other areas he claimed to people in public that I was his wife. He identified me as Mr. Wood on his lease to the leasing agent or Marsha Wood. My name has never been Marsha Wood.
What obligation did he have to provide insurance to you?
He didn't. It was an agreement. It was actually an offer that he wanted so that I would sign him onto my lease at my first apartment.
Are you all living together? Because you told me you were not living together.
We were living together in Austin and many years ago. And he said that if you will let me live with you, I will claim you as a dependent on my insurance.
And at this time, when you got arrested, were you living with him?
Yes, I was.
Okay, so you all, because I asked you specifically if you were living together, and you said you were not.
I apologize, incorrect. We were living together.
So in February of 24, you were living together.
Yes, as roommates.
Okay. But as roommates, or were you having a relationship?
As roommates at that time, we broke up our romantic relationship September of 2023.
All right. All right, you make your solution.
Okay, me?
Yes, ma'am.
Okay, I just wanted to be clear. Okay, I have some witnesses to question that are waiting in the queue.
And what the witnesses going to testify about?
I'm sorry?
What are the witnesses going to testify about?
The witnesses are going to testify. Mr. Wood reached out to one witness, a licensed professional counselor of mine, attempting to create a narrative and her notes that have not been altered since the date of that. And he was also threatening to call 911 because he knew I had a prior arrest.
What does this witness contribute to him owing you damages?
This witness contributes by showing manipulation and abuse prior to the arrest.
But you're not suing him because he manipulated you and abused you. You're
Yes,
suing
that
him,
is why I'm suing him.
but that's not what it says on your petition, and that's not clear. What you're suing him for is you're saying that because of his actions of filing a false police report and that you having to go to jail, that therefore you incurred expenses as a result of that.
Yes.
That's what you're saying. That
And
has-
prior to the arrest, expenses with I need to hired a tax attorney to straighten it out because of the federal tampering of the, or not, that's not the correct word, but claiming me on IRS, taking my social security card, which I've never provided to him. And that I've incurred costs for that for.
Did you hire a tax attorney?
Yes, I hired a friend that's a tax attorney, yes.
And did they represent you to have your taxes redone?
Yes.
So did you pay someone to refile your tax return?
Yes, I did.
All right, you may proceed then.
Okay. I have evidence showing that Mr. Wood is actually the hostile one. There's a police report that he was aggressive with his son, broke his son's phone. There's another police report.
Those things have nothing to do with your claim. So
All right.
I don't want to hear those things.
Okay. On the scan, I had multiple missed appointments and cost incurred. I went to counseling through a licensed professional counselor at $120 a counseling session once per week. Due to I was diagnosed with post-traumatic stress syndrome disorder.
Oh, one moment. Were you seeing a counselor prior to your arrest?
I was seeing a career counselor prior to my arrest.
And you went to a different counselor afterward?
No, same counselor.
Okay. How long have you been visiting that counselor prior to your arrest?
I was visiting her with her approximately 2020.
But you said this is a career counselor. What is a career counselor?
She
do?
changed to a career counselor. She's a licensed professional counselor.
Okay, is she the one that you have in the queue?
Yes.
Okay, let's go ahead and bring her in.
Okay.
So Mary, if you can bring her in, please.
Your Honor, can I object to this?
What is the objection?
What bearing does this have on this case?
Well, that's what we're going to find out. So if you can state unequivocally that it has absolutely no relevance whatsoever, then show me how. Otherwise, I'm going to ask the counselor so that I can get an idea of what kind of testimony they're going to present before I even allow the testimony. So, Ms. Williams, are you the counselor that she was talking about? You've been in here the whole time?
Yes.
Okay, let me have you raise your right hand, please. You solemnly swear the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, I'm going to ask you a few questions just to kind of get to where we're at. I do not want you to give me any type of privileged information of any sort. Okay, I'm just trying to find out, first of all, what kind of counselor are you?
Yeah, I'm a licensed professional counselor. I'm qualified for general counseling and I specialize in career counseling.
Okay, especially career. And so what does career counseling entail?
In my case, it's a very holistic approach to just all the roles in one's life and helping them work together to be the most purpose-oriented aspect of your life.
What type of education have you had to get you to this point to be a licensed professional counselor?
Yeah, I have a master's in counseling.
I'm assuming a bachelor's in
Psychology.
psychology. Okay, how long have you been doing this?
I got my license in 2013.
Now, with respect to Ms. O'Hara, I don't want you to give me any privileged information, but simply, let's start with, when did you first start seeing her as a client?
With the first counseling center, because I've moved several times, that goes back to, I think, 2015.
And you indicated that you specialize in career counseling. were you giving career type advice to Ms. O'Hara? Is that what you were counseling her on?
That's one of the areas that we were working on, yes.
Okay. Were you working on other areas? What other areas were you working on?
Her general mental health, anxiety, and dealing with the stressors in her circumstances.
And these are things that have been going on since 2015, that you've been doing that type of counseling as early as 2015.
Yes, and the issues that she would work through have changed over time.
Okay.
Well, some have accumulated.
All right. Now, you've seen her regularly from 2015 until a period in time she was arrested. Is that correct?
Yes.
And so when she was arrested, that was in February of 2024. Is that correct?
That's my understanding, yes.
Did she miss an appointment with you during
No.
that 1 week? Okay, so she didn't incur any additional costs with respect to missing an appointment?
No.
Okay, now since that date, have her visits to you been similar to the type of counseling sessions that you had with her prior to that arrest?
This is the nature of symptoms, yes.
How often do you see her?
Usually once a week.
Once a week, and you've been seeing her once a week pretty much this entire time?
Mm-hmm.
Okay.
Yeah, brief hiatuses, but I was on maternity leave once, yeah.
Do you receive insurance? We accept insurance payments.
No.
So everything is paid in cash. Okay. Thank you very much.
Yeah.
Ms. O'Hara, this witness is not going to provide any information that is relevant to your claims that he caused you these damages. Okay, so I'm not going to take evidence from this witness for that purpose in terms of any of those other kinds of claims. Okay.
Your Honor,
Yes, ma'am.
this witness can prove manipulation because this witness directly contacted this witness and manipulated and presented a narrative and manipulated her into trying to believe something that was not occurring.
So you're telling me that Mr. Wood manipulated your counselor into doing something that she would not otherwise do?
Correct. I left the apartment after
Well,
he
hold on.
was hostile, and he was.
Miss O'Hara, you have to stop. Miss Williams, did Mr. Wood contact you and manipulate you into acting in a way that you otherwise would not have acted?
I wasn't manipulated into action. I did experience an attempt to manipulate me.
Okay, but you didn't do anything as a result of it?
No.
Okay, all right.
Well, Your Honor, she called me.
Miss Williams, you are free to go.
Okay.
You don't have, I mean, you can stick around if you want, but your services are no longer.
Okay.
All right, Miss O'Hara, I need you to get to the point because you have not presented anything at all that would suggest that Mr. Wood is the cause for you having to spend additional monies for treatment to your foot or for anything else.
I also incurred expenses for movers. The initial down payment was $99. And that's the paper I have. In the scanned document, it was approximately $500 due to the fact that when I was at the storage unit separating my things, and by the way, we both had consent to enter that unit. And both of our names were on it. I was moving my things and separating them to my own unit. Mr. Wood showed up. There was a 30-day protective order. I advised him we're not allowed to be 250 yards from each other. Please step away. He did not. I was pinned in a corner. He was very hostile, yelling and screaming. So therefore, the movers were there for a lot longer. And so my total bill was approximately $600 combined with the down payment and the length of time they had to stay.
You all shared a rental unit, right? We're talking about storage unit. Is that what you're talking about? Or is this?
Correct. And also the storage unit waived 6 months Mr. Wood did not pay for the 6 months of storing my items. He is lying
So
about
were
that.
his were his items in the storage unit?
Both of our items were in the storage unit.
And was he required to pay the full rent on the storage unit?
We were both paying it.
Okay, so you're saying he didn't pay his share? You paid yours?
The unit was, he was the primary under the unit, and I was allowed access. And I was listed under allowed access,
You didn't
but
pay
I was
any,
not on the lease.
you didn't pay any rent on the unit?
I paid him.
You paid him, he's not liable to pay any. So what have you lost?
What I lost was the moving expenses and having to get a separate one. And
And I don't mean to belabor this point, but you guys don't have a relationship. You have a unit that he's responsible for paying, that you're paying half, right? And now you all have broken up and you want him to pay for you to move your things out. Show me where he's obligated to do
I
that.
would not have had to hire movers had he not made a false accusation.
The false accusation, man, has nothing to do with anything. He made an accusation, right, that you assaulted him. I'm not here to decide whether it was false or not false. The assistant county attorney signed a document saying that they didn't feel that they could prove the case. It doesn't mean that the statement was false. It just means that they didn't feel they could prove it. Okay, so that accusation is not the basis of you having to hire movers. I need you to present to me evidence that his specific actions are the direct cause of your damages. That's what I need to see. That's what I need to hear.
Okay. I went to my doctor's office and was diagnosed with PTSD. I paid that out of pocket. I paid $120 each week for counseling because I was struggling with nightmares, night terrors, post-traumatic stress disorder, anxiety.
All of those things, ma'am. Because for now, as far as I'm concerned, you're suffering those things, perhaps because of the arrest and having to spend the 6 days. And I can only imagine that that's a very difficult thing to do. But how is it that he's the cause of your PTSD?
Because I spent 6 days in jail on a false accusation. My dog was taken from me. My Pembroke Welsh Corgi was taken from me by Mr. Wood, and I am the sole owner of this Pembroke Welsh Corgi. And Mr. Wood was attempting to rehome my dog. I had to file a police report in order to get my dog back.
And I'm sorry to hear that, because I understand how pets are very important to people, and how for emotional support or any number of things on how.
Thank you.
You know, I get that. I understand. And that can be difficult. But with all due respect, ma'am, you don't have a case here. This is a breakup gone bad, and you're blaming him for it. And you're upset that he filed charges against you. And I can tell you, I've been a judge for more than 20 years, and I've been a criminal defense attorney for longer than that. And I can tell you that of the more than 2,000 family violence cases that I've defended, okay, that the vast majority of them had some false allegations in them. Okay. But even so, you know, it comes down to a number of different issues. The two of you just simply don't get along. And after your breakup, you clearly should not have been living together, even as roommates, but you chose to.
No, and I wouldn't have. I was only living with him until my other case was eligible for expungement and dismissed in Hayes County. That is the only reason why, because I was not able to rent an apartment. I was staying in an extended stay.
Now, and I understand that, but if you had an emergency protective order, you shouldn't have been living with him anyways.
We were not. That was after the arrest.
So you opted to live with him after those issues had occurred?
No, incorrect. There was a 30-day protective order issued after the arrest, February of 24.
And that expired, and then did you move in together again after that?
No, absolutely not. No, I'm in a much better place not being around that man.
And I'm sorry, I don't see any circumstance here, any situation where
Well,
he caused of your damages.
would this make a difference? I had to liquidate my 401k with Charles Schwab in order to pay for the new expenses, the unexpected expenses of hotel and other lodging and healthcare. That was totally unnecessary. I had to liquidate my 401k for this.
You did not get along. He filed a criminal complaint against you. The police department, sheriff's department, whoever decided came in, for them, it was sufficient to say this is enough to effectuate the arrest. Okay. You were not in a good place. You should not have been together in the first place. Okay.
No.
You're already broken up. You already were not getting along. You already had prior history. You opted to stay there, right? Up until the arrest, right?
Because he threatened that if I did not stay with him, that he would change his story with Hayes County, and then I would then be charged with the
expenses, okay, are expenses that you incurred because the relationship didn't work out.
the expenses incurred was because of his lie of a false accusation.
Well, let's assume for a second it was a lie, okay? The sheriff's department believed enough evidence existed at the time to arrest you, even if it was a lie.
I was very calm when they came. There was no physical contact or yelling between Mr. Wood and I that day. And I had 3 kids in the apartment that proved this.
Ma'am, I'm asking you to provide to me something independent of Mr. Wood's actions that caused you to suffer this harm. And you're saying that because he lied about the physical assault.
I have hotel expenses.
Stop. Because you're saying because he lied about it, therefore you were arrested. And because you were arrested, you missed a number of appointments, physical therapy appointments. Okay?
Yes, I had to obtain emergency.
Missing those physical therapy appointments did in and of itself did not cause you to pay any additional fees. You fell when you walked out because you didn't have your little scooter for your leg.
Yeah, that doesn't matter.
Right. And again, there's no tie, there's no nexus between his actions and the cost that you incurred, right?
Incorrect, because I had to get emergency lodging, which was approximately $3,300 a month at extended stay hotels.
How much were you paying for rent?
The rent for the apartment was $1,700.
You were splitting that, or
Yeah.
you were paying $1,700?
We were splitting it.
Okay, so you needed to go find another apartment. Your claim is that you couldn't find another apartment because the expungement hearing had not occurred yet on the original case that you had with him.
That's what he told me, is that I wasn't able to rent a car, an apartment, or get
So
a
he
job.
told you couldn't.
Yes.
Did you try
And-
to rent an apartment?
Yes.
And why were you denied? the
Because
ability to-
I had an arrest with 2 felony counts and a misdemeanor
Okay,
in Hayes County.
all right. Ma'am, I'm going to dismiss your case. There's no evidence here whatsoever to show that Mr. Wood is responsible.
What
for-
about the hotel fees and suddenly having to get in a mailbox because I was homeless due to his actions
Ma'am,
without
all of-
warning?
All of these things have to do with a bad breakup. And because of the prior history that you all had, the physical history that you all had in Hayes County and in Travis County, enough so that you didn't have a relationship anymore, but you were still living together. So these are all things that you did knowingly go into a living situation with him.
I didn't
Right?
have anywhere else to go. I stayed in an extended stay, and Mr. Wood begged me to.
Was the lease in your name? Was the lease in your name?
No, the lease was in his name, but I was the lease apartment leasing
knew
agent
you were
was
living
aware
there.
that I was there.
Right, and that's fine, but it wasn't in your name. You weren't liable on the lease. If he didn't pay, they weren't gonna come after you, they were gonna go after him.
Correct.
Right, okay. You would have had to pay rent anywhere, regardless.
Correct.
right? The fact that you chose to go to a hotel or someplace else, I get temporarily, but
That
you're
was the
saying.
only place that I could rent.
Okay. I'm sorry, ma'am. There is no evidence, none, not a scintilla of evidence to suggest that he's responsible for these injuries or these damages you claim to have incurred as a result of him making allegations against you. There's no.
What
nexus-
about the out-of-pocket physical therapy fees, the out-of-pocket for Lyft rides because I no longer could get to physical therapy? The
I
out-of-pocket.
did physical therapy before. You said because it was your foot, it was the right foot.
Yes, actually, both of my feet are damaged. I
You
was supposed to have
to
surgery
take
on
them
both.
anyways, right? Because you had the surgery 2 months before all of this happened. How were
Yeah.
you getting to those appointments prior to you being arrested?
Mr. Wood agreed prior to the surgery to drive me.
And so now he's not driving you because you guys don't get along
No,
anymore.
he wasn't driving me towards the end. It was neglect.
So he wasn't. So how are you getting to those appointments towards the end?
I wasn't. I was trying to get Lyft rides. I was trying to get people in the community to help. I
No, ma'am.
wasn't.
No, ma'am, that's on you. You can't tell me that he caused you to miss appointments because he didn't want to take you because you guys aren't getting along.
The appointments that were missed that I'm referring to are after when I was arrested.
Right. But you also just told me that you, towards the end, he was neglecting you and he was not taking you to your appointments.
There was neglect in many forms, actually.
But he's not obligated to take you to these appointments, right? You're not married. There's not a relationship here anymore. You live together.
But we had an agreement prior to surgery.
And what did you do in return for the agreement?
In return, I kept the house. I did his laundry. I cooked all the meals. I did the grocery shopping.
That's not a contract, man. So there's not an agreement there. There's no consideration for him to take you to these appointments that he's required to do so. But there's nothing. You have no claim here, ma'am. I'm sorry. You simply do not have any claims here. Now I understand how difficult this is for you. I understand that emotionally you've suffered through this, but you had a bad relationship to begin with and you opted to stay in it.
Well,
right?
I just thought of something else. I forgot. I apologize. I do have some damages because on the first arrest, Mr. Wood was not on my lease. I actually had another person on the lease because I did not want Mr. Wood living with me. We both contracted COVID for my daughter because Mr. Wood lied to the police officer, and also because I bit him in self-defense. I was arrested, and there's a fees involved in breaking that lease.
You're talking about the Hays County issue.
Yes.
And we've already agreed that I'm not going to hear anything to do with Hays County.
Okay.
Right. So that has no relevance here today. I'm dismissing this case. You just simply don't have a claim. All right. Good luck to you all.
Thank you, Your Honor.
Thank you, Your Honor.
Every day in the USA, people find themselves in court.
Court does call the case of the people versus John, is it Versavi?
Haley Zend on behalf of the people, Your Honor.
Good morning, Your Honor. Dan Garrett, I believe it pronounces it Resavi, is that correct, John? Resavi, Your Honor.
Resavi, got it.
John Resavi.
All right. Meeting time set for trial. Are we ready to proceed?
Before ready, Your Honor, I did want to put on the record that there was a police offer to be discharged with sentencing under 7694, and it's my understanding the defendant is rejecting the offer.
So acknowledged she is, Your Honor, and we are ready to proceed as well. Thank you.
All right, very good. Opening statements, or are you waiting?
I'll do it short, Your Honor.
Pardon?
I'll keep it short, Your Honor.
All right, very good.
Your Honor, today we're here, it's been a trial. Today, the court will hear testimony from D'Angelina Terrell, who the court will hear was in a relationship with Mr. Savvy. They have 2 children in common. The court's going to hear from Mr. The events that occurred on September 24th, to include an incident with Mr. Savvy where she was pushed after trying to put their children to bed. And I believe at the end of this testimony, the court will see her testimony, see her demeanor, and find the defendant guilty beyond a reasonable doubt.
All right, very good. Mr. Would you like to give an opening statement, reserve, or waive?
I'd like to give one, Your Honor, very quickly. Your Honor, this case, as you heard counsel say, goes all the way back to September of 2024. At that time, my client, Mr. Rezavi, was and is a veterinarian, a National Guard veteran. He was living in Pittsfield Township, sharing custody with the complainant, Ms. Terrell, of 2 children that he thought he was the father of, and later learned that she had lied to him, was not the father at all, which I think will reflect on her credibility, which is clearly going to be an issue in this case. But nonetheless, they shared custody at that time, 50-50. He had the kids, and he invited Ms. Terrell over. You're going to find that their relationship was toxic, probably at best, but they still did sometimes hang out. And that night they were planning on hanging out a little bit, so we invited them over. The kids would not go to bed, being rambunctious because mom and dad were together. It was getting late, so John told her, "You got to go." Over the course of about 45 minutes, he kept saying, "It's time for you to go," for lack of a better legal word, revoking her ability to be in his apartment. She told the police she protested. She didn't want to leave. She wanted to hang out with the kids, and that caused some friction. As for what allegedly happened, Your Honor, my client will tell you that as he's standing in the doorway saying, "I'm going to get your purse, it's time to go," she loses her cool, smashes by him, pushes him up against the wall where he smashes his head and shoulder against the wall, leaving a divot in the wall and redness on his head. She runs, grabs the phone, and calls police. Now, what she tells police, Your Honor, is that he pushes her and that he smashes his own head against the wall, which I think the physical evidence, my client's testimony, and he will testify in this case, will definitely belie that. I'm hopeful at the end of this case, you'll find that this was toxic and this was immature, but this was not criminal, especially at Mr. Rezavi's hands.
Okay. May I call your first witness?
Thank you. People call D'Angelina Terrell.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
See, state spell your first and last name correct, please.
D'Angelina Brennan, Beangelena Brennan, but my former last name is Terrell.
Go ahead, you may inquire.
Thank you, Your Honor. And you go by Lena.
Yes,
Lena, do you know a John Rezavi?
I do.
How do you know him?
Bartender when we were both living in Manhattan, Kansas.
Did you have a relationship?
Yes, it was one of friends with benefits. I got to like a romantic relationship.
So you had a kid together? Okay. If you saw John today, would you recognize him? Is he in the courtroom right now? Can you identify something he's wearing and where he's sitting? And where's he sitting?
On the left side, the courtroom to the farthest left.
Okay. Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shall so reflect.
So I'm going to direct your attention now to September 24th of 2024. On that date, were you at 3341 Primrose Lane? And is that in Pittsfield Township?
Yes.
County of Washtenaw,
Yes.
State of Michigan? And on that date at that location, did Mr. Rice have you do anything to you that made you call the police?
Yes, so he had asked me to leave after putting against the bed, and I was trying to do so, but I didn't grab my purse. As I was walking to grab my purse, he had cut me off and started pushing me more towards the stairs. And it was like, I don't know how long it happened. I just knew that I started hearing the kids cry, And I told John, I was like, hey, the kids are watching their phone. He kind of sounded all of it. And then the walls were up.
Okay, so let's kind of start back at the beginning. Whose residence is that?
It's John's residence.
Okay, and how did you end up being at that residence on that day?
On that day, I went to class and we were in the middle of a quiz, so they said, you had work John on that. And he had asked me to pick up a target order that he had placed that was ready. And I told him I would do that. And he spoke on the phone. I asked him if the kids would probably like to know, because I didn't want to go inside. Because I knew that my presence would like rile them up. And I didn't want to stir them up right before bed. He told me they were sleeping. I had a clicker to his garage because it was kind of like a townhouse condo situation. So I opened the clicker, and before I could even open the door, our eldest son, Alexander, opened the door. And I told John, because he was standing there, I was like, don't worry about it, I'll just put him to bed for you. And then we could like kind of talk later, because the whole point of me being there was to talk. I forgot that part, but we were just gonna hang out and talk.
So then, sorry to cut you off. So you got it there. Kids are awake. You go in the house and you're going to put them to sleep.
Yes, I told him well, at the time I thought it was just one son, but then I saw the other son was awake too. So I said, I was going to sleep. And we could talk later. In the middle of putting Arthur to sleep, Alex had fell asleep. And John had came in, and he was just saying, like, they don't do this while you're here. It doesn't go like this. They're only doing this because you're here. And I told him it was fine because Alex had just fell asleep and Arthur was on his way to sleep. Like, just give me like 30 minutes and Arthur should be asleep. And the second time he came into the kid's room, that's when he asked me to leave. But at that time, Arthur was like 2 seconds away from actually like being into deep sleep, and I asked him if I could stay just a little bit, just so he could fall asleep, and then I'll leave. And he was like, no, you need to leave now. And I was like, okay, fine. And the way he was standing in front of the room entrance. And so I was going that way, and he was like, no, you need to leave to the bathroom. But the way that their door is set up is like, when the room entrance doors open, it blocks the bathroom doors entrance. So I moved the door.
The hallway door?
The entrance to the room door. Okay. To get into the bathroom, because the bathroom cuts out into like the little hallway that his house has. And so when I did that, he was like, bitch, did you just try to close the door on me? And I was like, no, I'm just trying to leave. And then he cut me off as I was trying to get to the kitchen to grab my purse and stuff. And that's when he started pushing me. And I kind of started pushing him off of me and asking him to let go of me. And he wasn't trying to let go. He was like, no, you need to leave, you need to leave, you need to leave. And I was like, I'm just trying to leave. I was like, I'm just trying to grab my purse. And that, I don't know how long that went on. I would maybe say like 2 to 3 minutes of him trying to push me and me trying to like get him off me, because the way that his house is laid out, there's like a small, short set of stairs and then a very long set of stairs, and tile at the bottom of those long set of stairs. And in that moment, I was scared that he was trying to push me down the stairs, because that's how badly he wanted me to leave. And like I said earlier, the only reason why he like kind of let go of me is because I said, hey, John, the kids are watching, they're crying. And they were, and they were really scared, and I called the police. And as I told John I was calling the police, that's when he decided to hit his head against the wall and said that I hit him. I was nowhere near him at that time. I was like as far away as I could be trying to call the cops.
So how did this whole incident make you feel?
It made me feel scared because like John and I have gotten into fights before. But like I never felt like my life was in danger. I think that was the only time I was like, wow, this man's really trying to hurt me. And I couldn't even tell you like what I did wrong to even make him want to like try to.
Your Honor, may I have one moment? And I know you mentioned your two sons. Are those two sons you share with Mr. Rysavvy?
Yes.
So he is their parent?
Yes.
Okay.
Bowser isn't his biological son. That's something we found out later down the road. But not at the time. We found out, well, John did a DNA test on Alexander, like a month or two after the incident happened. And found out that he wasn't his biological son.
Okay. And that's the older one?
Yeah, that's Alexander.
And the younger one?
Is Arthur.
And was the same testing done?
I just only know the one for Alex and not Arthur.
Okay. All right.
I have one more moment, Your Honor. Nothing further to this witness, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Mr. Brennan, good morning. Let's start with the location at Primrose Lane. That was Mr. Rysavvy's house, yes?
Yes.
You were not on the deed, you were not on the lease, you were not on any sort of documentation, correct? You had your own house or location elsewhere, yes?
Yes.
So I think you told the judge and the prosecutor, he told you to leave several times, yes?
He only asked me to leave once. And then when I was trying to grab my purse, because it was in the kitchen area, that's when he was like, no, you need to leave, but I can't leave without my keys or my wallet.
If I heard you correctly earlier, I think when the prosecutor was asking questions, you said, and I quote, "Give me 30 minutes." Is that correct?
Yes, for the kids, because he didn't ask me to leave at that time when he came in the first time. He was just getting agitated, saying that they will do this while I was here, like me.
So if you're asking to give me 30 minutes, what are you asking him to do? What?
I said, give me 30 minutes so I could finish putting our youngest son Arthur to bed. Because the whole point of me being there was to talk and hang out.
Okay, so give me 30 minutes is in response to him telling you it's time to go.
Didn't ask me to.
You use the word with the police, who I think Officer Branch is here over my shoulders, that you protested. I think that was your word on the video, correct?
I didn't protest. I just said that I wanted to finish putting them to bed because I was there and I knew the moment I left, it would rile them back up.
Do you recall using the word protest to the officers? I protested for 30 minutes. And ma'am, with respect to a 911 call, what was your intention in calling 911?
Well, one, I still haven't had my purse at the time to leave. So that was the other intention was so that I could be able to leave safely, because at that point, he just put his hands on me, he just tried to push me. I just wanted to leave.
So I'm curious, and why is the call and about him smashing his head in the wall repeatedly? Why are you telling the dispatchers that?
Because he just did that as I was calling them. Like the moment I said I'm calling 911, he started hitting his head against the wall. And that was very confusing to me. And so I let them know because I wasn't near them. In fact, the kids were the closest to me. And I informed them that that there were kids present and that what had happened was he was trying to push me.
I mean, you guys had a custody arrangement at that time, correct?
Yes.
It was 50-50, correct?
Yes.
In response to the question I think the judge asked you, you had told Mr. Rasevi that Alex was his child, yes?
Yes.
And he was paying support for him, yes? Continues to, yes? You had the children 50-50. This was his night on September 24th, 24, correct?
Well, so that's a little tricky because custody agreement actually states that on Tuesday, I pick up the kids from school. But because I was going to school at that time, I had asked him if he could additional.
So whose night was it on this night?
It's technically mine.
Okay. And this particular night, you guys had 50-50 custody, correct? Did you seek to try to change after this?
Not full custody, but I definitely felt like after this incident, John's behavior has grown increasingly concerning, to the point that the kids were coming and telling me very concerning things.
Now, Ms. Brennan, when you first gave the story to the judge, you said that my client had sort of his hands up and was stopping you from coming back into the apartment. Is that accurate?
I wouldn't say accurate. He actually like was pulling me by my shirt and then pushing me by my shirt, if that makes sense.
Did you have any sort of stretched out shirt, any marks, any injuries, anything that you could show the police to what we call corroborate that? Did you have any injury whatsoever?
No.
To your knowledge, did you see injury to Mr. Rasevi's head?
No.
But of course, your testimony is that he put his own head into the wall. Is that correct?
Yes.
Okay. I have no further questions.
I guess I'm trying to figure out. He asked you to leave, right? At some point.
Yeah, he asked me to leave and then.
But what was your response to him asking you to leave?
My response was, Kara just finished playing the argument that he's almost asleep.
Is that the give me 30?
No, that's not the give me 30.
Okay, so when does the give me 30 come?
That was prior. That was the first time he came to the room. He didn't ask me to leave, but he was getting agitated and saying that they don't do this while I'm here. And I just told him, give me 30 minutes and I'll be done. Putting them to bed.
And so how much time had passed before that comment and then him asking you to leave?
I wasn't aware of the time I didn't see, but I feel like it wasn't 30 minutes. It was definitely less than that.
When you said give me 30, what was his response?
He said, okay, and he closed the door.
And then at some point came back?
Yes.
Okay. So when he asked you to leave at that moment, I guess my question is why didn't you leave?
Because Arthur was still awake. His eyes were closed, but he was still awake. And I knew if I were to have gotten up, that would have just like kind of reawakened him. And that's when I was like, really just finished with him. So, and then I'll leave. And then he was like, no, he needs to leave down. I was like, okay.
Okay, so that was 2 times that he's asked you to leave because he said he asked you to leave.
Yes.
You didn't right then, right? And then he said, no, you need to leave right now.
Yes, and then after he said that, I was like, okay, fine, I'll leave. But then what I think kind of explained the situation when I was trying to leave out of the bedroom entry door. He told me not to do that. He told me to leave.
Where was your cell phone?
I think it was in my hand at the time. Because I had it in the room with me and the kids.
Okay. And then when you exited out, did you exit out the bedroom door or the door that leads to the hallway through the bathroom?
The door that leads to the hallway through the bathroom because he was standing in front of the bedroom.
Didn't ask why, but that's the door you exited out of.
Yes,
How far is the stairway from that door?
I would say that.
Okay. And then did you head down the stairway?
No, because I didn't have my purse in the room with me when I was putting the kids to bed. It was in the kitchen area on like the little countertop.
And is that on the lower level?
No, that's on the top level.
That's on the same level as the bedrooms?
Yes.
Okay. And so you said, let me get my purse. And then you went to get your purse?
I was trying to, but that's when he cut me off before I could even grab my purse. He started like pushing me more towards the stair area where the door would lead to. Like there's a short set of stairs, like 2 or 3 steps, and then there's a long flight of stairs after that leads to like the door.
Did you ever get your purse?
I did once the police were there.
So prior to that, you didn't get your purse?
No.
So did you leave the building?
I went down the stairs.
Okay, so hold on a second. When you went downstairs, your purse was still upstairs?
Yes, because at the time I was on the phone with the police.
So you called the police from upstairs?
Yes, because after he let me go, I was able to call the police. Because I was trying to get his hands off of me, so he wouldn't push me down those stairs.
Can I ask you, if you had your cell phone with you and he wasn't letting you get your purse, why didn't you just leave? And then, as you did, call the police from outside or wherever and ask them to come so you could retrieve your purse?
Because I didn't even get that opportunity. Like, once I went to the direction of my purse and he cut me off, that's when he started pushing me. And that's when the whole altercation.
No, what I'm saying is, okay, that happens. So why didn't you then turn, go down the stairway, go outside, call the police to then get your purse?
Because he was holding on to me, like he wasn't trying to let me go. I didn't have the opportunity to even like to fully even push him off of me so that I could even go down the stairs. The only reason why he let go is because the children saw what he was doing. And then after that, I went downstairs. Like I called the police, I started heading downstairs, getting my stuff on, and the kids too.
So Mr. Guerin had asked you about a custodial arrangement. And so this was a school day?
It was a Tuesday night.
Okay. And so the 50-50 arrangement at the time was what?
It was, so it was like Friday evening, Saturday, Sunday. Saturday, Sunday, every other weekend. And then.
Stop.
Sorry.
When you say every other weekend.
Right.
For him?
Yes, for him. It was every other weekend. I have a weekend He is a weekend, so we do 2 weekends with kids each month.
And then what happens during the weekday?
The weekday, he has them on Monday and Tuesday.
And this happened on Tuesday.
Yes.
So why do you say that was your day?
Because the way that our original agreement was laid out was that he has them until Tuesday morning, and then I pick them up in the Tuesday afternoon.
Well, that won't work, because really, the agreement would talk about overnights, right?
Yes,
So who had custody that Tuesday overnight? Look at what day of the week, September 24th.
yes. I did. It was my night, but I had asked him to take care of the kids because I have class in 3, so I wouldn't be able to take care of.
So suffice it to say, despite the agreement that when you requested that of him, he was to then take care of the kids,
Yes,
and they were gonna stay that Tuesday overnight.
yes.
And then again, why were you there?
Why was I there?
Yeah,
I had asked John, and he also had asked me to pick up his target order because he has 5 controllers for the kids, and I said that's fine. That I would do that.
okay. So you asked him to hang out.
So, yes.
So all of this, what time were the kids being put to bed?
I didn't get to his place closer to like 8:30, 9 o'clock-ish. I don't remember the exact time, but I know it was like late.
And had you picked up the target order?
Yes,
So it was 8:39. What times was during that time, the kids' bedtime?
I don't know how you guys are bedtime structured at his house, but mine's at 7 o'clock.
Okay, were they in bed when you got to his house?
One of them wasn't. Alexander, the oldest one,
How old is he at the time?
he was about to be 6, and he was 5.
Okay.
He was 5, and he was up. He had opened the garage door for me before I could even open it.
Okay, so at some point, but I mean, they're dressed for bed.
Yes, they were dressed for men. But I had informed John to let me know if they were up, because then I wouldn't have anything inside. Because I knew that I would roll them up. He was assuring me that they were in bed. Right. And so when they saw me, they're like, "Oh, mom's here, mom's here." So that's when I was like, "Oh."
Any questions based on the court's question?
None from the people you're asking.
Nor do I, thank you.
You step back. Call their next one.
People no further witnesses, Your Honor.
All right. Witnesses for the defense.
Your Honor, this time we would call John Resident, please.
Sir, please come forward.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
So have a seat. State and spell your first and last name.
John Recipe, JHN, RY.
Inquire.
Thank you, Your Honor. Mr. Reserve, good morning. Ask you, do you remember the events that occurred, did or did not occur on September 24th, 2024 at 9:40 p.m.? Just going to ask you point blank that night, John, did you aggressively push Miss Terrell Brennan at any time that night? Did you aggressively grab her sweatshirt, tug her sweatshirt, pull her in any way? Did you, I know it's a legal term of art, do you believe you assaulted her in any way? Were you violent towards her? Did you intend to harm her? Did you threaten to throw her down the stairs? Did you smash your own head against the wall? We're going to talk about all that in some details. Let me ask you a couple questions about you, sir. How old are you? And at the time, I'm guessing, what, 32 or so, yes? What do you do for a living? How long have you done that? I mentioned you're also a military veteran as well. What branch? Are you still in that or no? We heard some questions about Miss Terrell Brennan and your relationship with her. You two were never married, correct? Just very quickly, did you believe you had two sons with Miss Terrell Brennan? When did that change for you?
In November of 2020.
And we heard some talk about a DNA test. Did you take a DNA test?
Yes.
Was that self-initiated?
Yes.
And did it, in your mind, prove that the oldest Alex was not your biological son?
Yes.
Had Miss Terrell Brennan previously told you that he was?
She did.
Did she fight that he wasn't your son at that time?
She refused to believe the first test.
At the time of September of 2024, is it accurate to say the two of you had a 50-50 custody arrangement?
It is.
Heard the judge ask us some questions. September 24th, do you recall if that was your night, Miss Terrell Brennan's night, or you don't recall?
I don't recall.
Okay. But were the children at your Primrose address?
They were.
I asked her that she had Miss Terrell Brennan had a separate apartment or separate location, yes?
Yes.
I want you, from your own perspective, to tell the judge what brought you two together that night.
We were going to have sex.
And who initiated contact?
She did.
And so was the plan to meet up after the children were asleep?
It was.
And do you recall what time she arrived?
It was approximately 8:30.
Were the boys sleeping at that point?
I thought
Okay. They were in their rooms?
Yeah.
Okay. And so what happens after Miss Brennan arrives?
I go downstairs to greet her. When I was doing that, Arthur, our youngest, was the one that woke up. And then she must have spoken to bed.
Okay. And I guess I'd ask you from there, did the night start to change a little bit?
After waiting for I wanted to get to that because I wanted to get to that.
And you said waited for what?
For her.
Okay. At any point, Mr. Rezavi, did you ask Miss Brennan to leave?
I did.
How many times would you say you asked her to leave?
Well, I did it over again. Probably at least 10 times.
Getting back into your mindset, why were you asking her, telling her to leave?
I wanted to go to bed. I was tired. I wanted to get the kids to bed because it's going to be early morning.
And you said, asked her many times, did she agree?
When I told her actually to leave, she stormed out the bathroom door. Was starting to go downstairs, turn around, told me she could just look. I told her, I'll grab it, leave. She continued and tried to force her way through me. I held my ground with that. And then during that, I had my hands up and locked myself. My hands pushed down. I snagged my thumb on her hoodie, at which point she yells, "Don't fucking touch me." And then she began to hit and shove me. And then I started, retreating on back.
about 8 to 10 feet.
All right, lots to unpack there. We heard some conversation from her earlier that she said, you know, give me some time, give me 30 minutes. Do you recall that statement? Okay. You said a second ago to the judge that you said, I'll get your stuff. What stuff were you going to get for her?
She had her purse. She also had a lock on that I didn't realize she had brought with. She received that. So the purse I gave to her when she finally decided to go down the steps. I grabbed it, tossed it in a little square where the stairs changed direction for her to grab. I didn't realize she had a water bottle. Police told me that it was still there, so I gave that to them, and then they returned it to her.
All right, if we can back that up a little bit. At what point did you give her the purse back?
After she was shoving me, I hit my head. She called the cops, and then she left. So once you grabbed it.
Okay. Going back in time, when you say you'll get her stuff, why did you not want her coming back into the guts of the apartment?
She's taken things before. Did you get a ring?
Did you say a ring? And so when you tell her you'll get it, does she allow you to go get it for her at that point?
She would not. She told me to do it herself.
Okay. I want to ask you about the physical contact in very specific detail. I know I asked you this from the start, but did you sort of stop her physically by putting your hands on her?
I put my hands up. She was the one that was coming to me.
You indicated a second ago that your head hit the drywall. Can you tell the judge exactly where that occurred, how that occurred?
So everything started near the edge of the stairs. After she started pushing and shoving me about 10 feet, 8 to 10 feet from there, I ended up losing my footing and my head hit the wall along the shoulder.
Okay. Do you recall what shoulder it was? Okay. So your right shoulder and your head, what side of your head hits the drywall? Did you do that of your own intention? Did you do that on purpose? Did you knowingly smash the side of your head into the wall? You said you lost your footing. Was that after she, you believe, touched you in some way?
Yeah, she was in the process.
I'm going to ask you about sort of damage in both respects. Did the wall become damaged? And did your head or side of your head become injured in any way?
It was red. I had a bit of a headache.
Maybe short circuiting a little bit. When the police arrived, I believe it was Officer Branch who's over my left shoulder. Did one of he or his partner take pictures of the scene?
They did.
Did you get pictures of the damage as well as to your head?
Yes.
Here I'm holding what I will mark preliminarily, if possible, as Defense Exhibit 1 or A. This is a picture that was in discovery, and I wonder if I may approach the witness with it. Okay, thank you. Mr. Arcevi, I've handed you what's been marked as, for identification purposes, Defense Proposed Exhibit A as an apple. Do you recognize that picture? And can you tell me what that picture or those pictures are?
One is of my forehead, the other is
And do those pictures accurately depict what you recall them looking like, whether it be the wall or your head on September 24th, 2024?
Yes.
And is the top picture the damage to the wall?
It is.
Had that damage been there prior to the altercation between you and Miss Terrell? The picture of you, are you able to see any injury, redness on your head in that picture?
I am.
Was that injury or redness there before the incident with Miss Terrell? And do you believe then that those pictures accurately depict what happened to the wall and to your head that night? I would move for admission of Defense Exhibit A.
Any objection or voir dire? Exhibit A is admitted.
Thank you. Mr. Arcevi, as I sort of finish up here, I want to talk about the call to the police. Where was Miss Brennan when she called the police?
She was in between between stairs and where I hit my head. So near the bathroom door.
Did she have a cell phone with her?
She did.
I guess, some questions about, asked her how she felt. How were you feeling at that moment when she was calling the police?
I was in shock.
Shocked because of what happened? Shocked because she was calling the police, or both? Now, I asked you some questions about the police arrival. Either Officer Branch or Escobar from Pittsfield did respond to the scene, yes? Did you cooperate with them to the best of your ability? Tell them essentially everything that you could remember about the incident? And were you honest with them? Okay, and honest with the judge today? Okay, Your Honor, I have no further questions.
Examination.
So, Mr. Rice, have you mentioned, am I saying that right?
It's recipe.
Recipe? Recipe, okay. So you mentioned an incident in this narrative you put of someone hitting you, shoving you, you snagging your thumb on her sweater. Is that correct? Did you mention that to the police when you made the initial statement? And you mentioned also your shoulder from falling into the wall. Isn't it true that you told them that was hurt from something else previously than this incident in the body cam? Wait one moment, Your Honor.
Sir, the layout of this location, is everything upstairs?
So the garage is below. There's the door and the stairway goes out to it.
Gotcha. Okay. And was the person in the kitchen area or, well, where do you think, where was her purse located?
The purse was in my bedroom.
So it wasn't in a kitchen area? Did you tell her to leave through the bathroom?
I didn't tell her specifically to leave the bathroom.
You didn't what did you tell her?
I told her to leave. And then she got very angry.
Between the two of you, physical contact between the two of you took place in the hallway area? Is that correct?
Correct.
Were you not supposed to have the children that day? Do you recall?
I didn't recall.
You don't recall? All right. After this, was there then any other like family court actions or anything that occurred between the two of you?
March, we had front of the court hearing, and then it's March of 2025, September of 2025.
Okay, leading up to the March hearing, how was that initiated? What happened?
She initiated it after I was not being biologically mine. I was saying the kind words about her.
Okay, so this incident happens at the end of September. Sometime in November, there's the DNA test.
Correct.
All right. After the DNA test, then within 3 to 4 months after that, you guys are back in court.
Yes.
That hearing, from your perspective, what was the purpose of that hearing?
She wanted to adjust the parenting time.
Both or for what? Adjust it from 50/50?
Yes, from 50/50 to our current arrangement, which is every other weekend. She has them.
Say again?
I have them every other weekend. She has them the rest of the time.
So she wanted it adjusted from 50/50 to basically a 65/35.
Correct, yeah.
During the course of those, you actually had a full hearing before a referee? All right. Did you have a hearing before the judge then?
No.
Did this case or this incident become a subject matter of that hearing at all?
I didn't know it was.
Pardon?
It was not brought up.
It was not brought up. Okay. You didn't require any medical care, meaning the hospital or anything like that that night?
When I was arrested, I did go to the hospital when my blood pressure was.
Pardon?
I went to the hospital after being arrested, my blood pressure.
For blood pressure. So prior, it's gonna sound like a strange question. Prior to this time, to this September 24th day, were there calls like this before for you guys to get together to have sex, or? There were? Would that occur always at your house or at her place, or how would that work?
Primarily.
Pardon?
Primarily.
Primarily at your place. And who would initiate those calls?
We would both.
Both do it. Okay. And on this occasion, she initiated the call.
Correct.
On those occasions, or let me ask you about this one. Was it going to be have sex and then leave, or was she going to stay the night? What typically would?
She would generally leave.
She would leave. Okay. So no further questions. Any questions based upon the court's questions?
No, Your Honor, thank you.
All right, thank you. So you may step now. Any additional witnesses for the defense?
There are not, Your Honor, thank you.
Your Honor, maybe.
May.
Oh my God. Oh, it's beautiful.
One thing that's not done is the paint. We want a different color. Okay. Oh, no, but it's a functioning bathroom. It's beautiful. So that's the thing. Yeah. And then also there's that also just needs. Oh, how happy are you? Ooh, nice drawer. Lowe's. Okay. So. Puppy. No, that's, oh, is this the other one? Oh, I really like the flooring jokes.
All rise. 14A, District Court for County of Washington, State of Michigan, not accept the
May be seated. All right, back on the case of people versus, say it again. Resume. All right. Closing argument.
To leave this in the discretion of the court.
I will escalate, thank you. Court was going to take a break and contemplate the decision. I don't think that I need to. In listening to the testimony in this case, and quite frankly, the defendant is in his home. There are 2 children there. Mr. Terrell's rendition of the facts and circumstances don't make much sense to this court as to why she didn't leave when requested to leave. He had the absolute right to ask her to leave the home. She did not leave. Also, the location of her purse, she says it was someplace else other than where the defendant says that it was. And quite frankly, I think that the testimony and credibility of the defendant far outweigh that of Ms. Terrell in terms of the events as they occurred, the timeline of what occurred, and what he was then requesting that she then leave at some point because she is there, and I got the sense way too long. I don't believe at all that the defendant in some way started throwing himself into a wall to cause damage, which just, I guess it could occur. I don't believe that that's what happened here. I think it was, as he stated, he lost his balance, came back, fell against the wall as there was this dispute going in. And quite frankly, given the entirety of the circumstances, it was incumbent upon Mr. Terrell to leave the premises. As indicated, it was his premises. The kids were there. She, at the point he asked her to leave, did not, and she did not, he did not, she did not have a right at that moment to then be there, regardless of what she may have thought about giving 30 and doing whatever. So for those reasons, the court would find, and I'm just be honest with you, I don't have a lot of credibility in anything that she's saying when I'm looking at her testifying and what she's telling the court. And so for those reasons, the court would find that the people have not sustained their burden and would find the defendant not guilty of these offenses. Thank you. You're not on a tether, are you, sir? No, okay. Thank you.
Every day in the USA, people find themselves in court.
All right, I'm going to start at the top of my calendar with Rachel Berglund and Simon Ionashku.
There we go. All right. Now, this is going to serve essentially as a guide for the rest of you as well. What we're going to do is I'm going to swear both sides in. I'm going to take testimony. And after I'll start with the petitioner, I'll hear from the respondent. I will give the petitioner one last chance to wrap everything up. There are, looks like exhibits. Let me know what's important about these exhibits in your testimony, all right? Okay, would both of you or each of you raise your right hand, please? Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I swear.
All right, thank you. You can put your hands down. All right, and one thing I didn't say, but need to make absolutely clear, we only have a few hours this morning for these. Testimony doesn't get to go on for ever and ever. Try to, and it's not always possible, but try to make it brief, but on point. You should anticipate, even though I've reviewed records, you should anticipate that I haven't looked at anything. I need to hear what's important, what happened from you, because you're here. Okay. Rachel Berglund, you will start. What is it that you, this is a motion to renew a protection order. What would you like me to know here?
Your Honor, for context, the respondent had previously to this current protection order had been stalking and harassing me for about 8 years or so, including following me when I moved to different states, then sending me random items in the mail, clearly indicating that he knows where I live, sending emails after I had asked him to not message me ever again or contact me in any way, shape, or form, proceeded to send over 100 emails full of inappropriate, just paragraphs of like super graphic, inappropriate stuff, including images that were AI generated of me being naked, and other pictures of himself. Probably there was a lot that I didn't look at because it was so disturbing and disgusting. So despite me asking to stop contact, there was like considerable harassment, causing me to fear for my safety on a regular basis. Since then, there was the protection order that was granted last year, and the judge last year said that this is the type of behavior that results in like worse things happening, that I should like, you know, what did he say? He said that the respondents should get help and that this is a serious threat, and that he feared for my safety even, which was really validating because doing this whole process is like really scary and really stressful. So I appreciated that the judge could clearly see that there was something wrong with how I've been treated by the respondent. Since then, when the protection order was granted, or last year when he was emailed the the request to show up to court, even though he had already received it and seen it, still proceeded to send me another email, like further contacting me, even though he had received notice that he was to not contact me and come to court. So hence violating the temporary protection order that he was given. And I've also received like strange things in the mail. And so I have no way to prove that that was him, but that was something that he had done before. And to me, it feels like if someone's finds ways to like make me question my safety, even though there's a piece of paper that's supposed to protect me, but I can't prove, it causes a lot of anxiety and fear on a regular basis. I would really appreciate if this protection order could be renewed, because I don't think that if it were to go away, that the harassment would just stop. I think that it would either amp up or absolutely continue. If it happened for 8 years, it's not just going to go away.
All right, thank you. Mr. Ionescu, did I say that correctly?
Yeah, it's pretty close. Ionescu.
Ionescu.
Yeah, it's a weird last name.
Okay. Well, I try to get it right. All right.
Okay.
You are the respondent. This is your turn. What would you like me to know?
Yeah. So first of all, I just want to point out I have maintained no contact. I've not violated the order in any way, and that's because I have moved on. And there's no need for renewal because there's no threat. There was actually never a threat to begin with. I mean, there was, I communicated and I over communicated with Ms. Berglund for a long time. Of course, all she heard is, "Oh, he's a psycho." Yeah, look, I could sit here and I could, huff and puff about the exaggerated claims and like the false narratives that she constructed in her report. like they did. I moved to states to be closer to her. I moved to California because my two best friends moved to Silicon Valley, and I was wanting to do a startup. I was working for a startup. Like, I didn't move there for her. Okay, like that's absurd. So I mean, she's just exaggerating and making all these claims, but at the same time, I do understand why she is, exaggerating everything that happened between us, because I scared her. Okay, I did. I have to own up to that. I mean, last year I tried to apologize, and the judge said I was trying to maintain a relationship with her. I just wanted to say, oh, sorry, but whatever. So look, I will absolutely leave her alone. To be honest with you, look, there was actually, some substance abuse involved in some of the emails that I sent her. And the only reason I was sending her all these emails was just because, for whatever reason, Your Honor, whatever reason, interacting with her improved my creativity. She has inspired an idea that I think has the potential to have a big impact on the world. And I just, I communicated and over communicated with her on all these things. And I think, honestly, on some level, I'm almost glad it happened, because it led me to, well, things got much worse before they got better, especially after the video from last year. This trial went viral, and I started getting like all of my social medias were just attacked on the internet. I was attacked as people were in my comments, and I had to turn all my social medias private. And I think some of those were probably coming from people in her camp. I don't know who she told or whatever. I mean, she's been in the military, and I suspect she got her group of friends to send me threats. I got all kinds of threatening emails and everything else.
So on topic, please.
So my point is, like, that alone is like a big deterrent, but also we are 2,000 miles apart. Like, I live in Tennessee. She lives in Washington State. Like, the distance alone is a natural barrier. And like, look, I would never do anything to harm her. Like, the only reason that I was sending her emails is because I thought she liked it. Okay, I thought she liked it. And a very important point that I want to make here, and this is absolutely critical, is that yes, technically she told me to stop. Okay, I sent her about 115 emails in total. Around email 63, she told me to stop. Okay, and I didn't stop, and I should have. Okay, I acknowledge that. But the reason I didn't stop was because I was sending her money. Okay, and if you look at the exhibits, you can see royalties to Miss Berglund. You can see Venmo payments that I sent her at the time. She didn't say anything for over a year and 3 months. She said nothing to me. Okay. She was just quietly accepting the money. And that's where I think that plays a really critical factor in this whole misunderstanding is, I thought, well, she's accepting the money. And then she was kind of posting, she unblocked me after that. I sent her money and she unblocked me on social media and started posting pictures, almost like she was cooperating, like she was okay with it.
Did I hear you say those were royalty payments?
Yeah, I called her my muse. I said she inspired my work. I thought she was into it. I didn't realize, it was causing so much fear and anxiety. I don't want her to fear for anything. That wasn't my intention. I thought, we were friends. We were neighbors years ago. We got along. We hung out like all the time. We used to go boating together and everything else. I thought she was like, but look, it doesn't matter. I've moved on. I will never contact her again. There's no need for a renewal. This is impacting my personal and professional life. People are really questioning my character for over a misunderstanding. I just,
right.
This is too much.
Is there anything else you would like me to know?
Yeah, well, I mean, okay. So one thing I will say is, I did when I reached my low point, I went into counseling and I didn't realize. I thought my only problem was ADHD, and turns out I might be she seems to accuse me of being she seems to think that I'm like a narcissist or like a psychopath or something. But this is a very common category error for certain symptoms overlap. Turns out I guess I'm a little bit autistic, a little bit somewhere on the spectrum. And I think that probably played into my ability not to fully how do I say this? I have a hard time kind of picking up on social cues, I guess, sometimes. And I think I totally screwed up. I did not mean to scare her, Your Honor. I did not. I actually thought she liked it. I really did. I thought she liked it. I thought she was into it. And I misread the entire situation. And this is just a big misunderstanding. That's all I want to say. Yeah.
All right. Thank you. Ms. Berglund. And you don't have to say anything, but if there is anything you want to say to wrap it up, it's your turn again.
Your Honor, I don't think there's really much for me to say other than that me saying do not contact me in any way, shape, or form. If I am contacted, I will be considering it harassment is pretty clear and not that easy to misunderstand. And I believe in your ability to judge the situation, Your Honor.
All right, thank you. Okay, I am going to reissue this order. And it'll be just a moment while I fill out the paperwork. If, as you indicate, Mr. Ionescu, you do not wish to be contacting her, then this should be a simple year where you just don't have any contact. That makes it really simple.
Yeah. I mean, at this point, the damage is done, If it makes you feel safer, that's fine.
Okay, since both of you were present, neither of you, I have signed that order for 1 year. Neither of you needs a copy, but both of you can get copies from the court if you would like. The order is renewed. That will be it for this morning. Thank you. Next will be Michael Elm and Daniel Wisnant. Good morning again, Mr. Elm. Daniel Wisnant.
Yes, sir.
Good morning. I don't know if you heard my very brief introductory remarks. You signed on just a tiny bit late, but I'm just going to repeat it here. The way this is going to work, I will swear both of you in and take testimony first from Mr. Elm, then from you, Mr. Wisnant, and then return to Mr. Elm for a rebuttal, if any. You should each assume, even though I usually have reviewed all of the documents, you should each assume that what I will know about your case is what you are telling me. And so if there are exhibits that are important, you will need to tell me why they are important and tell me why this order should or should not issue. Okay, having said that, would each of you raise your right hand, please? You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do. Okay. Before we begin, before I start taking your testimony, Mr. Alm, do you still wish, looks like this is a motion to renew the order. Do you still wish to renew it?
Yes, sir.
Okay. And all right, let's hear your testimony, Mr. Alm.
Thank you, Your Honor. This protection order, the 1-year protection order was issued last March. The basis for it was multiple threatening statements that he made, threats of bodily harm to me. He made these statements not directly to me, but to his now ex-wife, who is a friend of mine. We were also co-workers for several years. In some of these statements, I'm sorry for the very vulgar language here, but to quote him, and some of the things that he said was that he was going to, quote, fuck him up and, quote, fucking crush his fucking face and, quote, go to prison for knocking fucking dick faces fucking teeth out. He also described having a confrontation with me at church, at home, or out on the street somewhere. In one of the messages that he sent, he said to his ex-wife, and I'm for sure not driving around trying to track you down, get over yourself. I'm just going to do my best to have the face-to-face with Elm. If it's at church, so be it. This all began because of an imagined affair that he thought I was having with his now ex-wife. A couple months before that, he imagined that she was having an affair with with her previous ex-husband. A few years before that, he imagined she was having an affair with a doctor that she worked with. That's what led to this. And he was making threatening statements to her at the same time that he was making these threatening statements to me. And she got a domestic violence protection order issued back then, and that was just renewed. And so that's a little bit of the history for the origin of the protection order. And from reading his declaration, it's apparent that he believes that by bringing up things unrelated to this protection order, he can call into question my character and discredit me and distract the court from his history of violence, including beating a man with a wrench years ago, his long history of drug abuse, his lack of empathy, and his failure to take any accountability for his actions. Despite his ex-wife having a protection order against him that required him to undergo drug abuse evaluation and treatment, as well as mental health evaluation and treatment, he has not complied with those requirements. And that protection order was just extended to 99 years within the past few weeks. His complete disregard for those requirements demonstrates he has no desire to accept responsibility for his actions. He has not expressed any remorse regarding the threatening statements he made and actions he took toward me, but rather he's trying to pass it off as hyperbole during a, quote, emotionally charged conversation. That's from his declaration. I want to first address one completely unrelated issue that he submitted along with his declaration, which he is attempting to use to paint a very unfavorable picture of me. Within this portion of his declaration, he made multiple false statements. So 6 years ago, I had a brief relationship with an employee where I worked. At that clinic, all the employees received free medical services from the providers on an informal basis. Because of that, the employees were all technically considered patients. At that time, I did not realize that was the case because the minor services we provided were done on a casual basis without appointments and no charging or anything like that. Over 3 years after that relationship ended, that person was prompted to file a complaint with the DOH, and that's what led to my 6-month license suspension. I was not deemed a, quote, sexual degenerate by the DOH, contrary to what Mr. Wisnet asserted in his statement. The record at the DOH confirms that this was an employee. Additionally, his statement, he stated that there were multiple complaints against me at my former office by coworkers and patients. That's completely false. Because this issue is completely irrelevant to the protection order being discussed today and inappropriate, in my opinion, to be included in these records, I do request that his statements regarding this be redacted from the record, and I additionally request that the copy of the DOH record that he included with his declaration be removed from the records of this case. Mr. Wisnick has claimed that the original protection order was based solely on hearsay with no witness testimony. It's not hearsay when I have the actual text messages and voice messages that he sent. In addition to the things I printed, I also had submitted a USB drive a year ago with the voice recordings. I also could have provided witness testimony today, but this declaration of his was only served on me about 12 hours before this hearing, making that impossible. He claimed that his texts and voicemails were taken out of context, which is not the case. He made threatening statements about me at the same time he was making threatening statements toward his ex-wife. So his statements made toward me were frequently mixed in with those directed toward her. I do not believe there is any context that would make it okay for him to say things like he wanted to hit me so hard I'd feel it forever, and the other things that I already mentioned earlier. He claimed in his declaration that his words do not constitute a direct threat to me and therefore do not justify a protection order. This is an invalid argument. If he were talking to a mental health provider and made such statements to them, that provider would be obligated to notify me of the imminent threat. His words would not be protected by HIPAA. Therefore, even though the threats were not spoken directly to me, it does not make them any less real. He also stated that he did not take any action to justify a protection order. Again, this is not true. He showed up at my house, apparently not knowing that I had already moved out of there. He also tried calling me multiple times in a row, despite not previously having my cell phone number. He had to deliberately put effort into tracking down my personal cell phone number in order to make those calls. He also tracked down the personal cell phone numbers of my former coworker and his wife and called them, trying to talk to them about me. He also called my former workplace multiple times wanting to talk about me. He also showed up at my former office and wrote graffiti on the walls there. And he also posted a defamatory fake advertisement in Shelton about me. Mr. Wisnet has also decided to believe that his ex-wife had an affair with me. He also believes, like I mentioned before, that around that same time, like a couple months earlier, that she had an affair with her previous ex-husband. He also believed a few years prior to that she had an affair with, this is a pattern of behavior of his. And the fact of the matter is he is the one who had several affairs while he was married, which he has admitted to. But for years, he's projected onto his now ex-wife, accusing her of being the one who was cheating. It is true, like I said, that I worked with his ex-wife and became friends with her. And in the fall of 2024, she helped me out while I was moving, including letting me temporarily forward mail to her house. Mr. Wisnet stated there's no reasonable basis for my fear, partly citing the lack of contact with me over the past year. However, lack of contact does not demonstrate there's no risk. It simply demonstrates that the protection order has helped to keep me safe. Just knowing that there was a possibility of him being present at this hearing caused me daily anxiety for the last couple of weeks. And since receiving his declaration about 12 hours ago, I have felt continually anxious, jittery, and sick to my stomach, which is currently the case. presently the case. He is a physically intimidating man, twice my size, who has a history of violence, holding grudges, and drug abuse, which makes him even more unpredictable. He continues to believe things that are not true. He takes no responsibility for his actions, and he has still not sought drug abuse and mental health treatment. These things all contribute to making him a continued threat to me. Additionally, right after he was served with the paperwork for this hearing, he started calling his ex-wife's adult son. Over the past year, he's continued to pester him. This shows his inability to let go of issues. He has not demonstrated in any material way that he is not a risk to me. In fact, his complete disregard for the terms of his domestic violence protection order demonstrates he does not feel the need to make any changes. I have taken several steps to try and minimize the risk of him ever having any contact with me, including trying to keep my new address private. At the initial filing of the protection order, I provided ample evidence to justify the protection order, contrary to what he said in his statement. And the court has all of this on file, and I believe the burden of proof now rests on him, and he has not provided any evidence that he is no longer a threat. Rather, his actions speak otherwise. Thank you, Your Honor.
All right, thank you. Mr. Wisman, just a moment before I take your testimony, I have a question for my clerk.
Okay.
Okay, returning to this matter, that did go a little long there, Mr. Elm. I understand you are pushing to have this move forward, but I don't want to. I have to get everyone heard before the end of the calendar, and I don't want to cut anyone short. So just keep that in mind, please. Mr. Wisman, your turn. What would you like me to know, please?
Where to start off? First of all, I mean, I don't intend, or I don't have any interest in Mr. Elm, or Ms. Pittman for that matter. So I'm sorry, this is a little much, but you know, when I came home, I worked on a boat in Alaska, and when I came home, I came home to find out that forgery had happened with the divorce. She had forged stuff, and then there was theft of my bank account, and I came home to something unexpected, you know, and I, you know, me and the ex-wife, like, we had our text messages, you know, that we had between each other, and yes, they did get inappropriate between me and her. But there was I never made threats to him, like, publicly to anybody or anything like that, you know, and when I found out that he was staying at my house, and found out that he was getting mail sent to my house, I did want to talk to him. And like I said, you know, there's no excuse for messages that I had with my wife, like the language and stuff that was very inappropriate. And on that matter, it was a lot of it was like a tit for tat. And like I said, I'm not trying to make excuses for the language that I use or anything like that, but it was like, that was kind of like what we had between each other, you know, and it was not right, you know. So there's no excuse for that. But, you know, and then I ended up getting an attorney, and I was misrepresented by the attorney. So I don't think I was represented well with that, what happened with me and the ex-wife. So anyways, so, and there's no accusations. A lot of this is hearsay, I feel. And I don't know what else to say besides, I mean, I have plenty to say, but I don't intend on causing harm or making contact or anything with Mr. Elm. I do not have any intentions like that. And I would like this to be, for this order to not happen because, you know, my rights are taken away and I want my rights. So I guess that's it at the moment.
Okay. Before I return to you, Mr. Alm, you both mentioned hearsay, but evidence rule 1101C3, hearsay can come into protection orders. So if you're going to be making legal arguments, this is why you really should not be representing yourselves, because I would rule that it comes in both those instances. All right, Mr. Elm, anything to wrap up?
Thank you, Your Honor. I just wanted to reiterate that that the hearsay is an argument that he made in his declaration, and like I said before, hearsay, none of it was hearsay. It's all written audio recordings.
No declaration was filed with the court.
I'm sorry?
No declaration was filed with the court.
Oh, okay. Well, he had this declaration served on me by the same person that served my paperwork onto him. Would you like me to forward that to the or no, I guess I shouldn't because like I said, I would request that that not be allowed because there's inappropriate things that are irrelevant to this case that he included in it. But I think I've already made a rebuttal to all the arguments that he made in his declaration, which I now understand you do not have. But I don't think I have anything further, Your Honor.
Okay.
Your Honor, I do have a question. Since that declaration has not been filed already, if it gets filed later or something, is that going to automatically become a part of this, or is it not going to be admitted as into the record?
I do not have it, so I will not be considering it. However, anything that does get filed is part of the court record. You would have to file a separate motion to seal, civil motion to see what might occur there. I am not going to decide in advance without consideration of the merits. I simply don't have a written motion in front of me on that, but at the moment, none of what you mentioned is in the court record. All right, I am ready to rule. I am going to reissue this order for 1 year. And I am doing this primarily as a precaution. I do want to take a look at the previous order, but my concern would be that even though it was arguably delivered late as part of this case, that declaration, since it didn't come to the court, sounds as though it was likely inappropriate. Now, you did rebut it, Mr. Elm, and I am not considering it. I am troubled simply by the fact of its existence with it not being filed with the court, not the content. I did not hear sufficient testimony to lead me to believe that there won't be any ongoing contact. As far as rights, this is an anti-harassment order. I am not requiring any surrender of weapons. Nothing of that sort. Mr. Wisnett, you'll simply need to not contact Mr. Allen and don't go near him. If you see him, go the other way. So really, your rights are minimally restricted. Just leave them alone.
Yes, Your Honor.
Okay, since you both appeared, neither of you has to get a copy of the order, but copies are available from the court if either of you wishes to have an order. Oh, actually, I may have left a box off on that. Let me take a look. I got it on there. Thank you. Okay, that will be it for today for both of you. Mr. Wisnett, I know you're disappointed. Mr. Allen, that might not even have been everything you wanted, but that is what I'm going to do. Hopefully, this ends it. And it sounds as though Mr. Wisnett is, at least with regard to you, Mr. Allen, hopefully remorseful for his actions. So hopefully this won't come up again next year. All right.
Thank you.
Thank you. Have a good day. I believe that takes us to the one remaining case. And I see both sides are still here. Thomas Soto, please step up to this table. And Darla Hatcher West, please step up to this table. And sir, your name is not Darla Hatcher West, so yeah, please have a seat back.
Hearing, so I wanted to get a little closer.
Do we have a hearing device? Yeah. You can be seated. Yes, we're just testing the device to make sure it's working, and that one is not. I have these wonderful hearing aids. I get to hear everything. I just turn them up. But... Okay, now we're testing again to see if this other device is working.
Not working.
Uh-oh. It may have been a while since their batteries were charged, perhaps. Okay, and we're trying again with another one. Okay.
Wanted to use this, this should allow you to hear a little bit better.
Just went past you. Sorry for that. All right, hopefully everyone can hear now. Is the gentleman a witness, or are you going to be wanting him to testify? Okay. When the time comes, I'll swear him in at the beginning, but when the time comes, you'll need to have him step forward, and you will have to ask him questions, and Mr. Soto will be able to ask him questions. I may ask questions as well. All right, let's start. All three of you, please raise your right hands. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes.
Okay. You have each seen this a number of times now, so you know how it works. I start with Mr. Soto, and then I turn to you. If you have a witness, we can hear from your witness. As I just said, you will have a chance to cross-examine the witness as well. You should each anticipate that I haven't reviewed the documents. I have, but that's kind of beside the point because we have people here to give live testimony. So, all right, Mr. Soto, please.
Well, basically, I want the protection order to stop the harassment that's been happening ongoing for, I'd say, about 8 months. And the evidence I turned in, it's not all of it. It's just a part of it. So I wasn't sure how much I needed just to get the protection order granted. If there is more needed, I would need time to gather the rest. Basically, it was 6 months of text messages that were harassing constantly from the respondent to a number of things. It was ongoing. I've asked her to stop. She wouldn't stop. And then once I finally blocked her number from mine to not call my number, she proceeded to text my kid's mother, who also lives with me, and just say all kinds of things to her, like I'm mentally abusing her for some reason. I'm physically abusing her. What's my name? Is it Thomas my real name? In fact, what are we hiding down there on the property? She's going to find out what we're hiding soon, and that we're all probably illegal immigrants. So there was that. Once she was unable to text me anymore, then started the in-person contact of yelling at us, screaming from a distance, and then coming to our driveway at 12:30 and at midnight, after midnight, 12:30, 2 times in 1 week. And in the same week, there were 2 incidences at 5:30 in the morning, the exact time that me and my son leave for work and school in the morning, so that we could be yelled at again from the shadows of the darkness of her yard. Things like, well, besides profanities, things like we don't have permission to be here. We don't have permission to stand on the porch. We don't have permission to do this, do that. I couldn't understand most of it. And a 5th time, even the same week that I filed this petition, once was at my daughter. My daughter was doing yard work on the side of the house, and the respondent went down the private easement that there is to another property behind hers, and proceeded to yell at my daughter, saying she doesn't have permission to do what she was doing, yelling at her and then calling her profanities and names. My daughter just stopped, looked at her, smiled, and continued on, was about to report, but then she drove off. The times at 12:30 at night, one was just to argue, to do nothing. The other time was to drop off some kind of plastic bag with stuff in it on the porch, and then you talk and say some statements and profanities into my camera. Even when the sheriff showed up a few days after that week, as he was showing up asking me about one of the incidences, she proceeded to yell at me or him or all of us at that time. The sheriff was trying to listen to what she was saying, and I just said, I really don't care. At this point, it doesn't matter what she's saying. It doesn't matter to me. It's better for me to ignore it and not get upset over it or to react. And he yelled out sheriff's department very loudly, and she still continued with profanity, saying what I could make out from the sheriff and my kid's mother and my kid, that it was something about being on the grass, standing on the grass. And he was like, is there a problem with the grass? I go, not that I know of. She's only complained about people turning around in the grass as if I have control over what delivery drivers or random people that drive down the driveway do. Yeah, and then that he was there to witness that, at least the profanities that she was yelling and this and that, which would be on the record of the calls and his statement. He gave me the CAD number for that, which I don't have with me. I honestly assumed today that I was going to have to ask for a continuance from talking to the sheriff's office. They told me they probably wouldn't have her served by today. So I honestly didn't expect this to go anywhere, or else I would have brought more evidence to submit and family. Yeah, basically it's just ongoing things like that. They're nonstop yelling at me from her yard with other people saying my name clearly, talking to me. So it's been a real issue. And one of the most major issues of this all is that my water, I have no access to running water in our house for, I'd say it's well beyond 60 days. It's approaching 90 days now. And when we tried to find out what the cause was, we were given different reasons at first. One was it's being fixed, it's priming, something like that, and it will go off and on. I looked it up. In fact, wells do that. They go off and on for a couple, maybe an hour, half hour. What they don't do is they don't go off for 2.5 days straight and then just turn back on magically, like it happened to me. And then again, the second time it happened was for 3.5 days. And the excuse was, I was told that because the respondent claimed I didn't pay the rent, she can't pay her electric bill. Therefore, there's no water. The well cannot be on, and therefore I get no water. Too bad. And then it turned back on after 3.5 days after I had contacted the respondent's husband, which I would say ex-husband, but it's her current husband, that they are separated. He said, I'm sorry about your situation. I can't make any promises. I'll see what I can do. And he went down there, and when he left, it was on. The third time was since, I believe, November 22nd. It's been off since then. So that's how long we haven't had water. And since then, me and my family have had to buy 100-gallon drums, various ones, elevate them, filtration systems, hoses, whatnot, and bring in water from outside and filter it, clean it, and then bring it inside with buckets and use other pumps and things that we have in the house for showers connected to things. So we've been kind of doing okay so far with having to deal with all that. We've gotten a little bit used to it, but it's been very, very tough, especially having one child in high school still, having to deal with all this. Yeah, I guess that's about it for right now that I won't even talk about. And not to mention the videos I have, one of just coming down there harassing us just for nothing, and the other one of the respondent's friend who is present here in the courtroom coming down to the property to have a dog attack me for no good reason, then telling me I should be afraid if I was him or if he was me, as far as the dog, because it is I don't know what it is, maybe a pit bull, but it's loose all the time. It's never on a leash, and it's in their yard, which is only so far from ours. So I had stated to him, do I have to be afraid every time I come outside, because it ran at me and attacked me? And I was lucky that he had yelled and it stopped it in its tracks just before it got to me. And he said, I said, do I have to be afraid every time? He goes, he's always loose. And he said, I would be if I was you. I go, what is that supposed to mean? Are you threatening me? And then he just laughed it off, and that was it. I do have that on video.
All right. Anything additional at the moment?
Not right now. No.
And you've already been sworn in, so you are under oath. What would you like me to know?
Well, see, when Mr. Soto, when I met him, that wasn't his last name, I let him move in for $800 off the rent to clean the place because I couldn't due to a stroke. He's been doing nothing but tearing the structure apart. He's a bus driver, he's not a carpenter. He doesn't know what he's doing there, and pulling it off the mobile home, he can't do that stuff. He can't tear apart the inside and change it to what he wants. He had no permission to do so. And he keeps doing that. He has not paid rent since October because he just felt he didn't have to. Well, I have a problem with my pump, and I don't have any income because he's annihilated it. So how can I get it fixed? Because my breaker's one's popping because the well's on my place. And he seems to think for some reason it's not my property. It's been in my family since 1962 when my grandpa bought it. So I think I'm on the property. He doesn't think I am. He calls it nonsense. F you, F bitch, F you, all this time. Stop doing stuff you're not allowed to do or don't have permission to do. You can't go in and paint because you feel like it. You gotta have permission. Paneling, you painted paneling, you didn't have permission. And he keeps doing all this, and I keep telling him all the time, you can't do that stuff. You have to talk it over. It has to be written. You can't just go and do what you want.
Is there a written rental or lease agreement?
As a verbal one, they need supposedly
There
needed some help.
are methods to address these things. You can't, that's why things are supposed to be in writing. All right, continue, please.
So I'm just, the damage is getting bigger and bigger. He encroached on the wetland, knowing it was a wetland. You can't do anything with it. You have to leave it alone. And he's gone overboard with that. Took the gravel from the driveway to move it over and make it wider. You can't do that. There's not enough room. It's a wetland. I can't use 20% of that land. I have two places on the same piece of property. So either place gets no benefit from the wetland. You can't do anything with it. And he's already encroached on it. So when the county finds out about it, I'll be the one getting in trouble, not him, because I'm the property owner. But he doesn't think I am. My husband, ex-husband, whatever you want to call him, he didn't do any of that. He says he didn't accept any money from Thomas. I don't know that. He told Thomas to pay. You owe $8,400 as for rent, not right now. What am I supposed to do with income? That's my income. And you totally took it away because you felt like it. I have obligations with traffic court too. Haven't been able to make those.
There
I have no
are,
income.
as I said, there are methods to address things like rent not being paid, terms of an agreement not being followed. It is very difficult to determine what the terms of an agreement are if it's not in writing. All right, what else would you like me to know?
Yeah, when I went down there, Super Bowl night, they were up. They were pulling on the deck with their car. There's a deck on the front of the mobile, and it's got a pergola on top of it. They're pulling it off, and I went down there and told them to stop. I never even got out of my car. And Thomas sprayed me several times with some sort of chemical in the eye. I don't know what it was. All I seen was an orange lid, and he was squirting me in my eyes, and I couldn't see. It burned like, oh my God, I can't believe how bad it burned. He had no reason to do that. I wasn't going at him. How would I get back in my van when I'm getting sprayed in the eyes? I had to turn around in the yard because the fence, the neighbor's fence, to stay away from that. I couldn't see to leave. So I had to go out on the road for a short, maybe a half a block, but still, I'm going on the road with no eyesight. My house guests had to help me in the house and get water and ice on my eyes and get them rinsed out and get ice on my eyes. That wasn't nice. That's assault with a chemical. Oh yeah. I filed the charge the next day. I couldn't dial the phone. I couldn't see the numbers. And it took about a week for my eyes to finally stop.
Anything else as far as this order?
No.
Any rebuttal?
Yeah, I can say that just about all that is untrue, of course, except for the spraying that I needed to defend myself. But aside from everything else, She's taken me to court already on a protection order against me that got dismissed about a month ago because there was no basis to her claims, the judge found, and he found quite the contrary after reading the almost 300 pages of texts that I would be harassed with the same stuff, same details, whether you want to call it them tearing up the place, which is not true, or encroaching on the wetland, which is not true. It's the same exact stuff I started from the beginning that I had permission on, and she decided to pretend it. I never had permission. When I realized this was happening, I was really worried. I stopped. I have messages sending her saying, look, I've taken the whole summer off, told my job I'm not going to take trips because this house needs so much cleaning up and renovation, not remodeling, but renovation. And so I was on hold for about a day, just sitting there thinking, it was crazy. I want to continue painting, want to continue patching up holes, replacing carpet, putting tile down, all that stuff, which looks much better. And I go and talk to her in person, and it was strange because I just couldn't understand these texts I was getting, plus the texts I got from a different number that she would not identify who she was. So I felt like I was being watched because I was being told weird things like, I hope you're not going to put brand new carpet down over old carpet and with no padding. And I was like, who is this? And she would respond, and then I'd get more comments about it. And then I said, I'm not going to speak to you. I don't know who this is. If you're a neighbor, who. I did not think it was her at the time until later on it became basically her main number that we communicated through. And she didn't let me know for about 12 days that who it actually was sending me these strange texts. Her friend, the gentleman here, he went down after all her claims of that I'm destroying this place. He went down saying, I expected this place to be destroyed. This is back when he was more cordial with me. And he looked at everything and he goes, there's nothing wrong with it. He goes, she made me think it was totally destroyed. And I told him, yeah, look at this is making the driveway better. It was unlevel. I added rocks. I did not take away rocks or destroy the driveway in any way. I added some cinder blocks to help like as a retaining wall. I painted. She said I could paint. We discussed that the very first day we met. He goes, hey, he wants to paint before he puts carpet in. And she was like, oh, nice. And that's it. And when I did it, then she saw the color and she had a problem with the color. That's in the text. So it kind of shows that there was permission because these things were acknowledged by her in the texts. And then she just had a problem with maybe the way it looked or the style. And I feel like it was just something, she just wanted to be upset with something every single day with me. She would yell at me for a woodshed I built right behind the carport that is just right against it. And she would say things like, you can't connect anything to the carport. It's not allowed. The county can't do it. I can't do it. What makes you think you can do it? And then, with all the profanities and start calling me names, I not once responded to her in that manner until months and months later, about 6 months later, when I had had enough and I was out with my family trying to enjoy the day. And even then, we still get a text from her saying all kinds of crazy stuff. And that's when I had lost it. And that's the only piece of information or proof she had that she was claiming I was harassing her when it's the opposite. She will say things like she was supposed to have the roof fixed. We have a leaking roof as we speak, and it would leak more if I hadn't put these humongous tarps that I had bought brand new to cover it because the old ones were getting old and deteriorating and moving from the wind. So I placed 2 brand new ones up there. And we still do have one minor leak. It's coming through every time it rains. I don't know how it gets through, but it does. When I asked her things like, and I didn't bug her about it through the whole summer. I was calm. And I said, any word on the roof? And she wouldn't let me know anything. And then one day she sends somebody down to our house without telling me, which she did admit on record in the last court. And she starts yelling at us when she comes down one night saying, your daughter ran the roof guy off. So don't give me any shit about not getting the roof fixed or trying to get it fixed. And I go, what do you mean he ran him off? This is the part where I realized in my family saw she is not rational or doesn't seem to be in the same reality as we are. I go, what do you mean she ran him off? And she goes, he came down here to fix the roof and she wouldn't give him any information and she ran him off. And how was she supposed to know who he was or what he wanted? She goes, and I go, you didn't even tell us. And she goes, I don't have to tell you. And I go, I think you do. If you're going to send somebody down here randomly, you need to let us know ahead of time who it is. And it turns out when I talked to my daughter, he had never said he was there to fix the roof. He had asked for her by name And she simply said, sorry, I think you have the wrong house. It's up there. And that was it. He walked away. And then from that, she says he ran him off. I mean, you know, and I asked her nicely about 2 or 3 times to stop bringing up my daughter's name in the text as if she has some part of this in the confrontation and all this nonsense. And she would stop and then bring it back up again. And it's been ongoing. And she says the things about the rent that started. What I basically think is she tried to use the last harassment case to get money and turn this into what it needs to be, besides my harassment issue, is I would say, an eviction hearing, something like that. And I've gladly welcomed that. I've said, please do that so we can show what the proof you have and the proof I have to show who's in the right, who's in the wrong for doing what they're doing. And that doesn't excuse the harassment that you've been doing. And I've never tried to be freeloading or live there for free. I paid every single time. And when it came to the month 6, and I have texts showing, I've even given her money 10 days ahead to help her out when she had money issues, telling me that her van's going to get taken away. She can't pay for the license. She can't pay for this court, that court, all kinds of things I didn't ask about. I said, you know what? If you'd like, I can give you the rent tomorrow, you know, basically 10 days ahead of time to help you out. You know, not alone, nothing, just ahead of time, no big deal. And she was like, okay, thank you. And, you know, and I did. And when it came to the next month, she started saying something about it. She asked me to borrow $200, actually more than one time, even our vehicles, to drive them. And I nicely told her, no, I will give you a ride, but I cannot let you borrow my vehicle, knowing the things I knew, like she doesn't have a license. It's not valid right now. She's risking it every time she drives her own vehicle. And I said, I'll drive you. I just need notice. She sends somewhere in the next few days, she asked for a ride. And 2 hours later, when I didn't respond within 2 hours, which I'm still at work, mind you, because I have a long work day, she says, you're not a man. You're not a man of your word. I guess you were lying. That was just fake. You don't care at all. And I hope you're going to have the rent on time this month, because if you don't, it's $50 a day for late fees, which we had never discussed. And I told her immediately that I said, oh, this is going to be a problem. I said, the rent coming up is paid for already. And you know that because of the $1,000 of carpet and installation I had put in the house, which we discussed in the beginning and they knew about. And as soon as that happened, that's when the magical water well problem started happening 2 times and then finally permanently. And I've never been told anything about when it might be fixed or when it's going to get help. When I tried to pay her bill, the electric bill, the one time the well was off, that she said it was because of her electric bill she couldn't pay, because I didn't pay apparently. She would not tell me how much it was, and she accused me of trying to get her personal information somehow, and I never asked anything about that. And I have texts where she stated that her friend that was living with her, another gentleman and a neighbor, are all thieves, and that she was going to call the police as much as she could on the neighbor next door anytime she heard them argue. She also said, I'll probably nail the inspector that came by from Orca, I believe, that accused her of burning materials other than wood. She was going to get a harassment case on him. And I have text of that. So there's a pattern showing that almost everyone around her, when I never asked her, she just sent me these texts unprompted just to do it. She would tell me personal things and say, I'm going to get this person, I'm going to get a case on this person, and this person's a liar and this person's a thief. And I was just like, okay. And I wanted to block her immediately when this all started, but I didn't, because I knew that this would be evidence and I would probably need it because this might go somewhere. And it did. Yeah, and the whole thing about $800 saving on rent, a lot of this doesn't make any sense, which I guess it's not the place to really prove all that, but it's not what the case was.
And 90% or more of all of this sounds like a landlord-tenant issue,
right,
which is not in front of me. What is in front of me is whether or not there is harassment and whether or not there needs to be an order. Realistically, it does sound as though there has been harassment, but I don't think it would have occurred if there were a written rental agreement or a written lease.
That was denied when I asked for that.
I think this is simply getting out of hand because the two of you aren't understanding. There does need to still be contact because it is landlord-tenant. I would be able to issue an order indicating no harassing contact, but by itself, that is pretty minimal and not very well defined. It would be difficult for law enforcement to enforce no harassing contact between the two. Go ahead. You have a question.
If it really is a lot of harassment, it really is in person now. My family we are so uncomfortable by it every single day, especially having no water. It's profanities, it's yelling at us for no reason when we're doing nothing wrong. The thing about pulling up the deck is ridiculous. When she said that, I looked at her and I go, where on the deck is what are you talking about? Literally, what are you talking about? And she's like, don't lie to me, fucker. You know what I'm talking about. All I ask is that we stop being harassed.
I heard and understood.
Right, but if she could just communicate to us through the email, as the judge I saw prior to this, he said email contact would be the only one, and that would be suitable, because then there wouldn't be, I mean, if she were to say things that were harsh or bad, I wouldn't care, because it's on email, you know. But if it needs to be legal remedies or whatever it is, I'd be happy to, because I have texts, like it's showing.
The two of you
work it out.
do need to be dealing with this as a landlord-tenant issue.
And I have tried to work it out many, many times and said to meet in public and to speak, you know, cordially to each other.
Well, here is what I'm going to do. I am going to issue an order. Yeah.
May I bring up another complaint I have, sir?
What's that?
May I bring up another complaint I have with harassment, as far as harassment?
Nope.
No? Okay.
I did not put a distance provision in here. I have allowed email for landlord-tenant issues, but other than email for that purpose, you're not to contact Mr. Soto for the next year. I am. And that includes through third parties. I can't hear over the printer.
I'm a maintenance man for the property. I take care of the little things. Obviously, we have no real managers. But I'm just really confused how this can go like this way.
The two of you, not you, but the two parties here, you need to be dealing with this as a landlord-tenant issue and addressing it in court in the proper manner. This should not even be here. I'm issuing the order because it does sound like there's been harassment. So I am, sir, I'm not revisiting the issue. That is my decision. It appears to me there has been harassment, but you still have to have contact. So I'm allowing email for purposes of landlord-tenant. But there are ways to address everything that's going on here, whether that's you moving to evict or you moving to enforce the terms of the agreement. This is difficult when there's no written agreement. But the courts are your solution for the issues you're having, not yelling at one another. Okay, I have copies of the orders for each of you. Mr. Soto, why don't you step up first?
What was that?
Are we gonna have them sign?
If you want them to, it's not super necessary.
It's all right. They don't have to.
Oh, okay.
They were both
Yeah, we
here.
usually don't. I don't.
All right.
One copy.
All right, thank you. Seriously, people, this needs to be dealt with in the proper manner, not through anti-harassment orders. So I did issue the order, and you can, of course, appeal my order if you wish.
I
All
just
right.
read the chemicals in the eyes.
Sorry?
The chemicals in my eyes that he sprayed me with several times.
And that
I never even got out of
you've
my car.
reported it, that will be dealt with. That is not something that I can address at this hearing.
Okay. Okay.
All right, Mr. Soto, you are free to go.
Thank you.
And Ms. Hatcher West, if you could come up and get a copy of the order if you would like one.
Oh, you made it, so yeah. I don't want to be wasting your time.
Pardon?
I don't want to be wasting your time printing the paper. Or you have a copy. All right.
Your Honor, she's been trying to get this done through the, like real estate side.
I don't know who they came in.
And, but since her stroke, she's had a little difficulty with.
I can't hear any of this because Mr. Soto already left. So.
Well, I look forward to seeing you again. Let's almost got out here with your order device.
That wouldn't be preferable. All right, thank you.
Thank you very much.
Right, especially when it's working.
Let's go to the sheriff's office right now and find out why they have arrested them. I mean, if I can do that, why not, Lord? I don't have to pay it anymore.
I believe that concludes today's calendar, and thank you all very much.
Every day in the USA, people find themselves in court.
Ms. Flanagan and Ms. Adams. Doesn't matter. Either one. And if you'll both stay standing for me, please. Raise your right hands. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
All right, two of you reside in the same building, is that right?
Yes, Lotus Court Apartments, Patterson Street, Olympia.
Okay. So, Ms. Flanagan, you indicate that Ms. Adams makes a habit of calling you names. She takes your walker and she pushes it away from you. She does something with her cigarette butts and
in the eye.
Okay. All right. Anything else?
Well, I do have something here from a friend of mine. I've been there 4 months and I have acquired some friendships there. One is Eileen L. Pierce. She's a very good friend of mine. She actually wrote something, an affidavit, to have me read to you.
Go ahead.
She said, I was doing my laundry, I believe it was on February 18, 2025. I left one load in the dryer. I had company over. I went down to get my laundry out of the dryer, but someone took my laundry out of the dryer, put their laundry in there. There was still 22 minutes left on my dryer. There was 6 other dryers open to use, so there was no reason for anyone to mess with my belongings. I went out into the lobby to see if anyone was been doing the laundry room. Martha and Jimmy, her friend in the lobby who sit down and read books. I asked if they had seen who went there, and they said Julia Adams. She just came out of the laundry room. I went back up to my apartment, and the time was then 6:30 p.m. I started to fold my laundry and found there was white dog hair all over my laundry and snot all over my black hand towels. The dog hair was short, white dog hair, which was her when she walks. About a half an hour later, I went to take my dog, Bella Rose, a Cocker Spaniel, out of the potty and went out front door, turned left to go back and get the dog poop bag. I got about halfway there back to where the bags were there and Julia was there with the white chihuahua. I turned around to go back and there was an aggressive pit bull on the other end of the walkway. Bella and I were stuck in the two dogs, aggressive. And Julia said to me, "You have to be fucking smarter," excuse me, Your Honor. "You have to be bleeping smarter than the bleeping dog." I don't know why Julia is talking to me in this manner, because I've never had any problems with her. The only thing is that I talked to Martha Marie Flanagan, and Julia doesn't apparently like that. But what is going on between Julia and Martha Marie has nothing to do with me. I wrote this because I won't deal with someone who's obviously escalating at the Lotus Court Apartments and bullying me, Eileen L. Pierce. February 18th.
All right. Ms. Adams?
Never happened. If it did, it would be on camera. There's cameras in the laundry room.
Okay. Talk to me about the concerns that Ms. Flanagan's indicated. Do you mess with her?
No.
Not at all?
No, and I have paperwork here if you'd like to look at it.
What's the paperwork say?
That I don't mess with her and she messes with everyone else. These are written statements from these people and the people, there's tenants, the other ones that they're willing to come in and testify, and there's also going to be, there's 4 people filing a restraining order against her tomorrow. So would you like to see these?
Not if they're present, I don't.
No, these people aren't present.
Okay, well, yeah, no, hold on to those. So why don't you bring one person up at a time? Just come on up, have a seat next to Ms. Adams.
My name is Cheryl.
Yeah, Ms. Lipsinger, come on up and just have a seat right here.
Sorry, we call her Sissy, so.
That's okay. And Ms. Lipsinger, raise your right hand for me, please. You swear the testimony in this case will be the truth, all truth, and nothing but the truth.
Yes.
Okay, go
yes,
ahead and have a
sir.
seat.
Thank you.
Yeah.
Sir.
Thanks, sir.
Okay, and what do you know about the relationship between Ms. Adams and Ms. Flanagan?
So, I know that Miss Martha doesn't like Miss Julia from the very beginning. And I know that recently there was a restraining order served on Julia.
No contact.
Oh, no contact, whatever. And so now everyone that is with her or around her has become a target of Martha. And I actually have never had problems with her. She pretty much ever leaves me alone, stays away from me. But since me and Julia have been friends, now she picks on me because me and Julia are friends and she doesn't like Julia. So she waits for Julia in the laundry room, and Julia goes out to smoke. So when me and Julia were going out together to smoke, in a way to go smoke, we have to go out down a hallway past the laundry room, and then So when we walk past the laundry room, Miss Martha comes out behind us and she walks so good. You walk
Okay,
really
no,
good.
no, just talk to me.
She walks really good without her walker.
Mhm.
But at the apartments, she walks with a walker like this. And she comes out of the laundry room with her walker really fast. You're in violation. You're in violation. I'm calling 911. And she starts trying to ram me and Miss Julia with her walker. And then she came behind us and tried to get out the door before us, and then calling 911. And she said, that's on camera, that's on camera. And she does that to everybody.
Okay, thank you very much. You can go ahead and have a seat back there.
Okay.
And did you have somebody else who wanted
Miss Tony.
She's witnessed her behavior, Shirley.
to? Okay, if either one of you want to come,
I think I will.
okay, and raise your right hand. You swear the testimony in this case will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
And your name is?
Tony Barlow. Tony, Toni, Barlow, B-A-R-L-O.
Oh, Barlow. Okay, thank you. Go ahead and have a seat, Mr. Barlow.
Thank you. So I'm Cheryl Litzinger's caretaker. And so I guess my reason to be here is on behalf of both of them, but mostly Miss Litzinger, because her stress level and her ability to leave her apartment and just kind of be natural, be on, a regular day with her has subsided. It's down to a minimal now. So, because before, she was being, very social and being able to be out, but this has really caused undue stress on a lot of people. And I can't talk for them, obviously, but I can talk for Miss Litzinger. And there has been a change in her temperament and how she wants to leave her apartment now. She's afraid that she's going to end up getting something against her just by meeting her in the hallway. Okay. It's just been that kind of thing.
Have you seen any of this?
I have seen her behavior. Yes, sir.
Describe it for me. What you have seen.
I've seen her try to hit somebody with an umbrella.
By her, you mean?
Oh, I'm sorry, Miss Martha. Yeah.
Okay.
Yeah.
Okay, go ahead.
She's been verbally offensive to people, and I came up right after she had spat in someone's face. And actually the police were there at the time.
That never happened.
Okay, yeah, hold on. I'll get back to you.
That never happened.
Ms. Flanagan, I'll get back to you.
All right, that never happened.
I'll let
Okay.
Ms. Barlow go.
So
That is a lie.
Okay, go ahead.
okay. So, there's been many incidents. She called 911 on this fella. He actually is dead now. He had lung cancer, and it was this issue with the elevator and her not letting him out of the elevator, and he did push her with his walker. So anyway, there was a big deal. She's, in my opinion, she's been a troublemaker from the word go, and she has all these protective orders on so many different people, and it's just a nightmare.
I don't have any.
Okay, Ms. Flanagan, don't interrupt, please. Go ahead, Ms. Barlow.
That's it. That's all I see. And I'm my main concern is Miss Litzinger and, her ability just to leave her apartment without feeling like she's going to be either assaulted or have a protection order placed against her.
Okay, thank you very much. And ma'am in the back, did you wish to say something?
This is Shirley.
Okay, thank you. Shirley, if you'd raise your right hand for me. Swear that testimony in this case be the truth, the whole truth, and nothing but the truth. Okay, and your last name is?
Peniagua.
Peniagua. Okay, Ms. Peniagua, go ahead.
Okay, I've been pretty much neutral with, I try not to get involved with anybody's stuff, but I have seen Martha come unglued on a lot of people. And they try to, we're all kind of out smoking. She comes out and refuses to leave in the area we're at. So the whole group has to get up and walk to the front of the building. So we have time to visit. And she has, we watched her try to poke somebody, this Ellen that she's got a state from. She tried to poke her.
Have you ever seen
management tried to get in or had to get involved?
Have you ever seen a situation in which Ms. Adams has initiated something negative with Ms. Flanagan?
I never witnessed it. I was at church one day and I heard about it when I came back, so I wasn't involved.
All right. Thank you very much, Ms. Flanagan.
Your Honor, yes.
Okay, Ms. Litzinger, hold on just a second. Okay, thank you.
Just say one more thing.
Sure.
Oh, Your Honor, Miss Martha's told everybody that Miss Julia is an alcoholic. And that's not true. Me and Miss Julia have been friends for a really long time. She's not an alcoholic.
Okay, thank you. Ms. Adams, do you have anything more you would like to say?
Yes, I came up early and I was writing a statement out for a friend of mine who has litigation against her. They're in court the same time we are. So that's another witness of mine that's not able to be here. But that's who's gotten the brunt of her abuse, along with myself and many other tenants. But she's escalating. I thought it would get better. I thought Lotus Management would handle it. Nobody seems to be. So I'm after me being protected from her, all the other tenants, and most importantly, Barbara, who again is in another courtroom going against her because she was verbally assaulted and physically assaulted from her. They did mention the other gal, she spit in her eye, so she's got to, I'm gonna take her to the police officers to have her, she'll file assault charges. She needs to go to her doctor to be tested for anything that may have been transmitted. She's doing a restraining order. I'm doing a restraining order, and I believe 3 other people. And then many people, if you'd like their number, name, anything from them, if you have any questions, even the staff at Lotus. But I have these written ones that I wasn't able to submit to you before this hearing.
So you all live in one building?
Correct.
And are you down the hall from each other?
No, I'm on the 5th floor and she's on the 2nd floor, and she also came up last night to my floor, which she's not supposed to. And then when I go out to have a cigarette, she runs up to me and says, "You can't be out here. You have to go away now." She doesn't understand the no contact order, which is fine. You know, I don't know that she's capable of it. So,
Tell her about that.
Your Honor, may I speak?
Oh, okay, I'll get back to you.
a lot of people couldn't make it here today for other obligations they had, but wrote to you.
And how long have you all lived in the same building?
I went in on September 27th. Anybody else's date, I do not know.
And was Miss Flanagan already residing there?
Pardon me?
Was Miss Flanagan already residing there?
I couldn't tell you that. I have no idea.
When did you come to know Miss Flanagan?
I can't remember that either because it's just been a nightmare since. So I'm, our staff could tell you that, who were in charge of moving everyone in. I don't even know when these people moved in. I know they're my friends now, but can't even remember their
that's okay.
Floor number.
All right, Miss Flanagan, go ahead.
Yeah, here's another one from Kathy. Last night, when I was on her, I didn't even know where she lived until a week ago, when Shirley served, because she saved me $75. So this is from Kathy. The girl that talked about her using profane and foul language. None of what she said is true at all. We have 9 incident reports, 5 grievances, and the management is aware of her. She's the one that assaulted me the other day with the Colombian lady, and we do have it on vid. The video is when Josh Dannenberg, the property manager, actually saw her do it. She called me demon. She's been on the elevator. Dave just got out of the hospital. He could come, but this is a letter handwritten from Kathy, my friend since I met 4 months ago. I did not arrive till October 29th, so I didn't even know she was living there. Anyway, apartment 311, I, Kathy Friol, have known Martha Marie for 6 months. She is a nice person who doesn't hurt anybody. Witnessed by Nathan, my son, on February 11, 2025 at 9 p.m. Lotus Court, incident report, February 21, 2025. Your name, Martha Flanagan, Lotus Court. Person involved, Julia Adams. Apartment, we just found out, I didn't know she lived on the 5th floor till a week ago. A lady named, I came back from church as I'm becoming a master and a minister, and I was gone for 3 hours. And so what she said is the absolute fabrication of the entire statement. Julia Adams was simply with my walker. She's the one that blocks it. In other words, she's screaming and screaming and screaming and putting her fist and slamming down her fist. And she's, as far as the other lady in apartment 501, Kim, was the one 3 months ago that said that she wrote the management, not me, about her alcoholism. I didn't know anything about her. I only know from Shirley that her boyfriend beat the living crap out of her a year ago. Her violence is excessive. She's accelerating her behavior. She came to my floor on the 2nd floor until she was told by management, you cannot go within her. And then Shirley was nice enough to save me $45 and call me in with the police. We did call 911 yesterday, and they're awaiting your decision, Your Honor. So what she said is absolutely fabrication, completely.
All right, thank you.
I do have a video of it all as well.
And Ms. Flanagan, has the order that I entered previously, has that changed anything?
No, Your Honor, just accelerated, got worse.
Okay. Which is kind of what I had assumed listening to everybody here.
Pardon?
So, which is kind of what I had assumed listening to everybody here.
I'm lost as to what you're assuming.
I'll tell you in a moment.
Oh, I'm sorry. Okay.
That's okay.
Are you willing to?
How many people live in this facility? Any idea?
60.
I believe there's
60.
64 rooms.
Okay, thank you.
And Sam passed away. He had lung cancer for 5 years.
That's the man she
Yeah.
tried to.
And that's that's the scooter that he put
That's
through.
enough.
So
That's enough.
she's also
That's
doesn't know
enough.
the whole story. When Enrique gets
That's enough. That's enough.
Thank
Talk
you.
to me. Ms. Flanagan. Talk to me. Okay, so you have 60 of you that live in this building, give or take.
Yes, Your Honor.
And I have some people saying that Ms. Adams is the problem. I have some people saying that Ms. Flanagan's the problem. I'm hearing that some people are going to seek orders against Ms. Flanagan. I don't know if there are other people seeking orders against Ms. Adams.
No.
But
yes.
Oh, hold on.
No.
Okay.
Let the judge speak, Julia.
I'm glad I don't live here. That's all I'm going to say right now. You guys would be mean to me. Protection orders aren't going to change anything down there. That's really why I asked Ms. Flanagan the question. The fact that there is a temporary protection order hasn't changed a thing. I don't think the police have any desire to come into the building and lock up all 60 of you because you can't be nice to each other.
They said they
I don't think that's going to happen.
Well, they
if
said
I issue the order, That's
Okay.
really what you're asking me to do.
That's correct. They said they would if you do the order, Your Honor. That's what they
Okay.
said.
Well, they're not gonna lock up all 60 of
No,
you
we're
because
just
you're-
talking about
Okay,
Julia.
Miss Flanagan,
Okay.
you're all, no.
I know, but she
I
lied
can
through her
control
teeth.
it.
She
Nobody
lied
needs
through her
to shoot.
teeth and they falsified their statement.
Okay, all right,
And
Miss
that's a
Flanagan.
fact.
Okay, but you all are saying the same thing about the other one.
Mhm.
So I'm pretty confident that all, this is just a paper exercise if I were to issue it. I'm going to not issue it. Frankly, this is gonna fall on the management. They're the ones who work there, live there. They're gonna have to keep an eye out and make their own determination. I'm not in a position because you each are presenting other people saying, no, if it's her fault, it's her fault. And police don't want me to issue an order because they don't want to have to start coming arresting all the people in the building. And there's not enough room in the Olympia City Jail for all 60 of you, and the accommodations are not nearly as comfortable as the ones you have in your building. So I would just ask that you have some degree of respect for the others and just give each other a little grace and as much room as you can so that you aren't bumping into each other and you can find a little peace in your lives. All right, I have signed the denial order. Ms. Adams and Ms. Flanagan can remain where you are. We'll give you a copy of that order. And were I to hear other cases about this, unless there's something very different, the cases would all end up pretty much like this one is. So I'm just letting you know.
All right, Your Honor. Thank you.
Yeah.
Thank you for speaking and teaching us. Thank you very much. I appreciate it. I listened. I heard you.
Are you interested in the paperwork?
No, I don't need it. Okay. So, Ms. Flanagan, Ms. Adams, just wait and we'll give you each a copy of what I.
Thanks, sir. Oh, I'm sorry.
And Ms. Adams, here you go.
Thank you.
You're welcome. And Ms.
Is it possible I can talk to you after she leaves?
No, we can't do that. Yep.
Your Honor, she's trying to manipulate, as she
Okay.
does everyone.
All right.
She's miserable, and she is.
Okay, that's enough. I told her she couldn't say anything to me, and I'll tell you the same.
She's trying to manipulate.
All right.
Thank you.
Yeah.
I'm not gonna tolerate you doing it. Lewis County, Your Honor, they would have granted it, and they do arrest you, and she does have to pay. It's serious. You don't have to lose. We're gonna come back here. We're worried she has a firearm. She's, I want to talk to management. Thank you. I thank you. You're one of the rare judges left. Thank you,
No, let's let that linger for a moment.